We first met Champagne about a month ago when her need to get things right really ticked off Judge Simpson. She's been back a few times since then, and I think she has finally found his sweet spot. It's absolutely adorable. Make sure you watch to the end. I just have two quick notes about this one. Number one, every time I see the Arbor One chick in the pink shirt, she's eating, which is totally fine. It's just kind of weird to eat on Zoom, but whatever, go for it. Except for she licks and sucks under her fingernails when she's done to get all the crumbs out, which totally grosses me out. Ew. Number two, when I saw this defendant, I thought, oh, cool name, cool hair. And it was all downhill after that. So enjoy.
Judgment to the plaintiff by default for possession, redemption amount, any amount requested. Writ to
Thank
issue
you.
10 days. Arbor One versus Champagne Wilson.
Cheryl Wolkoff on behalf of the plaintiff.
I'm here.
Ms. Wilson? Hello, Ms. Wilson.
Hello.
Okay, let's see. We were at 1454.10. I don't know if that included the 150 she paid that day or not.
It did not. The balance right now is $1,310.57.
Okay. Ms. Wilson, how do you plan on getting that paid?
Well, the balance should include a payment of $300 that I made yesterday, and then a payment of $475 that I made today. They let me know that they could see the $300 one already in the office, and that they were going to add the $475 before my court date. With that payment, with the $158, that equals $932.10. It's a little bit more than that, which was my portion to pay. And SCR has approved me for rental assistance, and they're to pay $520, which is the remaining balance on that. So I'm just not sure why it's not reflecting on their end. But when I went today, basically they just want me to have the people from SCR email my landlord's people to tell them that they'll send them a check, because they said my landlord basically said that their provider number is not working and it's hard for them to get the money from DHS. I don't really understand how I have anything to do with how they get the money from DHS, but they said that I need to have the lady basically say that she's going to send in a check instead of going through the way DHS normally pays the
Okay.
Arbor.
All right. Hold on. she had that all wrapped up, didn't she?
Yep.
All right. Let's first hold on. Hold on. Miss All right. So I have $775 of this that should have been paid.
Yes, I have receipts for all of that.
Okay. Whoa. I heard you. Do we know whether or not that's there?
Amy too? Can you confirm that?
Confirm that the payment of the $300 is on her ledger, and I believe I remember my assistant Stacy telling me that 475 has not been implemented into our Yardi system, but it was received.
Okay. So
and Your Honor, as long as the DHS is agreeing to give us a actual check, our corporation does not have a provider number for DHS. So we do not accept SCR payments in the portal type form as of right now.
okay, as of right now. Okay, I got
It's
you.
It's a very long process. And when I worked here before, we had a provider number, and I'm in search of, with Lansing, trying to figure out how to reset the portal up. But we don't accept DHS payments unless they come in the form of a check.
Okay. All right. So if I have my 1310, take off 775, what do I have?
1310 minus 775, $535.
Okay. So Ms. Wilson, I'm still about $35 short.
I paid $158. I paid $300, and I paid $475.
Whoa. Hold on. So I'm missing 150 that you paid. Right?
I paid $158.
Your Honor, that's reflected in the balance.
Pardon?
Oh, I said that's reflected in the balance that I gave you, the 158
Yes.
payment.
Right. So what I'm saying is you're about 35, did you say? So you're about 35 short. And
That's not right.
Oh, okay.
I'm sorry to interrupt, but that's not right.
Okay, so here's going to be the problem. Over $35, DHS is not going to pay until that clears the account. The 500. Was it 500 even they were going to pay? Ma'am?
$520 is what they're gonna pay.
Okay, that's where we're actually
We'll
going to
waive the
be $15 off.
$15, Your Honor, if we can get okay.
Thank you.
Hold on, excuse me, Your Honor. There's nothing to waive because I paid $932.
Okay, does it really matter? Does it really
does-
matter, Miss
That's
Wilson?
condescending to tell me that they're gonna waive.
Does it
something that I don't
really
owe.
matter? Really? I mean, if you want to just have a fight, we'll have a fight. But does it really matter? I'm just trying to get the money there so your account's clear. Isn't that what we're trying to do here?
I want to make sure everything's correct.
You know what? All right. Here's what I'm going to do. Ms. Luckoff, your gracious offer of waiving the $15 is correct. Send her a ledger, make sure everything's correct. Everything's going to be delayed. If August kicks in and she ends up getting evicted because it's not paid, so be it. July 28, 2023, what time? 9 a.m. Because if we click over into August, they're not going to pay. Thank you. Court calls the case of Arbor One versus Champagne Wilson.
Cheryl Luckoff on behalf of the plaintiff.
I'm here as well. Can you?
All right, Miss Wilson. Okay, yes, I can hear you. Where are we on this? I think I had 13/10/57 that was owed last time we were here.
My records are showing today $481.10, including court costs. There was a discrepancy that we waived. I waived, as the court may recall. But the bigger issue looming right now is the landlord did not have a provider number, as I believe was indicated to the court last week. And I'm told by my client that a check was actually sent to Beal Properties, a prior management company, because they had a provider number. So somehow the assistance agency just must have put the word Arbor in, because I asked, that entity was Arbor 118 LLC. That's who the check went to.
Got it. So would that check clear her account?
I believe that it would, Your Honor. I don't have, I seem to remember it was $500, but I don't know that for certain, and Amy's not available today.
Got it.
But I believe that it would.
Okay, and the provider for August rent, what is your portion of August? What portion of rent do you pay, Miss Wilson? How much do you pay each month?
I pay the full portion of rent. I just received assistance for this last little bout that we had, but I pay the full portion.
Oh, I got you. Okay, so are you going to be able to get your August rent in?
Yes, sir.
All right. When do you think you're going to be able to pay that?
I get paid on Thursday, so I will pay it on, I'm looking at my calendar, on the 3rd. Yes, finally, I'm getting
On the
it in
3rd.
before the 7th.
Okay. So what I'll do, I mean, because this isn't, that other check really isn't your fault, but
I can reach out to them and see what they can do about that, though, because it does say Arbor 118, but I don't know what it is. I just thought that was, your guys' thing, because there's a couple.
no, I got you. So, August 4th, 2023 at 11, and defendant to pay August rent. And then it's the back's balance that we're going to be looking at and see if we get that resolved. Okay?
Your Honor, can I just confirm on the record here, Ms. Wilson, can you indicate the amount that check was for?
Yes, it was for $519.10, I believe.
Okay, I thought there was 500 something. Thank you.
Mhm.
All right, thank you, ma'am. Arbor One versus Champagne Wilson.
Cheryl Wolkoff on behalf of the plaintiff.
It's me
Hello,
again.
Miss Wilson.
Good morning.
How are you?
I'm well. How are you?
I'm okay. Let's see, where were we on this case?
Your Honor, this is the case where the check from the rental assistance went to Appeal Properties, the old
Right.
management company. And we adjourned, so there could be additional time to try and retrieve that check. Since then, obviously, August rent has kicked in, and that's where we're at. And I believe the defendant indicated she would pay that on the 3rd. That's what my notes say. I
Did you
have
get
also
that paid, Miss
noted,
Wilson?
I actually on Monday emailed the office to see if I could pay 500 this week and the remainder next week because our power didn't get turned on until Saturday from Wednesday, so I had to replace my groceries. They didn't respond, but I know Amy was busy, but I did drop off a $500 money order yesterday. I also spoke with DHS. They said that they can see that they're going through the process of getting that payment refunded from Bill Properties and then sent out to the updated vendor number, but they said that can take up to 14 days.
Okay.
Right.
She's on top of it at least. So you did not get an answer from the landlord about August rent yet, correct?
Correct. When I called into the office, they did let me know, the staff let me know that she was in meetings and that it was kind of like a hectic week, probably because the power and stuff was out, and that's fine. But I did make sure that I at least dropped that off regardless of the response so that they had that.
Your Honor,
right.
respectively, August rent was due, and that was the agreement that was made.
Yeah, but okay, you're right that it was due, and I respect that. I guess my only issue is, had the check not been sent someplace, we wouldn't even be here. I mean, you might be arguing
Well,
about
there were
August.
also some cooperation issues from the defendant that required us to set this over, Your Honor. But I'm going to leave this in the court's discretion. I just wanted to note on the record my concern.
Yeah.
What did
All
I
right.
just,
What
I
I-
don't,
what-
I'm sorry, I did not to be rude or anything, but what was the cooperations? Because I haven't been informed of anything. I figured everything's been going smooth so far. I understand
Oh.
that it's the 4th and that rent's due on the 1st, but it's not even the late fee assessment date yet for August.
Okay, I know. And we did, and I had marked that you were going to pay the August rent. I did not put a date, but that you were going to pay that, I think, before today's date. But I acknowledge that there were certainly issues with the power out here, and it was rather crazy. So I'm not going to penalize the defendant. I'm going to put this out to the 18th. You're going to pay the August rent by what date? The rest
This
of
is
it
going to be paid by Thursday next week, so that's going to be the 10th.
by the 10th.
So by
Okay,
the time you see me, everything will be cleared up.
that'll be cleared up, and hopefully then
And
the check will-
actually, that'll be
everything will
14
good.
days for the check as well. You're right.
Right. That's what I'm thinking. Okay, and then we're all done. All right.
Is that 10 a.m.?
At what time? At 10 a.m.
Okay,
on the
thank you.
18th.
Thank
All
you.
right, thank you.
Thank you, Your Honor.
Arbor One versus Champagne Wilson.
For the record, Lawrence Craftsman standing in for Cheryl Luckoff for the plaintiff.
I am here as well. Good morning.
Uh-oh.
Oh, okay. Can you hear me?
Yes, I can hear you.
Okay, thank you. Yes, I'm here. Sorry. You know I'd be
All
here.
right. No, yes, I do. So, and there's a little champagne right next to her.
I see.
Yeah, okay. So anyway, yes, there she is. All right. Let's see. Where are we on this case? How much do you have owing, Mr. Craftsman?
Your Honor, we show a balance of $1,073.60 for rent, plus court costs of $162 for a total of $1,235.60.
All right. All right, Ms. Wilson. How are we going to get this paid?
So actually, everything is paid. I don't know if maybe he just got the letters from up until the 4th. Maybe that's what it is because he's filling in, which is fine. But if you reach out and they can give you updated letters as of today,
Everything's paid. I went to the office this morning before I came to court.
Oh, okay.
No,
You
not
paid
to
it this
pay it.
morning.
No, not to pay it. I went to the office this morning because you know the issue with Bill Properties.
Right.
And that's the only portion that they don't have, is that portion. And so I went to them because basically DHS was like, maybe it would be better if I reach out to Bill Properties to get it expedited because they're not getting any contact. So when I went to the office today, they tell me that they checked their mail last night, and the mail that DHS sent to Bill Properties went to them because that's the issue, is that they have the old information. So it actually went to them, and I guess they told me that Amy said she's going to take it down them to Bill today directly to get that other $519.10. So my portion is completely paid. They can go ahead and double check that. But so now I'm just dealing with this DHS thing.
Okay. All right. Here's what I'm going to do. I'm going to adjourn it out 1 week. Let's see if we can get this payment straight. I don't know if we will be able to, but we can give it a shot.
Oh, they're gonna get it straight, Judge. Let me let you
Okay,
know.
all right, okay. Whoa. You didn't have to come at me like that. I just said I don't know if it's going to happen in a week. I know we will get it straight.
We're gonna nip it in their
Whoa.
butt.
She just came at me. I
Not you,
just said
Bill.
that,
It's Bill and DHS, baby.
Wow. All right. August 25th, 2023, 2 p.m.
Yes, please.
2 p.m.
Okay,
All
thank you.
right.
Bye-bye.
All right. Miss Wilson, you take care. You too, little champagne.
You as well. Thank
Right.
you. Bye.
Take care.
And Champagne's back. So if you guys haven't watched Champagne, it's a fun little journey. Started with an argument over $15, which almost got the case. The case would have almost been dismissed if she wouldn't have started that argument, but then it got extended, which then resulted in the assistance agency sending the payment to the wrong Arbor Apartments, which was the old Arbor. And I don't know if you guys remember, but right about the time I started streaming, so right at the start of 2023, Judge Simpson was involved in this huge deal with the Arbor Apartments because they didn't have the right occupancy permits, I believe it was. And so there was a big to-do, but they were switching ownership over. And it was those prior owners that the money got sent to. Well, they're refusing to give it back. So it was a whole ordeal. So Champagne is now, in Judge Simpson's good graces. Last time she showed up with her Minnie, who was absolutely adorable, and Judge Simpson was pretty.
I know, exactly. That's what
Wow,
you
fine.
just tell people. All right, thank you.
That's what I'm doing. I'm
Arbor One versus Champagne Wilson.
Thank you.
Cheryl Wolkoff on behalf of the plaintiff.
Hello, Miss
Here.
Wilson.
Good morning. Oh, it's good afternoon. I'm used to seeing.
Good
you.
afternoon. Yeah, that's okay.
So, Your Honor, on this one, this is the one where the payment went to the wrong entity. And I
Yes.
have been advised that the defendant just went in, I think she was so fed up, she went and paid the landlord. She has a zero balance right now, but I do want the record to reflect because she was approved. A payment did go to a third party who's
Whoa.
kind of denying it right now. I don't want to necessarily get in the midst of it, but I don't think it's really fair to Ms. Wilson what happened. And I don't know if you want to show cause this Beal Properties, but the money was.
Whoa. Okay.
So this $500 went to Beal Properties, but Beal Properties is saying they didn't receive it. So Ms. Wilson ended up just paying it.
Is
Your
that
Honor.
right, Miss Wilson? Oh, go ahead, Amy.
I just want to stop for a minute. For anyone who remembers this, the initial stream where she had pink hair, do you remember how much tension there was? And even like 2 months later, Attorney Luckoff was still like hot and not happy. Now everybody's besties. It's so funny.
Me too.
Yes, I just want to let you know that I've had several correspondents along. Champagne Wilson and I have both been kind of tag teaming Stuart Beal. Because I was here at the original sale and I know that account number, Arbor 118 LLC, is directly affiliated with Beal Management. And she's, Champagne has even went down there and we've been sending letters from the state of Michigan demanding the payment back. It is his vendor number, his provider number. We didn't even have a provider number. And he's basically stated in emails that we should operate from a position that he doesn't have the money and that all the accounts are closed. So Champagne and I, seeing Cheryl and the state worker, have been on this, and he is just not complying. He's saying that the account isn't there, the money isn't there. So we're kind of in between a rock and a hard place, because like Ms. Lutkoff said, Ms. Wilson had to really come up with that money from somewhere else when she was already allocated that money from the state of Michigan.
And Miss Wilson, how much
Yes.
did you pay? How much did you pay that
Five-
you shouldn't have had to? 500?
$520.
And you did that because, as Miss Luckoff indicates, you just got sick and tired of it.
I just want to go ahead and be able to be out of court, and had this have been paid in July 31st when the payment was sent, we wouldn't be here, so I don't want it to keep dragging out.
Wow, she just insulted me. So what she just said is, I don't want to see you, Judge. I'm sick and tired of this.
Under the circumstances, man, maybe.
All right. I'm gonna tell you what. I'm gonna do something. It's gonna make you have to come see me again, because I like Miss Luckoff's idea. I know we've been going around and round about this, but fair is fair. And so if somebody got that 520, you shouldn't have had to come out of your pocket to try to make it right. It just shouldn't be that way. So if I'm going to issue a show cause to Stuart Beal and Beal Properties. And if you could, if Luckoff or Amy too could send to Miss Wilding an address that we can. I know I said your name right.
23 North Washington Street, Ypsilanti, Michigan, 48197, baby.
Dang. What? Did you get that?
Because I've been down there in person, knocking on his door.
Okay, she's got it. Just guess nobody has to send anything. And I'm going to show cause why they shouldn't be ordered to pay you $520. Make them show up, and they were telling you whatever. Now they got to tell me, and that can be a bit of a problem for folks. So I'm going to set that for
September 12th at 9 a.m.
September 12th, 2023, 9 a.m. in person.
Did you want
And that's on this
me
case.
to
So
appear?
I am not dismissing it. So yeah, you guys got to be here too, because you guys were involved in it.
Okay.
Okay. Is that okay, Miss Wilson, even though you don't want to come see the judge?
I'm compliant, whatever I have to do.
Champagne and I will ride together.
Okay.
We've seen
All
a lot of each other lately.
No, for real.
Gotcha. Okay.
I don't want to see you
Thank
the 22nd. That's my birthday.
The 22nd
Yes.
of
My mother's
September?
birthday.
I'll be 31.
Wow, to be so young.
Yeah. My birthday is a few days after. I'm 31 too. Okay, never mind.
Talking about I'm
Anyway.
31 too.
All right, you take care.
Okay, what
Hi,
time
Miss
on the 12th?
Wilson.
I'm sorry. What time is
Pardon?
that?
The 12th at 9 a.m.
Okay,
At
thank
9
you.
a.m. in person.
Have a
All
good
right.
weekend, you guys.
You
Yeah.
too.
I told it to him. I said, hey, you dumbass, this different word I used. This is not me.
So Mr. Cruz is a feisty one. This is kind of interesting. Mr. Cruz was served a notice for an outstanding debt, but he is not the Mr. Cruz for the debt. And he is very upset that he was served for someone else who happens to be his son. But he's not happy.
How about Pine Rest Christian Mental Health Service versus Richard Cruz?
Ready, Your Honor.
Ready?
And I've got Richard Cruz.
Richard J. Cruz.
Oh, that I remember. This is one. I've got Richard.
That's one where the process server screwed up.
I remember. Counsel.
Yes, Your Honor.
Go ahead, Mr. Goodman.
Sure. Robert Goodman appearing on behalf of the plaintiff. Your Honor, also here is process server John Jordan. It's my understanding that Your Honor scheduled this hearing today because of a letter received by the court from somebody purporting to be Richard J. Cruz, presumably the gentleman that's appearing here via Zoom. In that letter, he writes that he has a similar name to the defendant Richard G. Cruz. He doesn't mention that he is the father of Richard G. Cruz, but more importantly, he doesn't mention to the court the attempted service approximately 2.5 weeks prior to the date that the proof of service indicates, March 25th, 2023, that service was effectuated. At that time, Mr. Jordan, who's here and can certainly testify to this fact, went to the address at 7397 Nicholas Road in Flushing. At that time, the gentleman who apparently wrote this letter indicated when he asked for Richard Cruz, he said he's up north hunting and won't be back for 3 weeks. So Mr. Jordan left and returned back to the address approximately 2.5 weeks later, or exactly on March 25th, 2023. At that time, Mr. Cruz admitted that he was in fact Mr. Cruz, but then said he didn't owe any debt. The papers were left with him. And then this Mr. Cruz apparently looked up the process server's personal residence and went to the process server's home and attempted to return the papers. So as we sit here today, Judge, we effectuated service on a Richard Cruz. Our defendant is Richard G. Cruz with a date of birth of 3/21/1967. I think Your Honor is up to speed as to kind of what transpired here. If this process server did not in fact serve correct Richard Cruz, it's because this gentleman standing here made it very difficult in order to do so. And I guess at this point, you know, Richard G. Cruz can certainly file a motion to set aside if he feels that service was improper.
Okay.
Okay, other side of the story. John.
Just briefly, because I've got process server here too, apparently. So, what in your Richard J. Cruz?
That is me, yes.
Okay.
The story is quite a bit like he says. John Jordan appeared at my place. I told him I wasn't the person being to be served. I had no debt. He asked where the Richard G. Cruz was. I think he was up snowmobiling, not hunting. Doesn't make any difference. I told him he didn't live here. I told him my name was Richard J. Cruz, as in Joseph. He looked down at the warrant that he had, and his comment was, "Oh, it's probably a typo." That's what John Jordan said. I told him it wasn't me. He left. He came back 3 weeks later. We went through this again. I told him I wasn't the person. He threw the summons and my FOIA on the ground and left. Prior to that, he had given me his address. He told me he lived around the corner. on Stanley Road, about 3/4 of a mile from me. So I took the summons back over to him. I showed him my driver's license. He looked at it and he read very slowly. He said, Joseph. I'm 79 years old. I'm not in my 50s. It was obvious that I was not that person. He knew it. And I get back to my vehicle and he came out and he tried to stuff the summons back in my window. I told him, I said, hey, you dumbass, this different word I used. This is not me. This is, you got somebody else. He says, well, I'll tell you what. He said, I'm going to give you a phone number and you can straighten it out, which is a bunch of BS because it's not me. It's not my job to straighten it out.
So, okay, so Mr. Cruz, hold on, rather than give me much more, Mr. Goodman, do you have your processor? I guess let's start with your process server.
Mr. Jordan, would you unmute yourself, please?
Jordan?
He's attempting to unmute himself right now. Maybe
Okay.
you can help him with that, Judge.
Yeah, I got there we go. There we go. Mr. Jordan?
Yes, good morning, Your Honor.
Morning. Why don't you raise your right hand there for me? Do you swear from the testimony you're about to give will be the truth?
So help me God.
Okay. Mr. Goodman, why don't I let you kind of coordinate with it? Go ahead and ask him questions regarding service.
Mr. Jordan, can you tell us your full name and your occupation?
Yes, John David Jordan. I am the owner of Jordan Transport here in Flushing, Michigan, and I do process serving for Great Lakes Civil Services as a part-time, just to fill in when I don't have runs.
Okay, and did you receive a summons and complaint to effectuate service of process sometime in early March 2023?
Yes, sir.
Okay, and how many times did you go? Can you tell us about the first time you went out to the Nicholas Road address in Flushing?
Yes, I went to Mr. Cruz's residence at 7397 Nichols Road here in Flushing. This was around the 1st or 2nd of March, and I knocked on the door and Mr. Cruz answered, and I asked for, yes, I'm looking for Richard Cruz. And he said, well, he's up in the UP snowmobiling. And I said, okay. I said, do you know when he's going to be back? And he said, well, he could be back at the end of the month. And I said, all right. I handed him a card that had Great Lakes Civil Services. Is just a informal business card. I did have my name wrote on it, my telephone number. And after that, I left. I waited 3 weeks. I come back to the residence to see if Mr. Cruz is back home. When Mr. Cruz, that's in this meeting, answers the door, he asked me for my ID to prove that who I was, and he thought this was a scam. I said, well, no, sir, it's not. So I handed him my ID. I let him take a picture of it. And then I asked him, I said, okay, well, I showed you my ID. Can I see your ID? And he says, well, no, he says, I'm getting emails, I'm getting things in the mail that I owe this money, this and that, and I owe no money. And I was like, okay, well, I understand that. And so he was going on, and actually he did state that he was getting something in the mail or email from the one that I was there to service. It was to do a service on. And I was like, okay. And at no time was a middle initial ever, discussed.
Okay.
So what I was trained to do as a process server, I listened to all the information, and he did admit he was Richard Cruz. And so at that time, I did place it at his feet and did a drop service and told him that he had been served. I got back in my vehicle. I sent in my information for my affidavit. And I will say that the only mistake that I did make on the affidavit is that I forgot to change the age on there for my prior that I served with. The gentleman was 55, 56 years old. I did miss that on the affidavit.
So you wrote on the description of the proof of service, age 56, male, base color, you put white, approximate height, 6'1". Is that
Yes, sir.
okay? All right, Judge, I have nothing further for Mr. Jordan. I do have some questions for Mr. Cruz, but I don't know if Your Honor wants to ask Mr. Jordan anything.
I don't think I do at this time, Mr. Jordan. Hold on though, Mr. Cruz, well, hold on, Mr. Cruz, since it's,
Let's clarify a little bit what John Jordan said.
Hold, Mr. Cruz, hold on. I'm going to give you, I guess, taking up half of my morning too, just like my last one this morning. Sir, why don't you raise your right hand there for me, Mr. Cruz? Do you swear from the testimony you're about to give will be the truth?
I do.
Okay. All right. First of all, why don't you give me you can put your hand down. Thank you. And you're Richard J. Cruz?
That is correct.
And what's the middle name, I guess?
Joseph.
Joseph. Okay. I'm sorry, Mr. Goodman. You can go ahead and ask him questions then too. We've got to.
Let me clarify just a little bit here. On the first bit,
Mr. Cruz, hold on. I'll give you a chance, but let Mr. Goodman ask questions first, okay? It'll be a little bit easier, I think. Mr. Goodman.
All right.
Mr. Cruz, are you the father of Richard G. Cruz?
I am.
And what does the middle initial G stand for?
Gerald.
Gerald. And what is the address of Richard Gerald Cruz? Does he live with you?
I think you need to hunt that. I'm not going to do your work for you.
Your Honor, I'd ask you to instruct him. It's relevant to this case.
No, it's not relevant to the case. The case here is John Jordan lying, and affidavit signed that he delivered it to a Richard G. Cruz at this address, and that is wrong. He saw my driver's license, read the name Joseph.
Hold on, Mr. Cruz.
Okay.
You're the one that opened up this can of worms too. I need you to answer his question though. Mr. Goodman, go ahead and ask him again.
What is the address of Richard G. Cruz?
I do not have that in front of me. I do not have it memorized, and I'm not willing to help you after what John Jordan did, look for somebody else. I will say this, that he would be absolutely mortified. He would be mortified if he knew that information you gave me, that personal.
Mr. Goodman, I guess I can't press him too much. You know what? Why don't we do it this way? From everything I've heard, there's a possibility that Richard J. Cruz was the one that was actually served. Now, I'm not faulting, quite frankly, I usually get appalled when the wrong person gets served. And I'm not faulting Mr. Jordan. It sounds like there's miscommunication between the two parties. What I'll do is find that there was no service on Richard G. Cruz, but what I will do is allow the subpoena. Is the summons expired? Do you know?
Yes, it is, Judge.
I'm sorry?
Yes, it's expired.
First. Here's what I'll allow, Mr. Goodman. Summons has been expired. It's expired June 1st, but giving there was some earnest good faith that the summons was conserved. I can't go back and extend that summons. If you could do me, I know this is causing more work, but just to do it easily, if you want to refile the complaint and the summons, I'll tell my staff to waive the fees for it, given everything I've heard. And then with regard to service, if there's a request for alternate service, I'll consider alternate service.
Thank you. Thank you, Judge. We appreciate it.
That makes the most sense for everybody, you know, for Mr. Cruz and everybody. Okay.
We appreciate the court's time. Thank you.
All right, Mr. Cruz, and we'll just leave it at that. So I'm finding that Richard G. Cruz was not served. Okay.
Okay, but what about John Jordan's basically perjuring the court?
I don't believe he, from everything I've heard so far.
He saw my drive, Your Honor.
Okay,
you
go
saw
ahead.
My driver's license.
I guess, Mr. Cruz, if you want to tell me you're under oath still, then go ahead and tell me what he lied about.
Your Honor, I would object to this round of questions.
No, you got your word in, buddy. You got your word in. Let me get mine.
It's been this, Mr. Cruz made it difficult.
Mr. Goodman, maybe I'm sorry, Mr. Goodman, go ahead. Maybe I'm jumping the gun. Go ahead.
Maybe I made it difficult. It's not my job to make it easy. John Jordan saw my driver's license. He read the word Joseph. He said it out loud. He knows that that is not the one, yet he went to in front of a notary and said he served it to that person. He's a liar.
Okay.
Judge,
He perjured himself. He duped you into issuing a warrant or a judgment.
Well, I think I've corrected whatever happened here, and I'm not taking any. The credibility is at issue for both sides, quite frankly. So, Mr. Goodman, we'll just do it the way I said, okay?
Thank you, Judge.
All right. Good luck to everybody. All right. Good luck. All right.
Court will note the appearance of Mr. Schaefer on behalf of the plaintiff and Ms. Greenlee-Clore on behalf of the defendant. This matter is before the court on the defendant's motion to resume court-ordered parenting time. Ms. Greenlee-Clore, go ahead.
Thank you, Your Honor. We're here again on this motion. My client has had this child, primary physical custody of this child since 2013. That was due to Miss Bailey having an insecure household, her having some mental health issues, and her threatening to abscond from the state of Michigan with the minor child. At this point, my client is just trying to get his son back. The parties agreed that while this matter was being sorted out, that Miss Bailey would have the minor child stay with her aunt for a weekend until they sorted this out. Shortly after that, the child arrived at the aunt's. Stephanie went and hired an attorney and filed this ex parte motion. This was never an agreement of the parties that this child was going to go and stay long-term with mother, or that the child was going to somehow start attending school in a different school district. Mother has withheld this child for 3.5 school weeks at the end of the school year. Didn't take this child to school at all. This child sat at home. This child has now been interviewed by CPS in her home when that's what she's saying that my client's going to do. And at this point, she's completely withholding this child. My client just wants this child back. Essentially, custody has been changed without a full hearing in this matter. Based on the response here, it looks like Stephanie has now enrolled the minor child in schools in Springfield Middle School. There's no motion pending to change schools here. This child needs to be returned, frankly, to my client immediately. This child is in danger at Stephanie's house. Stephanie has now allowed this child to be interviewed by CPS in her home. She's talked with CPS in her home. And everything that she's alleged that has kept this child with her has now happened in her home. This child is not safe in her home, obviously. She's not protecting the interests of this child in her home, obviously. She apparently plans to change the school district of this child without permission of my client or this court. She's withheld the child from school for 3.5 weeks. This child was an AB student. We don't even know what happened with his grades yet for the end of the school year in Allegan County, but he probably needs to be in summer school. Stephanie hasn't talked to my client or won't talk to my client about that. At this point, there's no reason this child should be withheld. This court last ordered that my client show proof that the CPS investigation and criminal investigation were over. However, there were no investigations. We can't show any proof that these investigations were happening or that they're over because they never happened in the first place. The police did initially do a forensic interview with the minor child, no, but that's it. Nothing was found. Nothing's going forward. We don't know what happened with Stephanie and her having CPS in her home, but it can only be presumed that it's due to the condition of her home and the concerns in her home that are long-term. And again, this court removed her primary custody for a reason. This child has lived with my client since 2013. There's been no motion to change custody at this point. She has had temporary care of this child pursuant to the court order. At this point, this child needs to be returned immediately to my client's household. My client hasn't had contact with this child. My client hasn't seen this child. This child needs to be returned. If this court wants to do an evidentiary hearing on this, we can certainly move forward at that point. But on a temporary basis, this child needs to be returned to his primary established custodial environment with father. Thank you, Your Honor.
Thank you. Mr. Schaefer?
Your Honor, these are the same issues that were brought up on the ex parte motion and the reconsideration of that. The circumstances were that there were allegations as set forth in the emails from the defendant's household that there was an allegation of a child in his home against this child as to improper touching. And as a result, the CPS got involved, the police got involved. And as a result of the emails whereby the defendants indicated that they were going to have the child talk to the CPS and the police, was not in the best interest of this child and was not protecting this child. And that was the purpose of the ex parte motion. As a result, the child hasn't talked to the authorities in this regard. The matter is still pending. The fact that the amount of time has gone by is not demonstrative of it not going forward. And to place this child back in the same household where we have the accuser in that household is not in the best interest of this child at all. This child needs to be protected, and that was the purpose of the ex parte motion. And I think it should continue until there is absolutely no chance that this is going to go forward. And to put the child back into a household where the accuser is still in that household of children is not appropriate for this child. My client has done everything that she can do to preserve the education of this child. She's looking forward for the education in the fall. The child has gotten credit for the year. He is a good student. And to place him back in that household where you have an accuser and you have an ongoing investigation is not appropriate. So we're asking that this matter be dismissed for that reason. And also, it's the same allegations that we had before that's been denied.
Your Honor,
Hold on. Who is the accuser and how is he related to, again, the defendant?
I believe it's one of the children in his home.
That's not true, Your Honor.
Okay. Well, what's the accuser's name?
Your Honor, there is no accuser. The minor child at issue here is the one who indicated that he might have done something wrong. The child that he indicated he might have done something wrong to is 3. The child went through a forensic interview and nothing was found in that forensic interview. I want to bring the court's attention to paragraph 9E of mom's response here, where she indicates she talked to CPS and the minor child talked to CPS with her.
Not concerning this matter, Your Honor.
Okay.
And that just further indicates that mother has CPS involvement in her house, and which is one of the reasons why the child was removed in the first place.
Well, we don't know that. It's all just guesswork at this point. So, I mean, we can utilize hyperbole all we want. There's no allegations or anything of that particular nature. Well, the court did initially, when the court did the order, again, keeping the child in the care of the plaintiff, there were obviously some allegations at that particular time. Again, I wouldn't, this matter came back before the court on basically a ex parte motion. I don't look at those as the same as motions that are brought where the parties have opportunity to each, again, allege and to respond. So that is the reason, obviously, that the defendant's motion for ex parte relief was denied, is I wanted to have a hearing on it. I didn't want, again, additional ex parte motions just going back and forth in the case without any time to have any response. What I'm going to do in this particular matter is, obviously, the child is there's a provision under the other order for summer parenting time. The court is going to continue whatever the summer parenting time is, that would again, that would commence and continue through the summer immediately in this particular matter. I'm going to then allow the current order, the order for custody, meaning the order not Mr. Schaefer's order, but the other order, to go back into effect. Court will reconsider that if in fact there is something substantial that comes out of a CPS, but if there isn't, then the court wants to put this back on the appropriate footing, and there is, as Ms. Greenlee-Clore states, there's no motion to change custody, so I'm not going to do it under the guise of a pending CPS investigation that may or may not proceed and may not be fruitful in any way. So at this point, do you understand? Again, it's kind of convoluted, but do you understand, Ms. Clore, what I'm saying?
It's my understanding that so I'm looking at the old order here from 2013. It indicates that the parties would exercise week on, week off during the summer.
Yep.
Ms. Bailey's now had the entire summer. Will my client now have his half of the summer, or will they start week on, week off immediately?
We'll do the week on, week off. I can always address any makeup at a future time. So we'll do the what day do they exchange? Is it a Friday or a Saturday?
Cody, what day do you guys exchange? Just word it.
Friday, and generally Friday to Sunday on her weekends.
Okay.
Well, no, during the summers. Have you guys been doing week on, week off during the summer?
Generally every summer we've been doing half on, half off. We never really did the whole week just because the transportation was easier, but we continued our weekends through the half of summers.
Okay. Well, do you want? I'm sorry. Go ahead.
Let's do this because apparently we can't agree. The court will do the week, as the order said, alternating weeks, starting this Friday, where the child will go back to the defendant. And at the end of the summer, then he currently has custody, so the child would stay with him at that point, unless something else comes up with CPS. So, Ms. Clore, you can prepare that order and submit under 7-day notice of entry.
Thank you. And if I could just specify 6 p.m. on Friday?
Yeah, 6 p.m. on Friday is fine.
Okay, thank you, Your Honor. I will.
Okay. Mr. Schaefer?
Stephanie, give me a call, please.
Okay.
Yep.
Okay, thank you. We'll conclude this matter at 9:11 a.m. You're free to go. Have a good day.
Thank you.
So I understand, were you renting the property to Seth, Corinne?
No, we were boyfriend and girlfriend
Okay,
for 2.5 years.
okay.
And
Mr.
I did a notice to quit and he didn't move out, so I had to file again.
Okay. Was he paying any rent to the property or anything like that?
We were mutual on things. I'm not asking for any money or anything like that. I just want my house back. I haven't been there in 48 days and I can't go there with him being there. So
Okay.
the Montrose Police Department told me not to go there.
Yeah. Okay, Mr. Coran, anything you wanted to tell me?
So yeah, she basically said, yeah, we were together for 2.5 years. We were actually not boyfriend and girlfriend. We were supposed to get married. We were engaged.
Okay.
Same thing.
I have 2 kids. She has 2 kids. I gave up my condo to move in with her. It was 2 years ago. It was sometime in June. I gave it because COVID kind of messed me up pretty bad. I had 2 surgeries, and so we agreed to move in together. I have nowhere to go right this second. I have been moving my stuff out slowly.
Okay.
Pretty much everything in this house is mine. I'm working 70. I'm at work right now. I'm working 70 hours a week.
Okay, so let's kind of cut through it a little bit though. When can you move? It's her house. You don't have an interest in it, sounds
No,
like.
I understand it's her. I understand it's her house. She's been chasing other men, so I told her I was done.
That's besides the point.
Guys, I don't want to get into all that. Just how much time do you need to move? How much time do you need to move?
Can you give me a month?
I
do have.
I'll be homeless. I can't do a month. I'm sorry.
She's living with her dad.
No, yeah. And my kids are sleeping on the floor. They have nowhere to sleep.
I never said they had to sleep on the floor.
Okay,
They have beds at home.
I cannot come to the house for any reason while you're there. You're very dangerous,
You
and I'm
could've
very
came to the
scared of
house.
you.
Okay,
No.
guys, I'll just, hold on. I'll just make a decision based on what both of
I'm
you.
sorry. There was
That's
nothing going on
Okay.
between that stuff.
I
so-
turned in police reports, harassment.
Yeah, I knew your kid. Now, what about all the stuff that her kid broke of mine? How do I go about getting
I
that
can't do,
taken care of?
it's a whole different issue. All I'm gonna deal with is when a move out date is, okay? So I'll give, by statute, I can give you 10 days. That'd be July 28th. So.
Is there any way to get me to the 1st and then I can just pack up?
This Mancor, can I give him just to August 1st? That gives him
I
that extra.
can't. I can't go to the 1st. I'm sorry. I'm gonna have to stay in a hotel this next 10 days.
Oh my gosh.
All right. Well, it's her property. She has the right to ask for the 10-day statutory period. I'll order move out date by.
Oh, she's not gonna have no beds or nothing to sleep in at the
That's
house.
fine.
It's all more stuff.
I'm fine sleeping on the floor right now as long as I have my house back for my kids.
Guys,
My kids have beds there. I'm the only one that doesn't.
You physically just took off and I haven't talked to you in over 2 months.
Because you harassed me.
No,
And I have
you
that.
kicked me in the face.
The judge has all that.
There's a police report. There's police reports on everything.
All right.
Yes, the judge has that. I turned it
Just
in.
like all the weapons in the house that your kid had at 16 years old too.
That's besides the point. This
No,
is
it's
about
not.
moving out and finding a house. If you make $1,500, you should be able to find a place.
Yeah,
You
and
had
I'm
48
trying.
days.
And
All
I'm
right, guys,
trying. I'm
gonna
working
mute-
70 hours a week.
Hold on, I'm muting both of you. The order is.
Trying to argue on the phone or on the, in the
July
hearing.
28th.
I'm surprised the judge is even putting up with this much of it.
All right, I don't know what you're doing there. July 28th, okay? That's the move out date. Got to be moved out by July 28th. I'll send out a judgment to both of you, okay?
Calling case 2023-1775 DM Hope Rangel versus Ruben Rangel. Today is Monday, July 24th, 2023 at 9:12 a.m.
Court will note the appearance of Ms. Podolsky on behalf of plaintiff, Ms. Huffman on behalf of defendant. This matter is before the court on the plaintiff's motion to prohibit the child from meeting the, I guess I should say the defendant's emotional, or I guess or I don't want to say significant other, we don't know that, but just simply the other person's partner. Ms. Podolsky, you can proceed.
Thank you, Your Honor. Complaint for divorce was filed with this motion. The parties continue to reside in the same home together with the minor child. So there is no custody or parenting time order in place. However, we do have concerns that there are significant others involved that are either romantic in nature or at least extremely emotional in nature. We do not believe it is appropriate to introduce the minor child to any such partners while the divorce is pending. So we're asking the court to put an order in place that prohibits both parties from introducing the minor child to such a partner or prohibit further contact with such partners. We do believe this has already occurred, and so we wish that it did not occur further. We have concerns as defendant believes because maybe something romantic hasn't occurred yet that an emotional partner is not in fact cheating. So that's why we have included that type of language of emotional partner. Thank you.
Okay, Ms. Huffman, what's your response?
I actually filed an answer indicating that my client denies that he has any romantic partners or any type of partners. However, he would, well, and also stating that we agree with the plaintiff. We simply asked the court to grant plaintiff's motion. So.
Okay, Just so I heard that correctly, Ms. Huffman, you're agreeable and you want the motion granted?
That is correct. I indicated in our answer that we were fine with the plaintiff's motion entering or us doing a consent order, that the children not be introduced to either party's significant others of any type, whether they be romantic, emotional, whatever, because my client's not doing that anyway, so he doesn't care. He's
Okay.
fine with that.
Okay. Well, Ms. Podolsky, it appears that you've got an easy motion then if we have an agreement. So if you would prepare the order and either submit it to Ms. Huffman or submit it under 7-day, we can conclude the matter, and that's fine. Just go ahead and prepare that.
Will do. Thank you, Judge.
Okay, thank you.
Thanks. Yep, thank you.
They what?
The office is going to be here half an hour.
Okay.
Are you ready? Okay.
Yeah, I'll just do this one. Court does call the case, People versus Bruce Larkins.
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender.
Judge, I would ask that the officer in charge, Martinez Gibbs, be allowed to sit with me at the council table, and we are going to sequester the other witnesses.
All right, our witnesses are ordered sequestered. Defendant and officer in charge may remain. We call your first witness.
Thank you. We call Arnold Warnock.
Sir, please come forward, be sworn.
Swear further testimony about to give will be the truth, the whole truth, and nothing but the truth, so help you God. See, date and spell your first and last name.
Arnold Gornell, Gornall.
You may inquire.
Thank you. Arnold, is there something that happened on July 3rd of this year that brings you to court today? What was that? Okay. And did that happen? Where did that happen?
Complex where I live at.
Where is that? Where's that located?
401 West Michigan.
Then okay. And is that in the city of Ypsilanti, Michigan? Is that in Washtenaw County, Michigan? All right. So what happened when your life got threatened? How was your life threatened?
Well, I just come back from picking up deals from the Hope Center to bring back to the complex. Two for myself, one with my girlfriend, and two inbound. I bring two for the last 7-8 years. Then I pulled in the third handicap parking spot. I went back and learned got the rooms out of the back because I turned around and started walking about 30 feet to the entrance to the building. This resident walked up to me and started mumbling something. I said, "What'd you say?" Says, "I told you never to speak to my wife again." I'm gonna lose my fucking brains out. Stepped back, jerked his shirt up, pulled a semi-automatic out of his waistband, shoved it under my throat for about 5-6 seconds, kept saying the same word over and over. Moved it from there and put the barrel on my forehead for another 5-6 seconds. Well, I figured I'm just a dead man, so I just kind of took my arm, went like that, and started walking away towards the entrance to the building. And he poked me in the back with it about 3 times.
Okay. Now, you just made a gesture about what you did with your arm. Can you describe what that was?
I said, I think I took my arm after you removed the gun from my forehead. I think it went like that, maybe against it, I don't know.
Okay.
Just a turn. It was my back would be coming.
All right. Is the person who did that, who did this to you in the courtroom today? Can you point him out and describe him, please?
Said right over there, what's your?
Act to the record reflect incorrect identification of the defendant, Bruce Larkins.
Without objection, record shall so reflect.
Arnold, I'm going to show you what I've marked as people's proposed exhibit number 1.
Yeah, that's a 9mm semi-automatic.
Okay. All right. And do you recognize, is that the firearm he used that day?
Yes.
Okay. We move people's proposed 1.
Any objection or voir dire?
No, thank you.
Exhibit 1 is admitted, and yes, you may approach.
Oh, sorry. Thank you.
Yeah, I know you didn't ask. All right.
That's all I have. Thank you.
Thank you. Cross-examination.
Yes, thank you. Good morning, Mr. Gornell. It's my understanding that you and Mr. Larkins have resided in the same apartment complex for about 4 years. Is that correct?
I've been there 10 years. He's only been there 2 years.
So you believe he's only been there 2 years?
Pardon?
You believe he's only been there 2 years?
I believe so, 2021.
And would I be correct in stating that that is when you began to know him to have a relationship with Patricia, who lives in that building? Now, you stated that you pulled up to the complex and parked in a handicap space. Is that right? And would I be correct in stating that the vehicle that you pulled up in has a handicap sticker or a handicap license plate?
License plate.
And that handicap license, that vehicle belongs to your girlfriend, Paula Mahler, is that correct? And that's her handicap license plate?
Yes.
Now, about the time you came to know Mr. Larkins through Patricia Larkins, pardon me, through Patricia, would I be correct in stating that you and Patricia had a romantic relationship?
Sexual relationship. I had a girlfriend and she had a boyfriend. We just weren't getting what we wanted to be doing.
And would I be correct in stating that your girlfriend was Miss Mahler, Paula Mahler?
Yes, it was.
And if not in 221, at some point within these past 2 years, between 2021 and now, Miss Patricia married Mr. Larkins, is that correct?
I believe she told me she got married in December of 2020.
Now, would I be correct in stating that you and Miss Patricia Larkins, Mrs. Patricia Larkins, sexual relationship, as you described it, lasted at least 6 months?
About 5.5. Along the way, I found out she was seeing this man.
And during the time you had that relationship with her, isn't it correct that you courted her in some manner by buying her gifts?
I bought her flowers, I bought her a set of pajamas in the bathroom, her earrings.
Would I be correct in, as also as part of a courting type gesture, that you also sometimes gave her money?
Never gave her money. Better, I took her grocery shopping on several occasions. She put $1,250 on my bridge card that I got from the state. Pandemic money I accumulated on it.
And it's sometimes during this relationship that you had, you would eat over her house, isn't that correct?
At breakfast every once in a while. Coffee. No dinners to speak of. Every once in a while on holidays, there's a big meal for 10 or 12 guests to show up.
Now, would I be correct that at some point after her marriage to Mr. Larkin, that you began to indicate that you believed that Mrs. Larkin owed you money?
Yes.
Okay. And on the date of July the 3rd of 2023, you actually had an encounter with Mrs. Larkin, is that correct?
A discussion with her on the elevator.
Isn't it correct that you threatened her at the time with regard to the?
I told her, if this is a threat, I said to her, I'm tired of listening to her count out her slides, and I said, I guess the only way I'm gonna get my $1,550 back, I'm gonna take it to court and sue you and let a judge make a decision. Now, is that a threat?
Is that
That's a statement.
That's a statement, okay. Isn't it correct that on occasions that you did say that you would have to do something about this, vaguely?
Legally?
No, just generally, that you would say to her, that you said to her that you were going to have to do something about this if she didn't pay you back your money.
I just explained to you. That take her to court and sue her.
So my question is, did you ever use the words that I just said?
If you're asking me if I ever threatened this woman, no, I've never threatened this woman. I made a mistake.
Okay, I'm gonna try to reframe my question because I don't believe you're understanding me. Isn't it correct that when you saw her on the elevator, this was not the first time that you had approached her with regard to this money?
No, it's not the first time. It's about the third time in 22 months.
And isn't it correct that on these at least 3 times that you approached her, that on at least one of the occasions you said, if I don't get my money back, I'm gonna do something about this?
No, I never made a statement. I made you the correct statement. What I said to her.
And would I be correct in stating that you have no written agreement with her with regard to paying back the money?
No, but I've got it all logged on a calendar book of 2020.
So on this day, after you had threatened Miss Larkin, isn't it correct that that's when you? Isn't it correct after you had made these threats to Mrs. Larkin in the elevator, that after that is when you saw Mr. Larkin, correct?
I didn't make any threats to that one.
Isn't it correct that after that encounter that you saw Mr. Larkin?
Went out front, his wife and I went out front door together, got on the elevator on my floor. She needed a shopping cart, unloaded groceries, so their car was parked right there. That's when I got my car with Paula and left to go to the Hope Center. I was gone approximately an hour before I got back. In the meantime,
And would I be correct in stating that when you got back, it was after you saw and had your encounter with Mrs. Larkin in the elevator?
I saw him 1 hour after I had an encounter with her. 6:10 p.m.
Now, when you saw Mr. Larkin, would I be correct in stating that Mr. Larkin used a cane,
What?
that he had a cane to walk with?
Yeah,
Am I correct in stating that Mr. Larkin always uses some sort of assistance or aid, like a cane or a scooter to get around?
I've seen him use several things.
And would I be correct in also stating that when you saw Mr. Larkin, that he had apparatus for breathing, for his oxygen tank?
Oh, I noticed it.
In the past, would I be correct in saying that you've seen Mr. Larkin with oxygen?
Not really. I've seen him use a, we call it walker, push cart walker, and a cane. I don't ever remember. I can't particularly say I've noticed him using oxygen. I've got a sign on the door that says oxygen.
So you've seen the sign on his apartment door that states oxygen in use? And would I be correct in stating that your girlfriend lived across the hall from Mrs. Larkin while you were engaging in this
Yeah,
sexual relationship? And during that time, there was no sign about oxygen in use on Mrs. Larkin's door, is that right?
no, there wasn't.
So that was only after Mr. Larkin moved in that that sign came up, correct?
Yes, I'd say so.
Would I be correct in stating that you do not use any aids to assist you with walking?
Not yet. Almost 82.
Would I also be correct in stating that you do not use oxygen to assist with your breathing?
No, I don't.
Would I be correct in stating that when Mr. Larkins approached you about your encounter with his wife earlier that day, that you were not pleased with his interaction with you?
Why would I be pleased with him? He just threatened to kill me?
Would I be correct in stating that on prior occasions, when approaching Mrs. Larkin with regard to the money you believe she owes you, that you called her or referred to her as something other than her name?
No, never.
Would I be correct in stating that you actually have, on at least 2 occasions, when asking about the money you believe you're owed, called her an Nigger?
No, I never.
Isn't it correct that you have also referred to Mr. Larkin in that manner?
I did one time, yes. He told me he was gonna beat my motherfucking ass on my, he called me up on my phone, told me that was the second time he threatened physical violence.
And isn't it correct that's because you have repeatedly threatened his wife, Mrs. Larkin, regarding this money that you say she owes you?
I've never threatened that woman with anything other than a statement.
Sustained. Sustained. Go ahead.
And would I be correct in stating that when Mr. Larkin spoke to you about about your encounter with his wife that day, that when he initially spoke to you, when he spoke to you initially, there was no weapon displayed.
There was what?
There was no weapon displayed when he initially spoke to you.
No, he displayed the weapon right after he got done saying, I told you never talk to my wife again, or I'll blow your motherfucking brains out. He stepped back, jerked his shirt up, pulled it out of his belt, shoved it up underneath my throat for about 5-6 seconds, then put the barrel on my forehead about 5 or 6 seconds.
Okay, I had to pause for a quick second here because I'm getting two totally different pictures of who Mr. Larkin is from Attorney Gaines versus the victim. So I went back to his pre-trial hearing so we could actually see him and hear him and get an understanding of who he is.
The case of the people versus Bruce Larkin.
Alex Chabalowski for the people.
Your Honor, Gina Noveski, First Assistant Public Defender, with and on behalf of Mr. Larkins, who is present via Zoom.
Mr. Larkin, state your name, please.
Bruce Larkins.
Okay, what are we doing?
Your Honor, Mr. Larkins is requesting we set a preliminary exam date.
Preliminary exam in this matter will be set in person, July 25th, 2023, 9 a.m. Who am I? Before myself.
Thank you very much, Your Honor.
On continued. Thank you.
Thank you, Mr. Larkins.
No, he displayed the weapon right after he got done saying, I told you never talk to my wife again, or I'll blow your motherfucking brains out. He stepped back, jerked his shirt up, pulled it out of his belt, shoved it up underneath my throat for about 5-6 seconds, then put the barrel on my forehead about 5 or 6 seconds.
Isn't it correct that after he said what he said to you, that you actually took steps closer to him?
Why would I do that?
And isn't it correct that the weapon was not displayed until after you had made these steps towards him?
I never made any steps towards that man. He was doing the stepping towards me.
And isn't it correct that at that time, he was the person who needed the assistance with the walking, correct?
How was I to know that? He didn't look like he didn't have any problem walking up there when he walked from the building up to where I was at.
But he did walk with a cane, didn't he?
He had a cane, yeah.
And you'd seen him before, you stated, with a walker.
I don't see that man not that often.
My question is, had you,
Apparatus for one day, and the next day he might have a different apparatus.
but you had seen him before using a walker,
Yes,
and you'd seen him before using a scooter.
yes.
And may I have one moment, please?
You may.
Those are all the questions I have for you at this time. Thank you.
Right. Sir, you may step down. Thank you.
We call Officer Marquez Gibbs.
Sir, please come forward to be sworn.
So I swear affirm the testimony about to give the truth, the whole truth, and nothing but the truth, so help you God. State still your first and last name.
Marquez Gibbs, Martezgibbs.
You may inquire.
Thank you. Mr. Gibbs, how are you employed?
Ypsilanti Police Department as police officer.
And were you working on July 3rd, 2023?
Yes.
Did you get dispatched out to 401 West Michigan to investigate a felonious assault?
Yes.
And when you got there, did you ultimately speak with someone named Bruce Larkins?
Yes.
And is that person in the courtroom today?
Yes.
He's where is he?
He's right over there.
All right, thank you. And at some point, were you able to recover a firearm from Mr. Larkin's apartment?
Yes.
And you had an opportunity before the hearing today to look at people's exhibit number 1, that
Yes.
photo. Is that the firearm that was recovered?
Yes.
And did you inspect that firearm to see if it's a working, legitimate firearm?
Yes.
Was it loaded when you
Yes.
found it? Excuse me. When you found it, was it loaded?
Yes.
All right. And thank you. No other questions.
All right. Cross-examination.
So Gibbs, you indicated that you found the firearm. Let me back up. Officer Gibbs, approximately what time did you arrive at Mr. and Mrs. Larkin's apartment?
Oh, couldn't tell you. I can't recall. I have to look at the incident.
By chance, would you have your report with you to refresh your recollection?
Yeah.
I can, Your Honor, may I have a moment to?
You may.
After looking at your report, is your recollection refreshed?
Yes.
So approximately what time did you arrive at Mr. Larkin's apartment? And when you arrived at Mr. Larkin's apartment, you indicated that you initially had an opportunity to speak to him. Is that correct?
Yes.
And he did in fact tell you that. I'll rephrase that.
Thank you.
Isn't it correct that based on your conversation with him, you were able to find a firearm in his apartment, correct?
Yes.
And at all times, Mr. Larkin was cooperative with you, is that right?
No.
No. Would I be correct in saying that Mr. Larkin was upset about the situation that occurred with he and his wife? Yes. But he did not lie to you about having a firearm, isn't that correct?
No.
And isn't it correct that he even told you he had a CPL?
Indeed, yes.
And you were able to confirm that he has a CPL?
Yes.
So he is licensed to carry and you were able to find the weapon without any challenges? Okay. When you arrived, would I also be correct in stating that you were able to observe that Mr. Larkin had on
What's the name? Yes, and a warm game.
Thank you. So you were able to see that he was utilizing or had recently utilized having to have oxygen.
Yes.
And would I be correct in that you also were able to see that he needed aids to assist him with walking?
Yes.
So you saw his cane, is that correct? And did you see his walker?
No, didn't see a walker.
Did you see a motorized scooter?
No, didn't see that. Once we were in the hallway though, so.
And when you arrived at 6:14 p.m., would I be correct in stating there was not a firearm on Mr. Larkin's person?
Correct.
And that you at no time saw a firearm on Mr. Larkin's person?
Correct.
But you were able to see that he had, as a person licensed to carry, that he had the appropriate equipment to carry if he chose to, correct?
Yes.
Okay, thank you. Those are all my questions. Thank you, Your Honor.
Any redirect?
No.
All right. Thank you. You may step down. Any further witnesses for the people?
No.
Any witnesses for the defense?
No.
Move to bind over.
Response?
Your Honor, we object to the bind.
Based upon the don't need argument, based upon the testimony in this case, the court would find that the people have shown by probable cause that an offense was committed and that the by probable cause that the defendant committed the offense. Therefore, the defendant is bound to risk trial on this charge. Ms. Gang.
Your Honor, we acknowledge receipt of the information related to legal on the record, and at this time, my client wishes to stand.
Defendant. Waiving formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
September 12th at 1:30 PM with Judge Conley.
September 12th, 2023, 1:30 before Judge Conley.
Thank you.
Bond in this matter will continue. Thank you. That's everything there. All right, which one?
Next on the list is a pre-trial conference in 2023 LM 283 Diltor Properties LLC versus Kennedy Kelly and others. Please announce appearances.
Locke on behalf of the plaintiff Diltor Properties, who does not appear.
All right, and is Kennedy Kelly here?
Yes, Your Honor.
And next to you is one of the defendants. Would that be Sydney or Michaela?
Yes, Your Honor.
Okay,
Yes, Your
Sydney,
Honor.
Sydney is in the white t-shirt, Michaela's in the white sweatshirt. Okay, and who is that with Miss Kelly?
This is my mom. She was my co-sign on the lease for the house.
Okay, now one of you had an attorney, but the attorney has been allowed to withdraw, so none of the defendants have attorneys, is that correct?
Yes, Your Honor.
Okay, and Ms. Locke, a brief overview of the petition. As I understand it, you're trying to collect $5,750 joint and severally with these three college students who were or are roommates and apparently rented from your client, who now alleges that there was some water damage in that amount. Is that basically the crux of it?
Yes, Your Honor. Damage to the plumbing fixtures that required significant repair.
And then there was and your theory that they owe that money is basically what?
The terms of the contract require them to pay, well, to maintain the fixtures, to maintain the property in good order. Essentially, the facts will demonstrate that when they left for Christmas break in 2020, they shut the heat completely off, not just turned it down, which resulted in the pipes freezing and significant damage to the plumbing. Then my client had to incur the expenses to repair the fixtures and demanded that the tenants pay based on their negligent actions. They refused, and here we are.
Okay. Miss Kelly, you don't believe you owe that money, is that correct?
Yes, Your
Can I
Honor.
chime in? Okay. Your Honor, I'm going to chime in because my name is also on the lease. So when the damages were incurred, it was when
Okay, what is your name? I'm sorry.
My name is Kelly Sherpy.
Your Honor, this individual is not a party to the case, so I would object to her making any statements on the record. Furthermore, Miss Kelly Kennedy, sorry, did not respond to discovery and has not provided anything as far as a pretrial document goes. We did submit pretrial, so this idea that another individual would be in pled at pretrial conference seems improper.
All right, so she says her name is on the lease, but she's not named as a defendant.
That's correct, Your Honor. All of the parents co-signed on the lease for their children, but all of the individuals named as defendants are adults.
Okay. All right, so back to you, Miss Kelly. You didn't respond to any of the discovery, that is the questions that were sent to you after the petition was filed and you filed an answer.
So the previous.
Hang on. Are you an attorney, Ms. Sherpy?
Mm-hmm.
She was just,
Ms. Sherpy, did you say you are an attorney?
No, I'm not.
Okay, but you are her mother, but she is a legal adult Okay,
Mhm.
and you're not named as a defendant, so go ahead, Miss Kelly.
I was brought to believe that it was done through my previous attorney who is not a part of this case anymore. So they were initially taking care of everything. I sent them all my documents, everything, and they said that they had sent it forward.
That it had been submitted.
I don't know what that means. Sent it forward?
Or it had been submitted
Submitted to whom?
to the court, because I sent all of my evidence and all of my answers to them so that it could be sent to the court.
Did you send your answers and documents to Miss Locke?
I do not believe so. I believe I sent it. I would need to look at their name.
Well, she was the attorney that requested it. She's the attorney that filed the case, but you don't think you answered her questions to her? You think you sent them to the court?
Yes.
All right, Miss Belen, does that sound right? Did she send you some questions for discovery that should have gone to Miss Locke, or do you know?
Just a moment. I don't see anything in the case. When were they sent?
Ms. Kelly, when did you send them?
I believe this was during the school year. I am going back and looking through right now. I apologize. Not that one.
Your Honor, if it's helpful, we sent notice of service of our discovery request on June 2nd and June 6th.
So that would have most likely been outside of the spring school year.
Yes, I just have to. Can you grab your phone?
Baby.
Okay, so, all right, so what in a nutshell is your reason that you don't owe the money?
I was not there. I was the first to leave, and
There's no photo evidence.
there was only, you can't talk.
I'm talking to you.
I understand.
Well, you need to stop. She needs to either get an attorney or represent herself since she is an adult. Go ahead.
There was not sufficient photo evidence. We were given 4 pictures when we asked for proof, and we were just handed the 4 pictures in the bill and a brief explanation on what had happened. And I was not in the state when this happened. I was the first of us 3 to leave. I believe I left around the 13th of that month, and I had done everything I could to make sure I was leaving the house well, I could say. Turning off all my lights, doing what I could, but I never touched the thermostat or any of the other fixtures.
Did you return to live in the residence after Christmas break?
Yes, ma'am, until we were handed our notice and we vacated.
And when were you given the notice?
I believe it was a month after, because we were handed the bill, and then through communication with our landlord, when we decided we were not going to pay because of insufficient evidence, we were handed an eviction notice.
All right, so Ms. Woodard, what is your response to this petition in a nutshell?
My response would be that I was also not present on the property at the time that the incurred damages happened. I left the property on December 14th, and I had left the country. I live in Canada. I'm from Canada. I had left to go back home. I returned to the property in January, and all the damages have already been incurred. I left the property in good standing when I had left. I had unplugged all of my own fixtures. I had turned off all the lights. I had made sure that the thermostat was in good condition. And I had notified Diltor Properties that I was leaving for Christmas break. And they had no response to that as to anything that they wanted done to prep the property for our departure. So I had left the country and had not spoken to Diltor Properties or anything of the sorts while I was away, and I returned in January, and we had been given an eviction notice shortly after that.
You said you returned to the damage. Could you tell there was damage when you returned?
No, not at all. I had no idea what had occurred. All that was said was that plumbing damages had occurred and they were fixing the property when I had returned. So was not allowed to stay at the property for 2 weeks until all the damages were fixed.
But you never saw any damage?
No.
Okay, so are you contesting that there was any damage?
I wouldn't say I'm contesting it. I'm just saying that I was not aware of anything that had happened while I was out of the country until I was notified after.
But your position is if damage did occur, you're not responsible.
I would say my contestation is that $6,000 in damages seems absurd as to what evidence we were given.
All right, so amount is too high. Okay.
And my other contestation would be that on our lease, it states that we are only responsible for plumbing fixtures. And when I look at the definition of plumbing fixtures, that would consist of the faucets, the toilet, things that aren't in the ground. And from what our understanding is that the pipes that had been broken were underneath the house. And also the water heater was replaced according to the bill that we were given.
Okay. And Ms. Lentz, your response to this petition?
Yes, Your Honor. Sorry for my voice. I've been sick. So I left December 17th for Christmas break, and I thought that when I was turning off the AC. I didn't think I was turning off the heater. And so then when I was leaving, because I was the last one to leave, I didn't realize that there was going to be a bigger snowstorm. It said that in the weather that week, that it was in the 60s. And then when I left, I went to my father's house, and then we had that snowstorm. And then I went to go check back on the house. And yeah, so it's just a very interesting situation. And then they also charged us for a crawl space. The evidence that they didn't give us was only the 4 pictures, and in one of the pictures it only showed one pipe actually being broken. And the pipes were, when they pulled them out, they said they were covered in styrofoam and duct tape, and they were already corroded. And yeah.
So are you denying that there are any damages done, or do you agree with the damages? The damage?
Sorry, can you say that again? You cut out.
Well, what is it that you're contesting in this petition? First of all, are you contesting that there was any damage to the property?
Not on my part. No, ma'am. No, Your Honor.
You didn't have anything to do with the damage. And so you're not okay, so you're saying you're not responsible, but do you know if there was damage? Are you saying there was damage and it wasn't your responsibility, or there just was no damage at all?
When I left, there wasn't any damage at all.
And when you came back, was there any damage?
Not that I was aware of, besides when we got notified that we had to pay for the plumbing.
All right. And what is your response to the amount that is requested?
I think it is a little absurd, and I wish that they would have communicated with us a little bit more better instead of just serving us an eviction notice and the bill.
In your answer, you denied the allegations and requested 14 days to file an answer or other pleading. But you didn't file any other pleadings besides this document, did you, that has affirmative facts and defenses?
I turned in every document that was given to me by Ms. Locke.
But none of you are going to have an attorney in these proceedings, is that correct? The three defendants?
No, on my part at least.
We will be moving forward.
You will have an attorney from this point forward?
Yes, Your Honor. At least on my part.
Well, this is a pre-trial hearing to decide a number of factors. Ms. Locke, have you any matters you want to pursue in this regard, the pre-trial hearing specifically?
Your Honor, I did submit to all of the defendants, what in Chapter 60 would be a pretrial questionnaire, but all of the pre-hearing information was submitted prior to our last hearing, including all of the documents that we intend to present at trial, as well as a witness list. I did not receive any of the same items from the defendants. I did follow up with each defendant after our last court appearance on the 3rd of July. When we had to be rescheduled because of a scheduling conflict. I requested all of them submit their discovery responses because none of them had responded. And Ms. Woodward and Ms. Lentz both responded to the discovery requests. I have their documents and I think what they intend to present at trial. Again, I haven't received anything from Ms. Kelly. I don't think any of the defendants here today have established a legal basis for why our claim should be denied, other than they don't think they should have to pay for the damages that were caused to the property. Ms. Lentz just specifically stated that she shut off the heater and then it got cold and everything froze. The contract does hold them jointly and severally liable for the damages, and there's some comments in their answers that they were evicted. I think it's important to note that they were not evicted from the property, but they left voluntarily. That can also be established at trial. I think, Your Honor, one of the main things that we want to clear up today before we proceed is whether or not a jury trial is going to be necessary. Ms. Kelly's prior attorney requested a jury trial. As I said, the contract requires the tenants to pay for any attorney's fees, and the cost of a trial is going to be significant, probably more than the damage claim. In addition to that, all three defendants are college students who are only in El Dorado and Butler County for a temporary amount of time. One defendant is an international student, and we would be concerned about our ability to collect on a judgment or even get to a judgment if they are not available for said jury trial.
How long do you think this trial might take, Ms. Locke?
Your Honor, we have the plumbing company available to testify, as well as the landlord that will testify. I would imagine we would be done in a day, but I don't know with jury selection procedures and those things, and having three defendants.
You're not asking for jury trial, right?
I am not, Your Honor.
Ms. Kelly, are you still wanting a jury trial?
I am open to whatever is best. That was we are currently looking for another attorney, which has been kind of difficult between moving to Texas, but we tried to settle and they denied it. We gave them an offer of a certain amount of money and it was denied.
Well, if I set a trial date, your attorney will need to be ready for that trial. Have you talked to any attorneys at all about getting ready for trial other than the one that left your case?
We are currently still reaching out. We have had trouble trying to find an attorney.
How much more time do you think you're going to need to find this attorney?
Good question. A few weeks.
Okay. And the other two of you, you said you do not intend to have an attorney, Ms. Lentz, is that right? Double checking?
Yes, Your Honor.
And Ms. Woodward, double checking with you?
Sorry, Your Honor. Yes, I will also be moving forward without a lawyer.
Okay. So I'm thinking maybe set this over for 2 weeks for another pretrial to see if you do get an attorney. Ms. Locke, any objection to that?
Your Honor, we would object. Her attorney filed a motion to withdraw, which was approved by the court. And that was back in June. We were before the court earlier this month where there was no mention of an attorney or wanting to find an attorney. We're now here at the end of July. The farther we get from when this case was filed and the damages were incurred, the harder is going to be for my clients to collect on this judgment and hold their tenants accountable.
So how far out are you? At this time, it doesn't sound like we have a true request for jury trial because the attorney that asked for it is gone, and Ms. Kelly said she's going to be talking to an attorney. So we can set this either for another pretrial or we can set this for a bench trial. And then if the other attorney thinks that they need to come in and ask for something different, we can always reconsider that. But Ms. Locke?
Yeah, sorry, Your Honor, I apologize. We would like a bench trial date set.
And how far out? You said you're going to have about 2 witnesses. Ms. Kelly, how many witnesses will you have?
I believe I will have, I would like to move forward with another pretrial. I would like to make that known. And for a case of witnesses, I don't believe, I believe I have one.
One witness. Ms. Lentz, how many witnesses will you have?
Your Honor, I apologize. Since there was no pretrial disclosure, can she tell us the name of that witness so we can be prepared?
Sure. Who is your witness?
My father, who was in communication with the landlord.
In construction.
And who is in construction.
And what's his name?
I believe, I'm sorry, I'm trying to remember if it is my stepdad. It is my my stepfather, Ryan Sherby.
B-R-I-A-N?
RYANSHERPY.
And is he going to be a fact witness? Or is he being presented as an expert witness based on his knowledge of construction?
Yes.
An expert witness.
Your Honor, again, there's been no disclosure of any of these things, and there was a prior attorney involved in this case on behalf of this particular defendant. And no responses to our discovery where we did request information about witnesses who could come forward on behalf of Miss Kelly.
Well, at this time, I will show him as a fact witness. I don't have any reason at this time to know what his credentials are, but if they want to get their attorney, again, their attorney can raise these issues and we'll take them back up. Anyone else that you're going to have come in?
No, Your Honor.
All right, Ms. Lentz, any witnesses?
No witnesses, Your Honor.
No, you're not going to either one testify on your own behalf even?
Oh, yes, me. I'm sorry, Your Honor.
Okay. How about you, Ms. Kelly? Are you going to testify on your own behalf?
Yes, Your Honor.
Okay. All right, so you're going to have a Brian Sherpy, and you're going to have yourself testify. Kelly Lentz is going to have herself testify. Ms. Woodard, who are your witnesses?
Only myself, Your Honor.
Okay. And how much time are you asking the court to reserve for this bench trial, Ms. Locke?
Your Honor, we will only need a few hours. I'm not sure based on the defendant's witness list, how long they will need.
Does anyone have any suggestions? Belinda, do we have, if we start, do we have a day where we could start at 1:30 instead of 2:30 and reserve the afternoon? Which means we could use it at 1:30. Ms. Locke, I know that's probably a little further than you'd like to go, but that'd be 4 weeks.
Yep, that works for my calendar, Your Honor.
All right, everyone else, August 28 at 1:30, you can be here, and we do these generally by Zoom. So if you have any exhibits that you want the court to consider, you'll need to exchange those at least a week before court and with all the parties and with the clerk at the courthouse. Now, did I see some kind of counter petition or cross petition in here? Does
Your Honor,
anybody?
there was a claim originally by Miss Kelly for attorney's fees. I replied to that and then it was dismissed.
Okay, all right, so no counter petitions. Okay. Anything else that we need to take up at this time? Now, Ms. Kelly, I will expect your attorney, that's 4 weeks out, I'll expect your attorney to be on board and ready to go to trial at that time and not come in at the last minute
Yes, Your Honor.
saying I've just been hired and I'm needing more time.
Yes,
Your
Your
Honor, if you don't mind, I would just like to confirm with all of the defendants that they are receiving my emails. With them moving, it's difficult to get mailings out. So if they are receiving my emails, that would be my preferred way to share exhibits and things going forward.
Anyone not getting her emails?
When was the last email you sent? I just want to make sure that I saw it or it went through.
I emailed you on Monday, July 3rd.
Okay. Give me 2 seconds. Okay, I see this. Okay, yes. So going forward, I got you.
Anything else that we need to address from anyone?
Nothing further from the plaintiffs, Your Honor.
Hearing nothing further, then we'll reconvene on August 28th at 1:30 for trial by Zoom. Thank
Thank
you
you,
all.
Your Honor.
We will be in recess and you may go, all of you.
Thank you, Your Honor.
Thank you, Your Honor. There we go.
Why don't we get everybody identified for the record here? Ms. Locke, if you'll go first announcing your
Yes,
client.
Your Honor. Sorry, Susie Locke on behalf of the plaintiff Stilltort Properties, who appear today by their managing member, Chad Young. He is in my office, but not currently on the screen. Currently on the screen is who we intend to call as our first witness, and that's designated by the Young witness box.
If you guys remember this case, there was a broken pipe when they went away for Christmas vacation, and it's like $6,000 in damages. I thought there was 4 of them. Anyways, and it
And then do we have Kennedy Kelly present?
Yes, Your Honor.
And you do not have counsel, or do you?
No, Your Honor.
She was supposed to get counsel
We have
before now.
Sydney Lentz present.
Yes, Your Honor.
And do
And
you
re-
have counsel today?
I do not, Your Honor.
Remember, Kennedy's mom was there,
Kayla Woodward, are you
kept
present?
passing her notes.
Yes, Your Honor.
Do you have counsel today?
No.
Me too. Yes. She turned the air conditioner off and the pipe froze in the basement and busted and caused like $6,000 worth of damages. But they were disputing the charges.
There had been a counter petition filed, but I understand that that was dismissed. So, and with that, is there anything else pending besides the petition that we addressed last time for a principal amount of $5,750? Ms. Locke, that appears to be the only remaining issue, is whether these three defendants owe that to your client. Is that right?
That's my understanding of the current posture of the case, Your Honor.
All right. So we don't have any agreements. Everyone still pleads not guilty, not responsible. Is that right? Ms. Kelly,
Yes, Your Honor.
Ms. Lentz,
Yes, Your Honor.
and Ms. Woodward.
Yes, Your Honor.
And I remember basically what this is about, but Ms. Locke, if you want to refresh with a brief summary of why we're here.
Thank you, Your Honor. In December of 2022, the three defendants were co-tenants in a property owned by Diltor Properties. In December, when the three tenants went home for Christmas break, they were all students at Butler Community College. They went home for Christmas break, and if the court will remember, during pretrial conference, Ms. Lentz admitted that she shut the heating and air conditioning unit off when she left. That resulted in a freeze of the plumbing fixtures and all the pipes. It caused significant damage that had to be repaired. When the repairs were made, the landlord, Diltor Properties, requested payment for the same from all of the defendants as part of the lease agreement. When they refused, we were forced to take legal action to try to seek that money be paid back to the landlord.
And is there one of you from the defense that want to tell me, do you have any reason to say you're not responsible other than your Ms. Woodward? Are you wanting to represent the group or yourself at least? Just a
Yeah.
real brief statement of why you're not responsible or why you think you're not.
Yes, Your Honor. We take no responsibility for the damages incurred over Christmas break. We had told Diltor Properties that we were all leaving for Christmas break. And as a result, they took no action to mitigate the processes of anything to prepare for us leaving. We had read through the lease agreement and it stated that we have to keep all plumbing fixtures intact and in good condition, as well as removing the outside hose, which we did that. We went through all the processes that we were told to keep the property in good condition. We made sure to remove all electrical appliances, unplug everything. I was the one that quite frequently checks on our thermostat while we were living there. I was sure that it was set at 70 degrees on auto when I had left for Christmas break, which was on December 14th. And my other roommates had left previously before me and also after. So I did my due diligence to make sure that everything was in good condition before I left. I had no knowledge that there was any damages incurred until we were notified by the plumbing that all of a sudden we had cracked pipes. Checking on the weather, we were told that it was negative 32 degrees, which is abnormal for Kansas. That's an act of God, Your Honor, to have temperatures go that low. Therefore, we take no responsibility for the damages incurred because it was so cold. There is nothing that we did
to lead to those damages.
Now, Ms. Lance,
I'm trying to remember. She was the one that was in the car last time, right? And she's from Canada. She was like down on the bottom right, and she was well spoken. Wasn't there a fourth one, or am I thinking of the mom?
Ms. Kelly, does she speak for you, or do you want to make separate statements of what you think your position should be today? This isn't your testimony. This is just the overview of what your position is and what you think the evidence should show or will show.
Yes, Your Honor. Most of my statements agree or align with Michaela's. I was the first to leave. I followed the cold weather protocol along with Michaela. We kind of walked through it together. And whenever we were told about the plumbing and given the bill and we asked for photo evidence, we were only given 4 photos. And then whenever we asked for more photos or more documents of the damage that had occurred, we were referred to the plumbing company, which we were given the same 4 photos that only showed one.
Okay, I think you're breaking it down a little more than you can do that when you testify if you want, but I think I've got the gist of it. Ms. Lynch, you're in with them that you think you followed the protocol and that you're not responsible for the damage.
Yes,
Is that your position? Okay. All right, Ms. Locke, you can call your first witness.
Thank you,
No,
Your Honor.
just hurricanes.
We would call Sydney
Mad at
Scribner to
me.
the stand.
Please raise your right hand. You solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Oh, I do. Sorry.
Thank you.
Yeah, remember they were calling
Yeah,
stepdad as a
Still
witness.
show that you're muted. I don't know what you need to
Yeah,
do.
I'm close to Miss Locke's computer, so
Oh, I
I'll try to speak loud enough.
Cindy Scribner, go ahead.
Please state your name for the record.
Cindy Scribner.
And what's your occupation?
I own a couple businesses, Scribner Enterprises and All Service Plumbing.
How long have you owned All Service Plumbing?
I believe we started it around October of 2022.
Are you the only employee of All Service Plumbing?
Employee or owner?
Are you an employee?
I'm not.
Are you just the owner?
Yes, I'm a co-owner.
Do you have any employees?
Yes.
And who is that employee?
Nathan Stevenson, and we've recently hired a new one.
And what sort of work does Mr. Stevenson provide for All Service Plumbing?
Only 3.
Does full service plumbing, much in range of plumbing that our customers have.
And why did you hire him when you started this company?
His experience, his knowledge, his way with customers, those are all things that drew us to ask him to be part of us starting this business.
And as the owner of All Service Plumbing, are you familiar with the property in El Dorado at 602 North Allegheny?
Yes.
How are you familiar with that property?
I know that we did some work there.
Can you tell us about the work that you performed at 602 North Allegheny?
Sure. So we did what I would call a full repipe underneath there due to frozen pipes. I think we may have also installed a hot water heater. Sorry.
Around December of 2022, did you become aware of an issue at 602 North Allegheny?
Yes.
How did you become aware of that issue?
I was speaking with Chad Young, who owns the property. He had come by my house and said that he believed that when his tenants left, they had turned off the furnace. So he and I decided to go over and see if that was truly the case.
And did you
There's
in
a
fact
link in the
go over to the
description.
property?
Yes.
What happened when you got there?
We went inside and found that the furnace was indeed off.
Can you describe what it was like at the property?
Cold. Very cold. Colder inside than it was outside.
Was there anything other than just
What
feeling
about
cold
you?
that gave you some indication that there might be an issue?
Yeah, we could see our breath. And there was also an icicle hanging from the kitchen faucet.
What did you and Mr. Young determine at that point about the property?
We determined at that point that it was likely that there were gonna be frozen pipes. And so, we went and just turned off the water at the main. And so when it unfroze, the water would be shut off to the house.
What occurred next?
Mr. Young left town, and when it got above freezing, Nathan and I went over to assess the situation.
And when you and Nathan got to the house, was that still in December?
I believe so.
And what did you do when you got to 602 North Allegheny?
When we got there, Nathan was by the crawl space. I can't remember if he actually went under the house or if he was just by the crawl space, and I went to the main water meter and I turned it on so that he could see there was indeed leaking under the house.
Okay. And what do you remember about whether or not there was leaking under the house?
He said that there were several pipes broken underneath them.
What did you all do next as far as your work at 602 North Allegheny?
At that point, we moved forward with getting it in the condition that it needed to be for people to move back into it.
And when you say that there was water leaking under the house, was this like one crack, multiple cracks?
I got the impression from Nathan that it was multiple cracks, but once he identified the leaks, he just told me to shut it off, knowing that we were gonna have to go underneath there and do work.
Did you know if any work needed to be completed inside the home?
I don't remember us looking at that time inside the house. So.
As a result of your work on the house, did work needed to be completed inside the home?
Yes, we ended up having to install a new water heater.
In your professional opinion, was that a direct result of this freezing incident?
Yes.
And in your professional opinion, was all of the work done under the house as a result of the freezing incident?
Yes.
Do you believe that any of this would have occurred had the heat been on in the home?
No.
Did Mr. Young tell you that he turned the heat off?
No.
Did Mr. Young tell you to replace the water heater?
He told us to do the work needed to get it back in a functional condition.
And did you have any indication that the water heater wasn't working prior to you coming to the house?
No.
So when you and Mr. Young first went to look at the house because he believed the pipes were frozen, did he say anything about, hey, while you're in there, fix the water heater?
No.
From your professional opinion, was a plumber necessary to do the work completed?
Yes.
Now, you ultimately provided a bill for these services, is that right?
Yes.
And if you saw that bill today, would you recognize it?
Yes.
Can you turn what's been marked as Plaintiff's Exhibit 11 in the notebook in front of you?
Okay.
What is that document?
That is an invoice from our company.
And how do you recognize it?
It has our logo and our address on it.
And in your opinion, is it the true and correct copy of the invoice that was provided for the services completed at 602 North Allegheny?
Yes.
Your Honor, we would move to admit Exhibit 11 and have it shared on the screen.
Objection? Hearing no objection, Exhibit 1 is admitted.
Sorry, Your Honor, Exhibit 11.
Oh, Exhibit 11. Change that number to 11. Thank you.
And does Your Honor have the exhibits in front of her? Does it need to be shared?
If you can share it, that would be fine, but I think I do have those. Let me double check.
Is this the same Exhibit 11 that you were just referring to in the exhibit notebook?
Yes.
And what was the total fee for the services that you provided?
$5,750.
And if we scroll down, what services were provided?
Says here that we installed some new 3/4 inch PEX water lines and some 1/2 inch water lines to a toilet. We eliminated some cracked CPVC, which is a different kind of pipe lines that had cracked due to freezing temperature. We also installed a 40-gallon electric water heater. And it looks like we did some administrative stuff, built a crawl space from a hole that we made bigger, some things like that.
And in your opinion, was all of this work necessary to complete the repair you completed?
Yes.
And do you believe that your pricing was fair?
Yes.
Looking back, would you change any of your charges?
Based on Nathan's response to the complexity of the work, I feel like we could have potentially charged more.
But from your perspective, this was an accurate bill for the services rendered.
Yes.
And the services rendered were a direct result of the pipes freezing.
Yes.
And from your opinion, being there that day in December, what caused the pipes to freeze?
The furnace being turned off.
Since you completed the work at 602 North Allegheny, was your bill paid?
Yes.
And who ultimately paid that bill?
Fieldsburg Properties.
Now, Ms. Scribner, do you also own rental homes?
I do.
About how many houses do you own or manage?
Right now, I currently own between 25 and 30 on any given day. I've managed up to 75 at any time.
What are some of the responsibilities of a landlord in providing water, heat, electric, all of those things to a home?
It's imperative that they make sure that those services are provided.
Does a home have to be habitable?
Yes.
And is one of those habitability requirements running water?
Yes.
Hot water?
Yes.
Had you not made the repairs to this home, would it have had running water when these students returned from Christmas break?
No.
I got it.
Since completing the work at 602 North Allegheny, have you done any other work for any of these defendants here today?
The defendants, no.
Have you done any work for any of their parents?
Yes.
And was that pre or post the work at 602 North Allegheny?
That's post the work.
And did any of their parents complain about the services provided?
No.
Did any of their parents complain about the fees charged?
No.
Nothing further for this witness, Your Honor.
All right, Ms. Kelly, any questions of this witness?
Not at this time, Your Honor.
Okay. Ms. Woodard, any questions?
Yes, Your Honor. Is there any photo evidence to prove that the furnace was turned off at the property at the time?
Any photo evidence? I don't remember taking a picture.
Is there any evidence at all to prove that the furnace was turned off at the property?
Yeah, I believe in opening statement, somebody said that Miss Lentz admitted to turning off the thermostat before leaving.
Miss Lentz, did you admit to?
You're not asking Ms. Lentz questions.
Not how this
You're
works.
asking this witness. You can do whatever you want later for witnesses, but
It was, how can, other than Miss Lentz admitting to the heat being turned off, is there any other way to determine that the furnace was turned off?
Outside of myself and Mr. Young's word, I would assume no.
Nothing further, Your Honor.
Look, there's
Ms.
mom.
Lentz, any questions of this witness?
No, Your Honor.
All right,
Your Honor, brief redirect.
go ahead.
I glanced
Is it
through
your
it.
standard practice to take photos at job sites?
No, on a regular basis, no. There are times that we have to bring insurance claims, things like that.
And this work was not completed for an insurance company?
No.
So did you have any reason to take photos of the damages?
No.
Nothing further for this witness, Your Honor.
Very well. Any other witnesses, Ms. Locke, or other evidence?
Yes, Your Honor. We will call Chad Young to the stand.
All right, please raise your right hand, Mr. Young.
Oh, 1 second, Your Honor.
That's not Mr. Young there in the black shirt?
No.
Oh, okay.
It's kind of hard to prove because you could flip it off,
You
take the
solemnly swear
picture.
the testimony
It's
about
not
the
quite
shall
as-
be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, thank you. Please
solid
proceed,
is some
Ms.
other
Locke.
things.
Thank you, Your Honor. State your name for the record.
Chad Young.
Hold on.
And what's your occupation, Mr. Young?
I own a rental company and I'm also a transportation safety coordinator for a ethanol company,
When you say you own a rental company, what's the name of that company?
Guilford Properties.
Is that the plaintiff in this action here today?
Yes, it is.
And do you own the rental property at 602 North Allegheny?
Yes.
How many other properties do you own in your rental company?
I own one set of properties with 6 residences on them, and then I own 3 other besides that.
And can you describe yourself as a landlord, what type of landlord you are?
You know, I'm a pretty good landlord. Every time I'm asked to do something, we get out as quick as we can do it.
I'm a great landlord.
Especially situations like this that
Is
are
that every slumlord ever?
not managed as quick as time allows us to get them managed. If we have to hire a contractor, then we're at the mercy of whoever we hire to get stuff done.
When you rent a property to someone, do you have someone do an application?
Yes, I do.
Do you have a walkthrough of the property before you agree to rent it to them?
Yes, we do.
And then ultimately, do your tenants sign a lease agreement?
Yes.
At the property at 602 North Allegheny, did you go through these steps?
Yes.
And in our exhibit notebook, exhibit 6, if you don't mind flipping to that. Can you tell us what this document is?
Yes, this is the lease agreement.
Is this a standard lease agreement that you typically use?
Yes, it is.
Is this a lease agreement that you would have used with all of the tenants in this case?
Yes, it is.
What are some of the standard terms of your lease agreement?
Such as what you abide by.
Sure.
Well, that they have to keep the property in good condition, just like it was when they rented it. There's always a deposit. If you have animals, there's a pet deposit. No tobacco or no smoking in the residence. Keeping the yard tidy and just keeping the place up like it should be.
The exhibit 6 that you have in front of you, how do you recognize exhibit 6?
This is one of our standard lease agreements with our name at the top of it.
And who is the particular tenant that this lease was entered into with?
This first one is for Kennedy Kelly.
And is this a true and correct copy of the lease agreement that you entered into with Miss Kelly?
Yes, it is.
Your Honor, we would move to admit exhibit 6.
Exhibit 6 is a lease agreement with defendant Kelly, is that right?
That's correct, Your Honor.
All right, any objection? Hearing none, it is admitted.
And if you look at exhibit 7, what is exhibit 7?
It's another lease agreement with Michaela Woodward on it.
And is that a true and correct copy of the lease agreement that was executed by you and Miss Woodward for the rental of 602 North Allegheny?
Yes, this, my wife actually did the agreement, but yes, it's Guilford Properties.
And does she have the authority to sign on behalf of Guilford Properties?
Yes, she does.
What's your wife's name?
Crystal.
And Your Honor, we would move to admit exhibit 7, which is the same lease agreement, but with Michaela Woodward.
Me too.
Any objection? Hearing none, it is admitted.
And finally,
screwed
Mr.
him.
Young, can you look at exhibit 8?
Yes,
And what is exhibit 8?
it's also a lease agreement, but this one with Sydney Lentz on it.
And how do you recognize it?
It is ours it's our name up at the top of the lease agreement. And this one was taken care of by my daughter, who also does our leases along with my wife, and her name's Tori.
And is this a true and correct copy of the lease agreement entered into with Ms. Lentz?
Yes,
Your Honor, the plaintiffs move to admit exhibit 8.
Exhibit 8, any objection? Hearing no objection, Exhibit 8 is admitted.
And Mr. Young, do exhibit 6, 7, and 8 all have, generally speaking, the same terms?
Yes, they do.
Are the only differences the lines, blanks that are filled in on those documents?
Yes, it is.
Okay.
They owe
Indicating
'em
the specific names of the tenant,
for the damage.
but the terms of the lease are the same.
They're the same.
If the exhibit 6 could be shared,
I mean, after a while, he's gonna be paying more in attorney's fees than if he just,
Or are you sharing that out of your office, or do you need the clerk to do that?
Your Honor, I can share it, or I believe Balin has our exhibits.
I have it.
Okay.
Give me just a second.
Thank you.
and they've had multiple hearings, they've had several motions back and forth. His bill is adding up already.
Mr. Young, on exhibit 6, the first page, can you please read for the court the highlighted portion in the first paragraph?
No, because you have to scroll down so we can see it.
The first highlighted portion says the tenant will pay for any damages to the property caused by the tenant or his or her guests.
And can you please read for the court the highlighted portion on page P14, which is the next page?
Yes, it says the plumbing fixture shall be kept in good condition and any damages caused by fixtures is the responsibility of the tenant. Hoses attached to outside faucets will be removed prior to freezing temperatures. If tenants fail to do so, causing any damage, the tenant will be responsible for the expense of the repairs to return the property to an undamaged state.
And can you read paragraph 13?
Paragraph 13 says each tenant will be responsible for the full rent and lease agreement, either jointly or individually in the case of default.
Can you please read the bold area at the bottom of P14?
Says the violation of any of the conditions of this agreement shall be sufficient cause for eviction from said premises with an immediate notice to vacate by the landlord. The tenant agrees to pay all costs of such actions, including reasonable attorney fees that may be fixed by the court.
Thank you, Mr. Young.
So the one girl was actually onto something when she was talking about fixtures, because I just pulled it up and said, what is a plumbing fixture? And a plumbing fixture is actually just defined, oh God, we're getting into words being hard, as an exchangeable fixture with examples given as bathtubs, bidets, channel drains, drinking fountains, showers, taps, urinals, things like that. So those are the actual fixtures. And that's what this whole thing is talking about, is they maintain the plumbing fixtures. And so he's trying to apply, you know, an orange to the apple bushel. And I mean, he might get away with it, but because they don't have an attorney to fight it.
Is this the same, are these same highlighted portions, paragraph 13 and that bold area, are those consistent in all lease agreements signed by the plaintiffs or the defendants here today?
Yes, they are.
And did you perform a walkthrough of this property?
Prior to them moving in,
Yes.
it would have either been myself or my wife or daughter who would have walked in.
Okay. And did you complete a walkthrough document when you did that walkthrough with them?
Yes, ma'am.
Can you turn to exhibit 9? What is exhibit 9?
It is the move in and out checklist.
And is this the move in and out
They weren't
checklist
moving
that
out.
you did with these 3 defendants?
Yes, it is.
They were returning.
Is it a true and correct
Yes, it is.
copy of what you did? Okay. Your Honor, we would move to admit exhibit 9.
Any objection to Exhibit 9? Hearing no objection, Exhibit 9 is admitted.
And on page 28 of exhibit 9, is there some indication about the dishwasher on this property?
Yes.
You want this screen share?
Sorry, Your Honor.
Lynn, can you put that on screen share?
I've got all the dates. I just don't know the lost date specifically yet.
This was Exhibit 9.
Yes, Your Honor, specifically bait stamp 28.
I meant the temps. I have the temps.
Can you see it or
Words matter.
not?
Not yet.
Oh,
Phelan.
sorry.
That's okay.
Glad you made it. Oh, that's.
And if you scroll to page 28, Mr. Young, what's the indication about the dishwasher in this house?
It says ordering new.
Did you order new during the tenancy of these defendants?
No,
Why not?
when I buy a house, there's a lot of stuff I got to go through to get to what I feel is something I would move into. And one of the things I wanted to do was put a brand new roof on the house. And that's what I did, along with clean the property up when I got it.
Have you since put a dishwasher in the house?
No, I haven't.
Why is that?
There were several reasons. Once the tenants moved out and I paid for this work to be done, that sets you back. I was set back and I had to wait to try to recoup funds in order to proceed with going through stuff.
Thank you. And in your opinion, as a landlord who owns multiple properties, was the dishwasher necessary as part of what you provided these tenants?
No,
Was a hot water heater necessary?
absolutely,
Was running water necessary?
absolutely.
I would beg
And
to
you just
differ in
heard
the dishwasher.
testimony from Ms. Scribner. Do you remember that?
Yes,
And were you present for all of that testimony?
yes,
And do you remember her saying that you and her went to the property in December of 2022?
yes,
Is her depiction of what you saw at the property in December of 2022 accurate?
yes, it is.
How did you come to know that you needed to go check on the property in December?
One of the tenants notified either my wife or my daughter and let us know, and then they told me I needed to go look at it.
And when you say let you all know, what did they let you know?
That the water wasn't working.
And how did the tenant come to know that the water wasn't working?
From what I understand, she went there to either check on things or get something picked up, and the water wasn't working, and she was there.
Okay. And what tenant was that?
I believe it was Sydney.
And did Miss Lenz indicate to you at any time that she had shut the thermostat off?
Yes,
And when you found out that she had shut the thermostat off, what did you do?
I explained to her immediately that's probably what happens, that the pipes had froze.
And then you went forward with contacting Miss Scribner?
Yes.
Why did you choose to utilize that company, All Service Plumbing, to complete the repairs?
It wasn't so much that I chose to utilize just that company. We had called, I think, 2 other companies on top of it, and I wanted to get the first company that could make it out there because they did not have running water. I wanted to make sure it would get fixed.
And ultimately, did you use All Service?
Yes,
Were they able to fix the plumbing issue before your tenants returned from Christmas break?
I'm not exactly sure what the dates were from when they returned and when it exactly got fixed, but they got it repaired. They were the fastest ones that could get it repaired.
Did any of your tenants ever tell you that they were displaced by the not having water?
No, the only times we ever talked about it, I told the tenants, I was like, if you guys got a place to shower or go, that may be good. It just may not be fixed for a minute because they're kind of at the mercy of who's doing it.
And when it was getting fixed, were any of the tenants currently living in the property,
No, they were all gone,
home for Christmas break?
from what I understand, yes.
Did you send a group message to all of the tenants telling them of the issue?
I believe we did.
Can you turn in your exhibit notebook to exhibit 13?
Yes,
What is exhibit 13?
it's a text message.
And can you describe the nature of the text message?
Yes, it's explaining to the tenants what was going on with the plumbing.
Okay,
go to
and what date was the message sent?
community
December
college.
28th.
And who
December
did you send the
28th.
message to?
It was all three people.
All three tenants?
Yes,
And is exhibit 13 a true and correct copy of the message that was sent on December 28th?
yes, it was.
Your Honor, we would move to admit exhibit 13, and if it could be shared.
Any objection to admission? Again, hearing none, exhibit 13 is admitted and may be published.
But are they gonna get that? That's why they had an
Well, then, do
attorney,
you have exhibit 13 by chance?
flimsy.
I do. Give me just a moment. Susie, what page does that start on?
It is on P62.
From what to what?
Thank you. Mr. Young, in this text message, are you telling all of the tenants that you turned because they turned the heat off, that the pipes had frozen?
Yes,
Did you tell them in this message that it wouldn't be fixed until sometime later in the week?
correct.
Did you tell them you wouldn't know for sure how much it would cost until the pipes de-thawed and the amount of damage could be assessed?
Yes,
Did any of the tenants object?
no,
Did any of them respond and say, we didn't shut the heat off?
no,
Did any of them respond and say, we're not going to be responsible for that?
no,
Now, ultimately, did you repair the house?
yes,
And you previously looked at exhibit 11, which was the invoice for the services provided. And that invoice was for $5,750. Is that right?
that's correct.
Did you request the tenants pay that invoice?
Yes, we had talked about it, yes.
And what was their response?
Initially, let's get it fixed and find out how much it's gonna cost and we'll get it taken care of. And then when the price came out of how much it was, it started to kind of turn the other direction.
And when you say turn the other direction, what do you mean?
Then nobody was responsible for it. Nobody wanted to pay it.
Ultimately, did they tell you their parents would pay?
I believe we had a parent even contact us to say, want to know how much it was too.
Okay. Who ended up?
Okay, before we get too far into another subject, I don't know if you guys saw it because she scrolled really fast, but in that text message, it said that the crack occurred at the main water shutoff, main water line, something like that in the main water line. So my question is to you people who live in the north, where's that at on your house? Because I live in Florida, we live in concrete houses. Our houses aren't made of sticks. And that's on the outside of my house. Like if I want to shut the water off to my house, I gotta go walk outside and shut it off. So if that's where the crack was in the pipe, like my heater in my house ain't doing nothing to help that. And they're also talking about pipes in the basement and underneath and underground and all of that. The heat in the house is not affecting that. Like that's where I'm getting a little confused here is why are they attributing this to the thermostat when where it happened seems to be not in the house. It's not like it was the pipe right underneath the floor going to the tub that froze up. I don't know. So you guys tell me where is the main water shut off and all of that at in your northern little stick houses? Gosh, I keep trying to play on the wrong screen.
up paying for the invoice?
There we go.
I paid for it.
Why did you pay for it in full?
I'm a firm believer, you have work rendered to your business, you gotta take care of it. It's a small town and people have to pay their bills. It ain't gonna happen.
And as a landlord, were you required to provide the home with water?
Yes,
Were the repairs that were made necessary to provide a habitable home?
yes, they were.
If the tenants had left the heat on, do you believe the repairs would have been necessary?
No,
If the tenants had left the heat on, would you have had to replace the
Right.
hot water heater?
no.
Would you maybe have had to replace it sometime?
Not any time that I know of that was in the foreseeable future because it was a fairly new one that was in.
So this is the thing. They're saying that if she wouldn't have turned the thermostat off, the pipes wouldn't have froze. But the pipes that froze and cracked were in the basement and wherever. Last time I checked, like, you didn't heat the basement, right? So if that's where it's cracked, it was cracked there because it was cold down there, and the thermostat from the house isn't going to change that. It's not going to heat that, right? Am I missing something? Tell me if I'm missing something here. Gosh, wrong screen. This throws me off. I can't do these live things.
And in your opinion, was what occurred
I
at
love
the
Hubs.
house
Those are
at
the
602
answers.
North Allegheny a direct result of the tenant's actions?
Yes, it was.
And who told you
Right.
that they had turned the
Okay.
thermostat
That's what I
off?
thought.
Sydney told myself,
Is that defendant Lentz?
yes,
And as part of the lease agreement that we previously reviewed, are the tenants all jointly and severally liable for the damages caused to the property?
yes, they are.
Did you try to seek payment for this invoice prior to the tenants leaving the property?
Yes,
And have you incurred legal fees in trying to enforce the lease agreement, which would have required payment for such damages?
yes, I have.
Is your basement finished or like unfinished?
Are you asking the court
like
to
waste.
order a judgment against all three tenants for the full amount of the invoice, the $5,750,
Yes,
That's
plus
surprising.
post-judgment interest on that amount?
yes,
And
Oh,
the
that's different.
costs and attorney's fees associated with prosecuting this claim?
yes.
Nothing further from this witness, Your Honor.
All right, Ms. Lentz, any questions of Mr. Young?
Not all. I know one in New York,
I do not have any
the
questions.
basement wasn't heated. It's always freezing
Ms.
down there.
Kennedy, or Ms. Kelly, any questions?
No, Your Honor.
Ms. Woodward, any questions?
Yes, Your Honor.
All right.
Mr.
Let's go,
Young,
Michaela.
did you acquire a permit for the extensive alleged damage underneath the house?
Mr. Young, you're muted.
Can you hear me now, Judge?
Yes.
Okay, I don't get permits. The contractor would have gotten the permit. If there was one needed, I don't know. I don't.
All right. I have one more question. In our lease, it states that plumbing fixtures are to be kept in good condition. To your knowledge, what would the definition of a fixture be?
Anything that's gonna have the water running through it, such as a faucet, toilet, any of that kind of thing.
So you would agree that it would be the faucets, anything that we would have control of, such as faucets, hose, things like that?
The whole interior, yeah, that it's gonna be anything without water goes through. That's
Okay,
my
so
opinion.
the damage that was done to
one
the
then.
house was the infrastructure of the pipes that was underneath the house. And in our lease, it only states that we are responsible for fixtures. Is that correct?
It's stated in there, and I might have to reread it. I don't have it memorized. It's stated in there that any damages caused to the property by the tenant or anybody that they have, his or her guest. So
You have to prove they caused it.
would fall underneath that as well as the responsibility of the tenant to keep the stuff up the way it's supposed to.
Yes,
Nothing
I've
further.
heard
Your
that
Honor.
too.
Any redirect, Ms. Locke?
Just briefly, Your Honor, Mr. Young, looking at Exhibit 6, which we previously looked at, can you read us the highlighted portion in the first
Again?
paragraph of Exhibit 6? Exhibit 6,
yeah.
page 13.
It says the tenant will pay for any damages to the property caused by the tenant or his or her guest.
And in your opinion, was the damage that was incurred a result of
Objection,
the
Your Honor.
tenant's
It's not qualified to answer this
negligence or
question.
willful shutting off of the heat?
Yes.
No further questions for this witness, Your Honor.
Any other questions just limited to what was just asked? Okay. Hearing none, then do you have another witness or any further evidence, Ms. Locke?
No, Your Honor.
All right, it sounds like the plaintiff rests. Ms. Lentz, have you any evidence you want to present?
Okay, I said in between these, I would show you guys the weather. Stop sharing this screen. Share this screen. Okay, so this is December 2022. So we're going to presume that it was one of these 2 weeks. And if you look, during the day on the 22nd, it got down to -4, but at night, so I believe -4 was the high during the day, and at night it got down to +30. Is that? I didn't really think about that. So what is this? Is this the highs or the minimum and maximum? Let's just click on it and see what it says. Okay, there we go. So at night it was 16 degrees. In the morning it was -2. During the day it was -2. So this was by far the coldest day. All of these days from the 22nd to the 26th were below freezing. However, none of them were -32 degrees, as was testified to. So, yeah, I'm going to say, negative temperatures can cause pipes to freeze. So they did say -30. They absolutely said -30, and we're nowhere near -30. Like, we got to -4 and a -6. And I even checked January too, just, to be sure. And at the start, like, maybe sometimes you don't come back right away, and it's even warmer. I mean, we're up in the 40s. So it definitely wasn't that. So back to 2022, December. Do you guys see what you wanted to see on here? So we're in the low teens and single digits right around Christmas, and then it starts to get up into the 30s. So it would be like right at Christmas is when it would happen. And we are going to stop sharing that. We are going to go back to this. No. This.
I would like to say, Your Honor, that
Okay,
I
if you're
only.
gonna testify, please raise your right hand. Your right hand, please. The other one.
Sorry, so sorry.
You solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
How would they know that? How would they know they're
Please tell us your
uninsulated?
full name.
Sydney Lentz.
Okay, and where are you from, Miss Lentz?
I'm from Wichita, Kansas.
Do you live in Wichita?
I do not previously. At the moment right now, I do not.
Okay, Miss Locke, do you have her address if it's needed?
As long as it's the same address on the answer that she provided, I do believe we have her address.
Okay, because I don't want her to say it live here, but okay. So is your address the same as what you have on your answer?
Yes, Your Honor.
Okay. All right, and what would you like to testify to today?
I would just like to make a statement saying that to my knowledge, that I only turn off the AC.
Anything else you want to say?
No, not at the moment.
Are those
All
separate?
right. Ms. Locke, any cross-examination?
Just briefly, Your Honor, Ms. Lentz, the air conditioning system and the heating system are controlled by the same thermostat, correct?
I believe so.
And when you turned off the air conditioning, you would have turned off on the thermostat, is that correct?
I honestly do not know. This is my first time owning or being in a house by myself, and I didn't have any idea on how the thermostat works or what to do or anything like that. So my knowledge was only that I turned off the AC.
And when you turned off the AC, did the screen on the thermostat go blank?
Not to my knowledge, no.
In December of 2022, there would have been no reason to have the air conditioning on, correct?
Correct, because it was freezing outside.
No further questions for this witness, Your Honor.
All right. Ms. Lentz, do you have any other evidence?
I do not, Your Honor.
All right. Ms. Kelly, do you have any evidence you want to present, including your own testimony? You don't have to, but you can if you want.
I would like to ask,
Oh, you wanted to ask a question of Ms.
oh,
Lentz?
no, ma'am, I was gonna ask to you.
Oh, okay. What's your question?
Am I able to call a witness now, or will that come later?
You
The
can,
one
this is what I'm asking you to do if you want, is now is your time.
Yes,
So-
ma'am, I would like to call a witness.
All right, and who do you want to call?
Ryan Sherpy.
All right, is that the gentleman there on the front of the screen?
Yes, Your Honor.
All right, Mr. Sherpy, please raise your right hand.
Your Honor, we would object to this witness. It's not clear that he ever went to the property or what the relevance of his testimony will be.
He looked at the
Let's
5
see.
pictures.
Talked about him at the last hearing. Was he approved as a witness at the last hearing? I don't recall.
He was tentatively approved without an understanding of what he would speak to. We objected to him being called as any sort of expert witness. And I'm not clear on what relevance his testimony would be other than as an expert in the field of plumbing or home repair.
Do you have any purpose for calling him as, other than as an expert witness, Ms. Kelly?
He was, yes, ma'am, he was approved as an expert witness during our last meeting.
Well, I don't recall that. What were the qualifications you offered?
His job title, or his
Oh,
business and his job,
thank you so much.
and his work with areas such as this industry experience.
Did he
And
ever?
Your Honor,
Go ahead, Ms.
Your Honor, if you'll remember back to our pretrial conference, Ms. Kelly did not respond to any discovery,
middle.
did not provide a witness list, did not provide an expert report, did not provide any documentation demonstrating what this individual's qualifications are or what he would testify here to today.
And as their stepdad. I mean,
As
You
I
need me to
recall, is
pull
he
up
the
my
father of
screen?
one of the defendants?
He is my stepfather, Your Honor.
I'll go ahead and allow a little bit of leeway on this.
Thank you, Your Honor.
Please raise your right hand. Do you solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Go ahead and ask your questions, Ms. Keller.
In your,
Well, let's establish his name and what his qualifications are to see if he has any standing to testify further.
Yes, ma'am. Ryan
No,
Sherpy.
she needs to ask you questions. You're her witness.
what is your
name, first of all?
what is your name?
My name is Ryan Sherpy.
And
Ryan Sherpy.
and how are you an expert witness in this case?
I've been in general contracting, construction, commercial plumbing superintendent for over 20 years.
And are you familiar with situations like this, such as
I am,
plumbing and freezing pipes?
especially in North Texas in the last, was it 2 years ago? We had a big freeze down here with lots of pipes bursting. I've done plumbing in North Dakota, Colorado, throughout the islands and the Virgin Islands.
And
Your Honor, I'm going to renew my objection that this witness won't be able to provide any relevant testimony. He just said that he's a plumbing contractor in Texas, the Virgin Islands, Colorado. To our knowledge, he's never been to the property. He's never been in the crawl space. He could have nothing relevant to provide the court today other than his opinion about what happens in Texas when it freezes.
Sir, did you ever examine this property that we're talking about?
Not that property, ma'am, only through the photos that I examined.
Photos only? Where'd
Yes,
you
ma'am.
get your photos?
They sent us 4 photos that we requested photos to prove that work was done. We received 4 photos, only one of a broken pipe, and the rest was just a stack of pipes, and then some funny plumbing that happened on the back porch, it looked like. But we weren't gonna pay anything until we saw the actual damage.
All right, well, hang on.
Yes, ma'am.
So you never went to the site. You've never worked with Kansas plumbing in winter, but
Ma'am, North Dakota is a little worse than Kansas. Colorado, the same way. There's a lot of relevance there. Freezing is freezing, no matter what state it's in. And I know Kansas Plumbing Code abides by the International Plumbing Code.
it sounds like he probably has the qualifications, but the problem is if he hasn't been to the actual site and examined the actual damage, I don't believe there's any.
Ma'am, I work with property management companies, over 500 homes that we take care of throughout the area.
But
I operate in what they require normally from us.
okay, but you agree, you didn't go out and look at this property or this damage?
No, ma'am. Only through requested pictures, which were not provided.
Which is
And
common.
yet you're prepared to give what you would call an expert opinion as to what caused the damage to these pipes that you never saw.
Just according to the one picture I saw of the frozen pipe, I would testify that it was, if you have a frozen pipe system, for one, the hot water tank should have a backflow preventer via Kansas law. And if that didn't happen, then there should be no reason, as long as the electricity was in place, that the hot water tank would have frozen over or needed to be replaced.
But you didn't go out to the site, so you don't have any firsthand knowledge of whether what you just said was required was in place or not.
No, ma'am, but
All right. I'm
I
going,
do know there was
I'm
no
going to,
permit pulled, because I called the city inspector and he said no
all
permit.
right, now you're getting into hearsay and
That's not, okay, yes, ma'am.
so I'm going to disallow this line of questioning. I'm going to find that it's not relevant unless you have some other purpose for calling him.
Right information, wrong way to get it in.
But I don't see how the testimony of this gentleman could be relevant when he never saw the
I have
condition.
property management experience, ma'am.
And that's going to help how?
I know as a contractor for property management companies that I would have to provide tons of photos to prove that these issues existed in order for payment to be made. I would never be able to get away with 4 photos of just random photos of one broke pipe and say that
Exactly.
you needed to pay me almost $6,000 for this work. That would never
All
happen.
right, Ms. Kelly, go ahead with your line of questioning, Ms. Kelly. Let's go
Oh.
ahead. Again, I question the relevance, but I'll take that into consideration as we go along. Go ahead.
Thank you, Your Honor. Going back to the permit, to your knowledge, and in El Dorado, it is required.
Now, I am not going to allow out-of-court statements by people that aren't here for cross-examination. So I'm not going to let your hearsay in. We're not going to talk about what this person or that person might say. It's going to be strictly on his firsthand knowledge. So let's keep those
yes.
rules in mind.
Yes, Your Honor. Can I have some clarification?
Anything that somebody else said for him to make his opinion, I'm not going to let in unless that person is going to testify. Because I think I know where this is going based on what he said a while ago. He wants to talk about what a city manager or city administrator, somebody said. We're not going down that inadmissible hearsay.
Yes, Your Honor. I was just trying to say that.
Don't just ask your questions. Don't testify. If you want to testify, you're welcome to, but not during his testimony.
She's scared.
Yes, ma'am.
Mhm.
Sorry, let me pull up my questions.
Yeah.
I would like to ask for his opinion on the situation as it pertains to the plumbing.
Well,
Your Honor,
go ahead.
Your
Ms.
Honor,
Booth.
I apologize, but before we start, it appears there's someone in the background of Mr. Sherpy's space that
She's
may
been
be
there the whole
messaging
time.
the defendant or sharing questions with the defendant. We would object to any of
Mom's
that.
doing it again.
Are you talking about the blonde-haired lady that is the mother of one of these young ladies?
Yes, Your Honor.
Okay, we had that problem at the last hearing, ma'am. If you're not an attorney representing them, you can't represent them. You cannot tell them what to say. You cannot tell them what to ask. I heard you telling Mr. Sherpy what to say a while ago. You know, don't be sending them text messages or anything like that. Now that's not going to happen.
I'll excuse myself.
That's a
Why
good
even
idea.
sit in the camera view?
Now, don't just go leave the room and circumvent what I said.
Yes, ma'am, she will not. You hear that, Kelly?
Yes.
Okay.
Is
Yes, ma'am.
Kelly your wife, Mr. Sherpy?
Yes, ma'am.
All right, now. I'm gonna find you in contempt if I find she's sending you, and I might get her for for practicing law without a license. She can't be your lawyer today.
Yes, Your Honor.
All right, go ahead.
I was just going to ask about his opinion on the situation pertaining to the plumbing.
Well, you need to have a foundation that he has something to base that on. If he
Have
didn't see it, if he didn't see it, how can he give me an opinion that counts?
Yes, Your Honor.
Did you look review the photos?
I apologize.
It's all right, just take your time.
Did you just let Michaela do it?
Not something you do every day.
I appreciate it.
It's like when you're standing in front of the class for the presentation that you've practiced 1,000 times and just like go blank.
I apologize. I cannot think of any further questions at this time. Retaining to his credibility, I believe.
Credentials?
Credentials that has not already previously been stated by him. And
Well, I don't remember if we got those on the record or not, but okay, but we know that he's done a lot of plumbing.
yes, ma'am.
Okay.
Um,
And we know he didn't actually go into the apartment and check it out. Okay. But
so, yes, ma'am. Continue. I apologize.
oh, you go ahead. So whatever else you want to try to cover with him.
In your previous experience
that
working
screen.
with plumbing or getting work
I have my
done,
pedal dog.
how many pictures are required to show that the work was done, completed, and the damage was significant?
Currently, the people I do work for require at least 20 photos.
Thank you. And if those photos were not taken or given, how would the person paying respond in your experience?
They would not pay me without proof of photos or receipts of material, everything else. They would refuse to pay that due to lack of proof. I mean, if there's no proof, then they're not going to pay me for the work. I could say that I fixed something all day long and never fix it.
Thank you. No further questions, Your Honor. Thank you, Ryan.
Yes.
Ms. Locke, cross-examination.
Thank you, Your Honor. You don't work for Diltor Properties.
Not for Diltor, no ma'am.
You don't work for All Service Plumbing.
No ma'am.
You don't work in Kansas.
Not currently.
You don't have,
Joint liability.
you're not currently
Joint and
managing any
several
properties in Kansas.
No ma'am.
And you didn't inspect the work completed on this house.
Not on that house, no ma'am.
And when Miss Kelly moved back into the house after Christmas break, the water ran.
I'm not aware of either way. I'm not sure, ma'am. I assume it did.
And that she never reported to you that the water was cold.
Not to me personally.
And prior to her leaving the house in December, did she tell you the water wasn't working?
Not that I know of, no ma'am.
And she didn't tell you that the water was cold.
No ma'am.
And when there is a freezing event, pipes may crack and leak, correct?
They may crack and leak when not properly insulated.
And no further questions for this witness.
Miss.
She almost stepped in it.
Ms. Kelly, do you have any other witnesses that you want to call?
No, Your Honor.
Okay, you don't wish to testify yourself either?
Um,
I'm not suggesting either way. I just want to make sure that I understand what your choice is.
yes, ma'am. I do not wish to testify.
And you don't have any other evidence you want to present?
No, Your Honor.
Okay, all right. And Ms. Woodward, how about you? Do you have any evidence you want to present?
No, Your Honor, just my testimony.
Okay, please raise your right hands. You solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, and say your name for the record and where you're from.
Michaela Woodward. I am from Saskatchewan, Canada.
Okay, and you're one of the defendants in this case?
Yes, ma'am.
All right, so what would you like to testify to?
I just want to reiterate the weather that was caused in Kansas at this time. There was a article done by the Wichita Winter Squall that this was record-breaking weather in El Dorado at this time. This was unheard of. It has never gotten that cold before. Pipes were freezing in multiple residences, regardless of the temperature that was set by the thermostat in the house. There were power outages. Like, who is to say that the power didn't go out in the property? We have nothing to prove that the power did go out, didn't go out. There is no proof to show that a thermostat was turned off. There is no evidence to show that a thermostat was touched at all. So I just want to reiterate that cold weather was the main cause of this damage, and we do not claim responsibility for that. This was an act of God. Something else I want to touch on is the lease agreement about the fixtures versus the infrastructure of the piping. We, as tenants, as stated in our lease, we are responsible for the fixtures of the house. That is the faucets, the taps, the hoses. We did everything that was stated in our lease to prepare for cold weather protocol. We were not aware of how cold it was going to get, and our landlords had not reached out to us at all about how cold it may get. It is good practice to reach out to your tenants. If I was a property manager, that's what I would do. And I'm sure lots of others would reach out to their tenants to notify them that cold weather is coming. Make sure you do A, B, and C. That was not done for us. As to my knowledge, they did not go to the property to check on the property as we were gone. They were aware that we were leaving for Christmas break, and nothing was done to mitigate these processes.
from the statements of the witnesses and Mr. Young, all the repairs
Really? Why do they have to delete them? It's just trying to get a drink of water. Okay, give me 1 second. Thank God I downloaded it. Downloaded it in a format, but it's not going to let me play. All right, so I have to play it and share that screen. Are you serious? It seriously didn't download? Guys, talk amongst yourselves for a minute. Give me a minute before I panic. Didn't download on this computer. Wow. Oh, whew. Today the 28th? Hot damn, got it on this computer. Okay. Give me a second, copy it over. And then we can watch the end, because, hey, we're almost there, right? Nothing like shutting it off right before the end. She was doing really good. Now I got to figure out where we were at, because they delete their streams like the second they are done. It drives me crazy. Like, what if somebody's 5 minutes behind watching it? You're not even going to give them a chance? I guess you got to speed it up or something. Okay, so I think Michaela was testifying. You don't want it on my massive monitor. So let's share screen, window, media player, share. Oh, hold on. I don't know if I hit the audio button. I'm tired. Share screen, share with audio, share. Okay, now where were we at? We had left. She was talking. Where's the audio? Oh, let's turn audio on. Further back? No, let me go. Dad, I heard that. Don't do that. Hey. Sorry. You don't have audio? You don't have audio now, or you didn't have audio before? You have volume now? Is it just delayed? You're like crackheads. Come on. Do you have no audio? Judge Webster wasn't talking. Okay, hold on. Their lips are moving, but no sound. Okay, here. We'll try this. I don't know how loud it's going to be, but is that screen 2? No, screen 3 here. Can you hear him now?
And Mr. Young, we do not claim responsibility for that. This was an act of God. Michaela Woodward, I am from Saskatchewan, Canada.
Okay. I can't. Okay, he's gone. We need the act of God quote.
We do not claim responsibility for that. This was an act of God.
There we go.
Something else I want to
I
touch
get there
on
eventually.
is the lease agreement about the fixtures versus the infrastructure of the piping. We, as tenants, as stated in our lease, we are responsible for the fixtures of the house. That is the faucets, the taps, the hoses. We did everything that was stated in our lease to prepare for cold weather protocol. We were not aware of how cold it was going to get, and our landlords had not reached out to us at all about how cold it may get. It is good practice to reach out to your tenants. If I was a property manager, that's what I would do. And I'm sure lots of others would reach out to their tenants to notify them that cold weather is coming. Make sure you do A, B, and C. That was not done for us. As to my knowledge, they did not go to the property to check on the property as we were gone. They were aware that we were leaving for Christmas break, and nothing was done to mitigate these processes. From the statements of the witnesses and Mr. Young, all the repairs that were done on the house was the infrastructure. That's all the piping underneath the house, as stated in our lease. That is not our responsibility. Our responsibility is the fixtures, not the infrastructure. And all the repairs was done underneath as infrastructure. And also, I keep hearing mentions of the crawl space and the temperature of the crawl space, that there is no venting to the crawl space. There is no way for heat to get to that crawl space. Therefore, the result of the temperatures inside the house does not correspond to the temperatures of the crawl space underneath the house. And yeah, that is all I have, Your Honor.
Cross-examination, Ms. Locke.
Thank you, Your Honor. Ms. Woodward, you've never been in the crawl space, correct?
No, I have not, Your Honor. Oh, sorry, Ms. Locke.
That's okay.
My apologies.
And you haven't lived in multiple other residences in Kansas, correct?
Not in Kansas, no.
And when you left, the power was on, correct?
It was on.
When you returned, the power was on.
Yes, it was.
And you were not the last to leave.
No.
And you were not the first to return.
No.
And you reviewed the message where Mr. Young said that the pipes had frozen, correct?
Are you referring to the group message that was shared?
Yes.
Yes, I saw it.
And at that time, you didn't state that you left the power on.
I did not state anything, no.
And you heard Miss Lentz say that she shut the air conditioner off, correct?
The only time I had heard is when you were questioning her today, yes.
And she stated she shut the air conditioner off.
To the best of her knowledge, she doesn't seem like she really knew, but yes.
And being in Canada, you understand that, being from Canada, that if the heat is shut off to a home in the winter, that can be very dangerous for the infrastructure of the home. Is that right?
It could potentially cause some freezing.
And you agree that your lease agreement states that the tenant will pay for any damages to the property caused by the tenant or his or her guests, right?
Yes.
No further questions for this witness, Your Honor.
All right, do you have any other evidence, Ms. Woodward?
No, Your Honor.
All right, I believe I've heard all of the testimony, received all of the evidence. At this time, I do find that the defendants did turn off the heat and cause the pipes to break, and would therefore be jointly and severally liable to the plaintiff in the principal amount of $5,750 plus interest and court costs and attorney's fees, as well as other fees. The plaintiff will be responsible for drafting a journal entry. Now, I would point out to the defendants, you have up to 14 days to file a notice of appeal to the Kansas Court of Appeal if you wish. Ms. Locke, is there anything further that I need to, from the defendant's or the plaintiff's standpoint?
Your Honor, if the defendants could just acknowledge by shaking their head that I can email a copy of the journal entry to them for their approval.
Okay, Ms. Kelly says yes. Ms. Lentz, yes. Ms. Woodward says yes. Okay.
Nothing further from the plaintiffs, Your Honor.
All right, anything further from any of the defendants at this time? If not, we are in recess. You are all excused. And I think, Belen, that concludes this docket.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Wow. Wow, wow, wow. That never would have. Okay, stop replying to people who say they can't hear. They're behind on the stream and they're replying to what we talked about like 10 minutes ago. That never would have flown in anything other than small claims court. They had no evidence. It's just, I honestly think if the mom hadn't, my personal opinion is that if the mom hadn't got involved in the very beginning, and soured some people's opinions, that this wouldn't have been an issue. I really think that. I think that they would have, if they would have looked like innocent young college girls, the case would have gone one way. But the fact that you have mom in there, you know, trying to control everything, I think took it in another direction. And as much as Michaela was a freaking rock star, I think that negativity overshadowed it. I really do. Yeah, I don't agree with it at all. But I also don't think that they had any knowledge of the law at all. So I don't think, oh my gosh, people, stop saying you can hear when you're 10 minutes behind in the video. Ah! Somebody said the hurricane shifted. My mom texted me, but I couldn't pull it up and see what was going on. So anyways, that was our interlude. I will try and cut that out and make it its own video.
Case of the people versus Susanna Williams.
I'm supposed to be.
Caitlin Kirby on behalf of people.
Ron Brown appearing on behalf of Suzanne Williams. Good morning.
Good morning.
Your Honor, we're trying to resolve this case. There's an offer to plead to an added count to a retail fraud in the 3rd degree. And count 1 would be dismissed. I know you don't do COBs or sentencing agreements, but I believe her jail credit is 93 days on this offense. So she would be seeking a credit for time served sentence with release. I believe the donuts that she stole and ate would be the basis for the restitution if the court were to order.
So there is restitution.
Yes, Your Honor.
Donuts. Okay, I didn't mean to say it like that.
What's the restitution, sir?
Right? You got to pay for the donuts you ate.
Oh, okay.
If the judge orders that.
So do we know the amount of restitution?
I'm just double checking, Your Honor.
They weren't Dunkin' Donuts.
I believe that I do.
They were packaged donuts.
Okay, thank you.
Dunkin' are fancy. You know, you can get the ones with the sprinkles.
You want to know what?
And the nuts.
You know.
And the powdered sugar.
No, you know what?
They weren't those.
No, Mr. Brown.
They were just,
When they told me you were going to be here, I almost stayed home.
For me,
Judge Simpson.
they weren't the powdered sugar ones.
Okay.
Okay.
We'll see. We'll see how much they cost.
I like donuts. I should have brought you some. They go good with your coffee.
$4.68.
Those are some pretty good donuts.
They weren't that good. Were they stale?
Yeah, I think so.
They were a little stale.
$4.68.
Yes, Your Honor.
See, I was shopping and forgot to shh. Okay.
They got everything down.
So she wishes to take advantage of the offer.
You want?
Yes, yes, Your Honor.
Yeah, have her sworn, please.
Raise your right hand. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
State your name.
Susanna Williams.
All right, ma'am. It is this court's understanding that you are going to be pleading guilty to the charge of retail fraud 3rd degree. That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that?
Yes, Your Honor.
All right. And understanding that, you still wish to plead guilty
Yes, sir.
to that charge? How do you plead?
I plead guilty, Judge Simpson.
All right. You understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
All right. Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that?
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
What is that?
If you don't like the sentence or you change your mind, then you got to get permission from a higher court.
Yes, Your Honor.
All right. Are you on probation or parole?
No, I'm not.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead guilty?
No, Your Honor.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily and of your own free will?
Yes, I am.
And because you believe that you are indeed guilty?
Yes, Your Honor.
On December 21st, 2022, at the location of 7,000 East Michigan Avenue, Pittsfield Township, Washtenaw County, that being the Walmart, what do you do on that date that makes you think that you're guilty?
I ate some donuts in the store premises.
Okay, so you went into the store and you ate these donuts and didn't pay for them?
Yes, Your Honor.
All right. Store was open to the public at the time?
Yes.
These donuts that you ate, this was property that was offered for sale by Walmart?
Yes, Your Honor.
And you didn't have anybody's permission to eat those donuts, did you?
No, sir.
All right, counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Anything either of you'd like to say before the court imposes sentence?
I'm sorry about that, Your Honor. I'm making better choices now. I had a chance to do the bond farms in jail program, so it gave me a chance to look at what's important in my life, and I've been sober for 3.5 years now. I just want to thank you again for giving me the time to be in here and to start my life again. Thank you.
Mr. Brown, you see April 23rd. She did. That was him, 93. You've been in since the time of the arraignment, is that correct?
For 93 days, yes, Your Honor.
She was arrested on April 24th, 2023, and then she was remanded from our court for 365 days to February 2nd, 2024.
And I'm gonna take that up next after you do the sentence.
Yeah.
The sentence that she was remanded on, I want to address that with your permission and your grace this morning.
Calls the case, People versus Susanna Williams, last year.
I believe.
Rita Rasinski on behalf of the people.
Councilman Basie on behalf of Susanna Williams.
Ms. Williams, can you state your name, please?
Susanna Williams.
Thank you. What are we doing on this?
Yes, Your Honor. Today is the date and time set for pretrial. We have been trying to get a video on this case to no avail, so we would just be setting for a bench trial at this time.
Ms. Williams, your counsel's indicated you're waiving your right to a trial by jury.
Yes.
All right, you understand you have an absolute and constitutional right to have the matter tried before a jury.
Yes.
You understand that by waiving that, this case will be tried before the court without a jury present. You understand that?
Yes, Your Honor.
All right, people also waive their right?
Yes, Your Honor.
Based upon the statement of counsel and defendant, court will consent to have the matter tried without a jury. Non-jury trial will be set for July 26, 2023, 9 a.m. That is in person. Okay, thank you.
Your Honor.
Bond continue.
Your Honor, may I
Yes,
discuss bond when appropriate?
go ahead.
Yes, Your Honor. Ms. Williams wanted me to let you know that she has completed Don Farms treatment. She just wants to get her life back on track here. So if we could get her a PR bond, Your Honor, so that she can get back to her life.
Is anything else holding her right now?
No,
It's
not that I'm aware of.
just your case, if I could be released after the Don Farms, which I have completed.
There was a sentencing that she had on another case,
Okay.
and she tells me that she had an agreement with you where if she completed Don Farms, she may be eligible for early release.
On that case?
Yes.
Did I sentence you to jail on that other case?
Yes, I've been incarcerated for 74 days plus 56, so that would be 120 some days on that case.
Okay, and I think I recall this. I think she was sentenced to, I think, did I give you a year or 180
Yes.
days? I gave,
A year on my first
Yeah.
violation, but I did complete treatment at Sacred Heart. So one of the violations I pled to it, but I didn't think I should have because I completed.
so,
it, and then
hold
I
on a moment.
done farms.
So here's what I'm gonna do. I don't have a problem setting this for a PR, but what has to get before me is the other case.
Yes.
So, in order to get that release done. So I think what really should happen in this case is that I'm gonna leave the bond as is. Send me a request for her early release with an order on the other matter, along with a request contained within that this be then lowered to a PR.
Okay, very good. We can do that.
So that getting her time on this one, even in the interim where it has to get to the court. We'll get to the same point. It's just that I gotta have the other case to do it.
Okay, Your Honor, I sent something over to Patrick concerning the early release after Don Farm. And he sent it back saying the court didn't indicate that you could be. So should I send him another kite asking to send the information to you?
Yes, because I don't even have that case in front of me, ma'am, right now. So
Okay.
I don't know what I wrote in there, but I seem to recall what you're saying.
Yes, okay.
Okay.
Thank you so much, Your
All
Honor.
right. Thank you.
Have a great day. Thank you.
You too.
I'll come see you again, Susanna.
Okay, have a great day.
Court calls the case.
Yes, though.
I'm gonna ask him, hold it. But you gotta write out.
Excuse me.
Sentence of the court, fines and costs of $250. I can pay that 30 days after your release. I'll order 93 days on this case, 93 days Washington County Jail, credit 93 served. I will also order restitution in the amount of $4.68 payable through the court to Walmart.
Your Honor, as a prosecutor, thank you for your grace this morning. As the prosecutor mentioned, she's under remand right now, doing a year in jail with an out date in February of 2024. I wasn't the lawyer present when you handed down that sentence, but I'm informed that it was a case from 2016 where she violated the terms of She violated once the terms of her probation and she was remanded. I don't have that case number before me right now, but when you sentenced her to the year in jail, you said upon completion of the Dawn Farm program in jail, you would consider releasing her on that 1 year sentence. And she's asking me now, very eloquently, she's reminded me about 4 times, if you would consider an early release, because I'm producing a certificate of completion from the Dawn Farm.
Okay, the normal way that's going to go about is that if that is sent to probation and we have proof of that to probation, then probation will make sure that it gets on my docket for consideration of the early release.
When's your next docket? Today? At
I've
1
sent it
o'clock, you
over.
got a docket, right? I'll walk down to probation and give it to him right now if you want. Because you got a docket this afternoon too. But I didn't want him to take her back and she's gonna blow up my phone, Judge. She's gonna blow up my phone.
I sent it through Patrick and I never got a response back because who was-
Mr. Noctree,
who was here on July 5th when I had my adjournment, he said that he was supposed to get everything together and he never did. But Mr. Brown has been working hard to
I'm a great
upside
lawyer,
down.
right? Oh, it's upside
To,
down. Am I a good lawyer?
Yes, you are.
She was
Yes, you are.
mad at me yesterday when I went to see her at the jail.
I was just upset because I thought I was going to be released on the 5th and I had completed this on June 20th. So, but
And she's gone through a series of lawyers, but I'm the best one, right?
you are. Yes, sir. Oh, he's going to make me go home.
So can we see her at 1 if I walk this down to probation?
Please.
She said, please.
I heard, hey, Mr. Brown.
Yes, sir.
9:39.
Huh?
My docket started at 9. I got out here about 9:15. And somehow you have, in 2 cases, managed to entirely try to disrupt everything. In 1 case. So here's what we're going to do.
Yes, sir.
What I indicated is, and this is how it usually happens. Mr. Noctree would get something to Miss Polera. You can take that down, and if they create a form, I don't even need to see her if I'm going to do the release.
Okay, so I'll be right back.
No, no, you can be, you're more than welcome back. But that's how that would happen.
So I've done everything I can. I'm gonna walk this down when we get
You're
done.
just gonna take it to probation?
Right now.
Okay, so do I have to write anything or do a kite? Because I've already done that and they didn't send me anything back. They said that they sent it over to you. I'm sorry, I'm anxious because I've been here
Really?
93
I can't
days.
tell. Tell Ms. Polera if she would then contact Mr. Noctree
Okay.
and see
Okay.
what can happen. That doesn't mean that it will happen today, young lady.
Okay,
All right?
I understand.
That is the way that the process works.
All right, thank you so
Despite
much.
Mr. Brown's efforts, I'm not changing what I normally do.
Okay,
All
I
right?
understand. Thank you so much. Have a wonderful day.
So I'm gonna go take this to her right now. So don't call me.
Have a beautiful day, Justin.
You do the same. We have sent the necessary advice.
When a friend asks you to drive their sports car cross country, check the trunk. That's all I'm saying.
All right, good afternoon. This is first appearances. We only have a couple. We have one that's in custody and one that's out of custody. We're gonna start with Lee Lang. I think we should have an interpreter. And I apologize. Is this Vietnamese or what is the interpreting language?
I was told it's Mandarin.
Mandarin, okay.
Hello.
Hi, Kathy. How are you?
This is Kathy.
Okay.
Good, thank you.
Are you the Mandarin interpreter?
Yes.
Have you had any chance to speak with Liang or Li Liang before now to make sure that you're communicating well?
No, I haven't. I have just notified I have this assignment earlier this morning.
Okay. Do
so
you
I
want to
have-
go to, we can put you in a private room with him and let you confer a little bit so that you can represent to the court that you believe, you're an appropriate interpreter for him.
Yes.
Okay, let's do that to make sure that we're all on the same page.
Okay,
So
thank you.
let's put you in a breakout room and we'll go ahead and take up Jeremy Brown's case. Okay, did you have any trouble communicating with Liang Lai? You're muted. You need to turn on your, there you go.
Is it? Okay.
Yep. Did you have any trouble?
No, no problem. I just told him who I am and just confirmed the language wise is all good.
Okay. Well, I'm not going to swear you in because we're not going to take testimony from anybody. Possession of marijuana with intent to distribute in the state of Kansas. They're alleging that he had 63 pounds of marijuana, that's why it's a distribution or intent to distribute case. And it is a level 2 drug felony in the state of Kansas.
So, you know me and my curious mind. What does 63 pounds of marijuana look like? So I Googled it. You'd be surprised how many people get caught with 63 pounds of marijuana. Interestingly, in 2017, it was worth 3 times what it's worth in this clip.
Okay. I don't see him, so I just talk.
Yes, you would have to
okay.
go to the
Yes,
screen.
I can see him now.
Okay, yeah.
李良，李良，你听到我吗？李良，你听到我说话吗？
可以听到。
刚才法官说，这法庭，说你拥有，持有，鸦片，然后还有，所以当时持有63磅，所以给你的罪名是持有并。
我可以说话吗？
He's asking, can he talk?
No, I'm just here. I'm not asking him whether he agrees with the charges or not. I'm just here to advise him of what he's been charged with by the state and what the penalties are if he's convicted. I'm going to enter a not guilty plea for him. I don't want him to say anything that might incriminate himself. I'm not asking him whether or not he agrees with the charge, but I have to advise him of what he is charged with at this point.
好的。
Okay, so it's
okay.
alleged in count 1 that on or about the 25th day of July 2023, he had in his possession or under his control more than 450 grams, but less than 30 kilograms of marijuana.
Excuse me, you said more than 30 kilograms?
No, more than 450 grams, but less than 30 kilograms.
Kilograms.
If convicted of a level two drug charge, the sentencing range is 92 months up to 144 months with the Kansas Department of Corrections, depending on his criminal history, and up to $500,000 fine.
500,000.
He's also charged in count 2 with not having any drug tax stamps.
Y'all, what is going on in the state of Kansas? So it's okay. You want to be a drug dealer, you know, that's still illegal and all. And marijuana is still illegal. But you got to pay taxes on your illegal shit. What? Are you serious? You have to pay taxes on your illegal drugs, whether you plan to consume them yourself or distribute them to others. Otherwise, you get a separate charge, and they can even take your personal property to satisfy whatever debts you may owe. Apparently, this law was passed back in '87, and it applies to the possession and or distribution of marijuana and controlled substances. And the rate for marijuana is $3.50 per gram. Wow. Other controlled substances sold by dosage units rather than weight for 10 doses. It says the tax rate is $2,000 per 50 doses. So I don't know what the 10 doses, the threshold is 10 doses. My mind is blown. So we're going to tax drug dealers. It's an anonymous program, so, you know, you won't get caught for the illegal drugs you're dealing that you're buying stamps for. What?
Okay.
I'm going to enter a not guilty plea for him.
Okay. Okay.
This case is assigned to me, Judge Satterfield. I'm going to appoint Jim Watts to represent him, but he may hire an attorney of his own choosing if he desires. And he goes to the jail on Wednesdays usually. So I want the jail to make sure they let him know, and we need to let him know that Jim Watts is there, and he's gonna need an interpreter and a Mandarin interpreter, and he can hopefully make a special appointment to get together with him before our next hearing. I'm going to set this for preliminary hearing, evidentiary, on Wednesday, September 6th at 9 a.m.
September 6th and 9 a.m.
Yes, we will need an interpreter. So the court will get a hold of you for that.
Okay. Excuse me, can I ask a question?
Yes.
You said he's going to jail on Wednesday. Is this the same Wednesday, September 6th?
No, I was telling the jail that I want them to make sure that if Mr. Watts shows up today, that they let him know that he has Mr. Langley as a client, so he can start getting prepared for that, because he'll need to have a interpreter to visit with him. So the sooner he knows about this case, the better. So that you don't have to tell him that. I was talking to the jail, not him.
Okay.
So he is set for an evidentiary preliminary hearing on Wednesday, September 6th at 9 a.m. and he will have an attorney.
Okay.
So, Mr. Sweeney, I'm talking to you. You may need to contact KVI, hopefully given the quantity and amount. They can maybe expedite their testing for this hearing, or you're going to have to decide how you're going to handle it. I know it's a fairly quick turnaround, but given the fact that he needs an interpreter and he may remain in custody, I want to go ahead and get this set for an evidentiary hearing. I need to ask Mr. Langley some questions so that I can set a bond. Will you ask him, please, where he's from? Where was he born?
He says, I was born in China, but I have been living in Ohio, US for 5 years. And over there, I'm doing conducting the business of transportation. Okay.
So is he here on a work visa?
李良，那么你在这儿是工作签证吗？
我是在这边是，就是我的爱人，他申请的是就是政治庇护，正在申请绿卡。我第一次来美国是作为读PhD 过来的，然后是在俄亥俄州立大学读的 PhD， 是在2013年。
My wife is applying for a green card right now, and my first visit, very first time I came to US, I was going to Ohio University to obtain PhD degree. That was 2013.
Okay. All right. I'm setting his bond at $250,000 cash or surety, and he's not to leave the country.
好，法官给你设的这个赎金是25万美金，然后你不可以离开美国国境。
Mr. Sweeney, do you have anything to add to that?
No, Your Honor.
Does Mr. Langley or Langley?
Yeah.
李良，Yeah，
Yes.
Leon, okay. Does he have any questions?
你有没有什么问题？He says, for this case, I wasn't intended to do anything, and also because it's my first time arrested, I plead judge to can you reduce this amount because this amount is way too high for my ability. I have two children. The older one is 9 years old, and the younger girl is only 5, and she just had a surgery. So I plead to be granted with a lower bond amount, so I can quickly go home to take care of my daughter.
Okay, hold on just a minute. I'm gonna look at the probable cause affidavit that the officer should have submitted with this case. But tell him the reason the bond is so high is because of the amount. It creates a presumption of distribution irrespective of what he believed his intent was under the law. It's a large amount, so it's a presumptive prison case. It's a high level offense, and it is presumed that he possessed with the intent to distribute based on the amount. Now that's a rebuttable presumption, but given that and the fact he has no ties to this community, is from another state and is not a citizen, so he's a national of China, I need to set a high bond given all of those reasons. But I'm going to take a quick recess and get a copy of the probable cause affidavit and review that because I want to determine if there were any other passengers and the surrounding circumstances. So if you could let him know that, I'm going to grab the affidavit. I'll be right back.
Yes, Your Honor. Li Liang.
All right, it looks like he was the sole occupant and the driver of the vehicle in which the black garbage bags or the trash bags were found in the back of the 2016 Porsche. So there are no other individuals involved, at least at the time of the stop in this case. I need to move the hearing from 9 a.m. on September the 2nd or September the 6th from 9 a.m. to 1 p.m. So his hearing date is still Wednesday, September the 6th, but it is at 1 p.m. instead of 9 a.m. Would you let him know that, please? Give me just a minute here. I'm checking on something. Let him know that his court-appointed attorney contacted us and he had a conflict at 9 a.m., which is why it was moved to 1.
Yes, I heard the time change. I still have a few questions.
All right. What are they?
你讲吧。I have a few questions. The first of my questions, my occupation, my business is international transportation, and I have a fleet of vehicles, and you can you can check on the vehicles I have, and my vehicle number is DOT 3626666. Your Honor, I have no idea of this this car I was driving had these marijuana at the back. I was just helping my friend to drive this car from Oklahoma City to Kansas.
Okay. He'll need to talk to his attorney about that. The officer smelled a strong, very strong odor of raw marijuana emitting from the car. And the approximate street value of that marijuana was in excess of $60,000. So this is a very serious case, and he'll need to talk to his attorney about that between now and his court date. I've set a bond and I've given him a court date, and the rest of his questions he'll have to discuss with his attorney, okay?
Your Honor, if I may explain that for my 36 years old life, I have never consumed marijuana or any drugs. So I have no idea that smell in the car was marijuana.
I don't want to hear anymore, because I don't want him to say anything that might incriminate himself. He's presumed innocent. I entered a not guilty plea for him. Now he needs to talk to his attorney. I've looked at the probable cause affidavit and determined there was probable cause for his arrest. The next step is a preliminary hearing, and the court will take up any matters that his attorney presents at that time. I've set a bond based on the level of offense, based on the fact that he may enter and return to China without extradition. He has no ties to our state or our community. It was a large quantity of drugs in the vehicle. And so that is what my job is to do: give him a court date, give him an attorney, make sure there's probable cause for the arrest, and set a bond. And that's what I've done. All right, we are adjourned. Thank you, Kathy.
So this is another grandma custody of an exceptional child case, but this one's a little different. Grandma has custody because mom passed away as a result of an interaction with a specific medication. The child has quite a few medical issues and was placed in a group home. Now, I know many of you are probably going to judge grandma for doing that, but I can tell you from experience that children with a lot of these issues, once they get a little bit older, especially boys, get stronger and become a lot to handle. And when they have so many medical needs, it's too much for one person to handle. And the structure and the socialization and the scheduling of a group home is about the only way that they can survive and actually thrive. The problem here is the group home is making decisions and not consulting grandma, and put the child on the medication that the mother had the reaction to and died from. And so grandma is going to court trying to get some kind of order to make sure that she's consulted on these medical decisions.
So we're here today on an emergency motion that was filed by Ms. January. I am presently, because this is an emergency, I'm hearing this from Caldwell County while I'm here at the courthouse here in Caldwell, but we are live streaming in compliance with the Open Courts Act. So with that being said, Ms. Guadano, if you'll start announcements of the attorneys for us, please.
Melissa Cuadrado for the Department of Family and Protective Services.
Ms. January.
Yes, Judge Stacy January on behalf of Ms. Alyssa Martin, who's the Joint Managing Conservator with the department.
Okay, Mr. Schulte.
Daniel Schultze, attorney ad litem for the child.
Okay, the court does note that we have with us representatives from Belong, as well as Anthony's mother, Miss Martin, who is participating with us by video today. So Miss January, this is your motion that was filed asking for an emergency hearing. So if you'll tell me what it is that you and your client are seeking today, please.
Judge, I believe you're aware of the facts of the case. Miss Martin is the PMC of Anthony because her daughter passed away when Anthony was very young. Anthony has been placed in an RTC facility, and the department through Belong, I believe, has attempted to work with Miss Martin. However, the facility, it's beyond. I don't know. I'll let you hear the evidence, but there were court orders that my client was joint managing. My client wanted to be involved in specialist appointments. This child has many specialists to include. He has rheumatoid arthritis issues, mental health issues, psychotropic medication issues. Repeatedly, they wouldn't acknowledge her. They wouldn't let her join in on the meetings or the doctor's appointments. Most recently, her biggest concern was Anthony had a psychological, in that psychological, it revealed that he had no family to provide the psychologist with any history of the family, which is 100% not true. Miss Martin would have been more than willing to participate in that. It appears that they put the child on Depakote without her permission. She learned just today that the child was put on Depakote back in March. Her daughter had a severe toxicity reaction to that, and ultimately, within months, her daughter had passed away.
So Depakote was actually one of the first generic medications in the anti-epileptic class of drugs. It's used to treat seizures, but it's also used as well to treat the manic symptoms of bipolar disorder. However, it is known to have serious side effects that affect the liver that can be fatal in certain instances. There's lots of precautions you can take. You just have to make sure your healthcare provider is aware of your medical history. So it's kind of a problem if grandma was not consulted or brought in to provide the medical history of the child before he was prescribed this medication.
So that is very, very concerning for my client. And now Anthony today is in a psychiatric hospital due to some suicidal ideation. So I just felt the need to bring this to the court. My client's very upset and concerned, and she wanted to be here to testify, Judge.
Okay, so Ms. January, is there any specific relief that you and your client are requesting today?
I just think 100% she needs to be included in the medical and the doctor's appointments. And when this child is put on different psychotropic medications at his young age, while she understands he is special needs and he does need the treatment, and she's not, trying to push back against that. It's just the complete lack of allowing her to participate in anything, which the information could be instrumental in getting the child the help that he needs. And despite our multiple attempts to have weekly updates with the facility, somehow they can't manage to do that. I do believe the department's looking for another placement now. We did learn that recently. But it's just, I don't know how we can force them to comply and to make her part of the treatment team. But, with that Depakote, it was just very alarming. And that's why I felt the need to bring it to the court's attention.
Okay, and in reviewing my notes from our last hearing, we were last here on April 20th, and at that time I had ordered that Ms. Martin was authorized to participate in medical and psychiatric or psychological appointments for Anthony. So it was my expectation that she should be able to participate. Also, as a joint managed conservator, even if she does not have the ultimate authority to consent to medication, she still needs to be involved in the process. So, Ms. Quadrado, tell me what it is that the department knows at this point, and if there's anything that you're requesting of the court today.
Judge, it's my understanding from my client that there have been some attempts to include Miss Martin, and it just hasn't worked out. Either she has been working or there was no service. And I'm not at all suggesting that that's been the case in all possible times, but I do know that that has happened at least once. I also know from my client that Anthony has actually been on Depakote since he was placed at the facility. This wasn't a new medication that was prescribed to him recently. And that information has been included in paperwork that has been provided to Miss Martin throughout this case. I also do know from my client that it is looking at alternative placements and may have found one, but that there may be an issue with that placement being able to accept Anthony because of his because of a diagnosis of autism, despite the fact that it hasn't that any that those kinds of behaviors have not been observed in Anthony recently. That facility did tell Belong that that because of that diagnosis, they may not be able to accept him. And we are just here to see what the court can do, to see what the court can order. But Belong has made every effort to attempt to include Miss Martin in meetings and updates and so on.
Okay, so Ms. Quadrado, who would be a representative from Belong that you think would have the most information on this case? Looks like Ms. Pollux is volunteering herself. So Ms. Pollux, if you'll raise your right hand for me, please. Thank you. You swear the testimony you're going to provide in this case is the truth, the whole truth, and nothing but the truth.
I do.
Okay, Ms. Pollux, since this is, I call this as an emergency hearing, I understand that, Belong and everyone else didn't have that much preparation time, just basically one day or a little bit more than a day. So I'm going to kind of let you tell me in a narrative fashion, just how Anthony's doing and what your interaction has been. And then if, the attorneys, I'll have given opportunity to ask you questions too. So you'll go ahead and start, Ms. Pollux. Thank you.
Yes. So I was actually supposed to go visit with Anthony on Tuesday. And they notified me while I was on my way that he was struggling at school. The school had notified them that he was having some issues. He had made a threat to tie his shoelaces around his neck and eat 2 items I think he assumed he was allergic to. Not sure the relevance with that, but so they did feel a concern that he needed to be assessed. I chose not to visit him that day because he's only met me once. I didn't want to add more stress to the situation, meeting new people for children with autism that can sometimes be a stressor. So I chose not to visit that day. I did stay in contact with the placement to try and figure out what we could do to get him into a psych hospital or get him assessed at least. I have throughout the process had to be the middle person between placement and the grandmother. The placement has made it clear to me that when they accepted him, they didn't realize he was JMC. And they, from their words, not mine, did not like the approach that grandma has made. Again, I've tried to be the middle person and facilitate, both parties and getting Anthony the best care that he needs. It's been very challenging. The schedules haven't matched up. Either they give me an appointment and it's after the appointment's already occurred, so I can't provide that information to grandma. I've asked them to contact grandma directly, and that hasn't really happened so much. Again, I think there's a difference in personalities and they're struggling with that. As Miss Quadrado mentioned, we have identified a couple placements. We've been searching for a little bit because we knew this was an issue. There's one placement that contacted me today, Hill Country Youth Ranch, which is in region. They told me they would have accepted him already. They do have a little bit of concerns about his functioning in terms of autism, so they want to ask more questions, but they're not ruling him out just yet. I have presented this to grandma. She was open to that when I spoke to her. And they have assured me that they'll, include her in as much of the process as it's possible. Unfortunately, I can't do anything until he's released from the hospital, but she and I have been trying to work together with the hospital to try and at least talk to Anthony. I have requested hospital workers so they can go in and see him as soon as possible, but it's overarching a lack of communication. And I think part of that is dealing with him being out of region and me not seeing him all the time. The courtesy worker is trying to help me, the LPS worker is trying to help me get more information, but again, it's a battle to get things ahead of time, I would say. So that's kind of where we're at right now.
Okay, thank you, Ms. Paul.
Sorry.
Go ahead.
I was just gonna say there are 2 other placements that we're reviewing him, but I haven't heard much from them yet, but it's more than just this placement.
Okay, so Ms. January, do you have any questions for Ms. Pollux?
Judge, I believe I'll save time and call my client, and if I need to redirect things with Ms. Pollux, I'll do that. But I think I'm good right now.
Okay, Ms. Quadrado, any questions you'd like to ask Ms. Pollux?
Miss Pollux, do you believe that you've done everything in your power to try and facilitate Miss Martin's participation in Anthony's treatment?
I feel that I have. Yes, ma'am.
And
Okay, Mr. Schulte, any questions of the witness?
Just one. So who ultimately has the medical consent power for Anthony B to put on psychotropic medications?
So with all of our kiddos who are in, and I want to make a correction earlier, he's in a GRO, he's not in an RTC. For all of our kiddos that are in that type of placement, it is myself and my supervisor that are listed. So I should be included.
Okay, so that should authorize the medication then?
No, I wasn't included in the appointment.
Who authorized it then?
The placement. He had he had a psychiatric medication management appointment, and he has those monthly. And I've been working with the courtesy worker, the LPS worker, to try and get her and myself at least in those appointments if we can't get grandma on a 3-way call. I have not been notified of any appointments prior to the appointment. I've notified after, but not prior.
Thank you. No further questions.
Judge, you're muted.
You're muted.
Thank you. So there was a statement that Anthony has been on Depakote for a while now. Ms. Pollux, can you kind of tell me what the timeline for his medication has been?
He has been on Depakote since his first appointment when he was placed at this placement in March. I think it was March 22nd that he was prescribed it. I was not aware of the family history relating to Depakote, so that didn't raise a red flag for me personally, because a lot of our kiddos are frankly on that medication. It wasn't until Miss Martin notified me, I think it was earlier this week, it may have been late last week, that was a concern for her.
And Ms. Pollux, what kind of notice are you getting about Anthony's, doctor's appointments and all those things? I mean, are you not learning about them until after they've occurred either?
Yes, Judge.
Okay. Ms. Quadrado, any other questions for Ms. Pollux?
No, Judge.
So, Ms. Cordado, any other witnesses you wish to call?
No, I don't have any other further witnesses, Judge.
Okay. Ms. January, any witnesses you wish to call today?
Yes, Judge, I'd like to call Miss Martin.
Okay, Ms. Martin, good afternoon. If you'll raise your right hand for me, please, so I can give you an oath. You swear the testimony you're going to provide in this case is the truth, the whole truth, and nothing but the truth.
I do.
Okay, go ahead, Ms. January.
Yes, Miss Martin, would you please state your name for the record?
Elisa Rochelle Martin.
Okay, I'm going to ask some specific questions here at the beginning. So, briefly, when Anthony came into the department's care, was he on psychotropic medications?
Yes.
Okay.
Yes.
And did those medications include Depakote?
No.
Okay. Did the medications he was on require blood level checks?
No, ma'am, not the ones when he went into care.
Okay. And could you just let the court know how many specialists he had at the time he came into the department's care?
Just the two, psychiatry and pediatric rheumatology. And then, well, and also ophthalmology, because he has to have his eyes checked more frequently than the normal population.
Okay, so
So
let's start with the little bit less complex one. Were you included in the rheumatology appointment?
No, and I had probably been working. I have always made it very clear to the home that the doctor's office could call me. As a matter of fact, the rheumatology, I told them, I said, could you please have the nurse or doctor call me so that I can give them some history or so that I can answer questions. And I remember texting during the appointment, are you there? Are you there? Are you going to call me? With no reply.
Okay. And to your knowledge, did Anthony have that rheumatology appointment?
Yes, yes. And Brianna sent me a paper, but it was only what they filled out for the department, whatever that form is. I don't have like a full visit note. All I know is that they continued his Enbrel. I don't know anything about his blood work. If the doctor thought he was getting better, getting worse.
Okay.
Or
And
anything.
so, as far as the big issue with the psychiatric needs, now let me back up. What medications was Anthony on when he came into care, if you remember the psychotropic meds?
Yes, ma'am. So he was on Concerta for his ADHD. He was on clonidine, which is normally a blood pressure medicine. However, its off-label usage can be for sleep and for mood control. He was on Trileptal, which is a seizure medicine, but off-label usage is for mood control. Risperidone and as needed Atarax. And then he also took melatonin.
Okay. And you recognize that Anthony needed help when he came into care, right?
Oh, yes, ma'am. Yes,
Okay.
ma'am.
And so to your knowledge, what, if any, of the medication that he was on is he currently on? Did the medication get changed without your knowledge?
Yes. When I received the psychologist report, I noticed that there were different medications. I noticed that the Trileptal was not on there, and instead Depakote was there. And also he is on something called desmopressin, which is supposed to treat enuresis, which is bedwetting or wetting himself.
Okay.
He is still on the other medicines.
Now, had the facility or the doctor treating him have notified you of the Depakote, would you have consented or raised an alarm as to the Depakote?
I would have definitely have had a conversation with the doctor and let him know about my daughter's history. And just to clarify, I'm grandmother. I'm not mother. My daughter, Anthony's mother, passed away some time ago. And right before her passing away, she had been on this medication. She didn't directly die from that medication, but she had had a psychotic episode requiring hospitalization. And she just went downhill from there and ultimately took her own life. And also, and let me just let the court know, I'm a registered nurse also. And I don't know if he's had blood levels drawn. Depicted, or also known as valproic acid, normally requires blood levels to maintain a therapeutic level. And then this incident happened at the school. But anyway, when I saw that psychologist report, that was the first time I had been told, and I had made it clear to the group home that I wanted to be included in the psychiatrist appointments if I could, but that they needed to give me notice. I cannot just walk away from a patient's bedside. Okay. If I have notice, I can make arrangements. I have told Ebony that. I have it in text messages.
Okay,
I don't know.
Let me just back up just quickly to
Yes,
the
ma'am.
so now may or may not be because of the DEP code, but in your reviewing the psychological, did you find information in there that made you feel that Anthony had regressed, such as the pull-ups and things? Could you briefly just tell the court about that?
When I read the psychological report, the psychologist indicated that he had defecated on himself during the assessment. And it also stated that he wears pull-ups full time. I don't know if that is true. I did talk with a worker at the home the other day. They said, no, he doesn't wear pull-ups all the time, just at bedtime, which he had at my house at bedtime. But
And so now that Anthony is in the psychiatric or hospitalized for concerning behaviors and statements, is that why you wanted, one of the reasons why you wanted me to bring this to the court's attention about your need to be notified?
Yes, and you know, about the medications, I mean, it was my understanding, being joint managing conservator, that I had equal footing in decision making. So if I misunderstood that, I apologize. But I have continually tried to find out information. I've tried to be as nice about it as I can. I don't just show up to that group home. I go and see him, you know, once a month. I try to find out, and my messages just go unanswered. And so I go through Bree. She has sent me information, and even Bree has told me that it has been difficult for her to get information. So I'm highly concerned that there's this lack of cooperation. And I will be honest, I was pretty incensed when I read the psychological report that they wrote. Give history. There is a very strong history here, and he's going down the same path. And
as your daughter, is that what you mean? As your daughter, and that's what concerns you?
Yes,
okay.
ma'am. Yes,
and
ma'am.
Just to backtrack a little bit, now it hasn't been Belong or Miss Pollux that's been the communication breakdown. It's been through the facility for the most part.
For the most part, I kind of think maybe all around, but Miss Pollock had indicated to me that even she has trouble getting information from them. And also the facility, or I keep saying facility, the home, Ebony has indicated to me that, you know, they only have to tell me what they're required to. And I said, well, I'm JMC, so all I asked for was just a weekly update, maybe FaceTime once a week so that I can see him, so that he knows he's not been abandoned, or that, because Anthony constantly worries that something's going to happen to me. I would sneeze and he thought I was going to die. Like, he would ask me, "Are you okay? Are you okay? Are you going to die?" That is a valid fear of his. So I'm just trying to maintain contact so that he knows I'm still here. Ebony at the center had told, I believe, Ms. Pollock, and possibly me at one time, that it was impossible to do weekly updates.
Okay.
I don't, yeah.
So you are in agreement for the department to look for additional placements,
Oh,
perhaps?
absolutely.
Okay.
Yes, ma'am.
All right.
Yes.
Okay. I'll go ahead and pass the witness, Judge. Pass the witness. Thank you.
Ms. Furtado.
I don't have any questions for this witness, Judge.
Mr. Schulte.
No questions either.
Okay, Ms. January, any other witnesses?
No, Judge, that I believe that's what I needed the court to be aware.
Okay, so Ms. Pollux, if you can tell me, is the department looking for a new placement? I mean, are you looking because we seem to have problems with this one, or are we looking because we think there's potentially a better fit for him somewhere else?
We've been actually and the reason why I requested placement was for a placement that would be willing to work with grandma. Hopefully in region, because that is much better in terms of my communication with the placement. I can just go and show up if I'm not getting what I need. So that's what I had requested. And like I said, we have 3 places currently looking at him. Specifically, Hill Country Youth Ranch is very interested.
Okay, so obviously it's a lot more complicated than I think it is. To me, it's just communication. It shouldn't be that complicated. Ms. Martin, the department does have the authority to consent to things for Anthony, but that's after consultation with you. And part of the problem is it's very hard for you to have meaningful input in this case if you're not provided with the information. I don't think it's that complicated, but to hear that Ms. Pollux is having issues at Belong, just tells me that there's a reason to move him. We need to move Anthony. I'm going to order that he be moved, but the department has to locate that place first. Like, this doesn't have to happen today. It doesn't even have to happen tomorrow, but we need to be moving him to a facility that will meet his needs after he's released from his current hospitalization, and that will work with all the parties in this case. Ms. Martin, I'll just tell you, some placements unfortunately just do not understand the concept of having a joint managing conservator. They just assume that the department makes all the decisions, that the parents are just, or the conservators are just somewhere in the background, and that's not the point of this case. The point of the case is to return, Anthony, or be able to return Anthony to your home. So I'm in order that Anthony be moved. There needs to be clear understanding with the placement that Ms. Martin is entitled to information, both his medical information and just generally how he's doing. Obviously, whether it's, Hill Country Youth Ranch or another facility, I don't believe that they schedule, a psychiatric appointment and then they just show up like a day later. Like, that doesn't happen. I mean, these things are scheduled far in advance. There's no reason why they can't give notice to the department and, ultimately to Ms. Martin. Ms. Martin, I think it's okay that you get all your information from, Ms. Pollux or someone else from Belong, but they have to be provided with the information. And I will say it's not acceptable if Belong's not getting the information. If you don't know how your child's doing in that placement, that's a reason to call licensing.
May I have a quick question? So he's in the hospital and they call for consent to give medications. Should they be calling me or should they be calling Brianna or Miss Pollux for that?
They should be calling the department.
Okay.
But Ms. Martin, I will tell you, hold on a minute. I mean, listen,
Yes, ma'am.
I understand that you're a nurse, and I
Yeah.
want you to be involved in the information. Okay. But there has to be a person ultimately who is the person to consent. Like there has to be that person. And I believe my prior orders in the case are that the department had the authority to consent in this case.
Okay, that's what I was asking. Yes, sir. Yeah.
But Ms. Martin, I understand that, you know, this is a very frustrating thing for you. And I'm personally frustrated because I don't think there's any reason why you shouldn't know about any psychological appointments, psychologists, psychiatrists, rheumatology, anywhere he's going. Like those are appointments that are generally, you know, scheduled out several weeks. And so there's no reason you shouldn't be able to get notice of those. I am going to order, because it seems like there's been such a large change in his medication, I am going to order a medication review in this case. You know, one of the issues is now that he's, you know, in a hospitalized setting, I'm going to say that he's potentially on, I call them crisis medication. You know, there's meds for the hospitalization, but most likely he will not leave with those medications. So I think we need to find out based upon what he's been on in the past, and that's all information Ms. Martin has that she can share. What has worked for him in the past, what has not worked for him, and then obviously what ultimately what he should be on at this point. So Ms. Pollux, I am going to tell you that Belong is responsible for providing Ms. Martin with this information. So you need to get all the appointment information. If there's a calendar or however, you know, the placements keep this so that you personally are responsible for passing this information on to Ms. Martin. Additionally, I don't know, Ms. Pollux, if you're getting copies of all the medical records, but if you do have those need to be shared with Ms. Martin so that she can read them. Ms. Martin's in a position that a lot of our, you know, caregivers and parents are not in. Not only can she read them, but she can actually understand to a greater extent than probably some of us. So please make sure that she gets copies of the medical records. Ms. January, is there anything else that you think I should consider ordering today? Okay, Mr. Schulte, are you with us?
I'm here.
Okay. Anything else you think the court should consider ordering today?
No, Judge. Hopefully we can get the change in placement. We'll correct a bunch of these errors. Just for my information, so if he's moved to Hill Country, the placement there, where exactly is that located at?
That's in the Kerrville area, I think. Okay. Ms. Pollux, is that right?
Yes, it's in Ingram.
In Ingram, okay.
All right, thank you.
And I have had several children at Hill Country Youth Ranch. That's and they've done. You know, I don't have complaints about that facility for other children. And as I understand, we'll say Anthony's profile, right? I would say that they've done a fairly good work with other children with a similar type profile. Obviously, every child has their own facts and needs, but I will say that we've had some pretty good resolutions to our cases after children have been there for periods of time. All right, so Ms. January, I think we lost you or you froze at some point. I have ordered that Anthony's placement be changed, but that's not an emergency. So when he's released and the department has a new location, then hopefully they can get him to that placement out of his current one.
Yes, Judge, and perhaps we can get with the department to see if blood level draws for the depicted has been done, and maybe but I don't know. I'll work with Belong in the department so we can work with that.
Okay, and I've also ordered a medication review for him.
Okay, yes, sir.
Okay, Ms. Cudato, any questions about the court's orders today or anything else you'd like me to consider?
Just that I understand you're ordering a change in placement and you're putting no time frame on that change of placement. Is that correct?
Well, I want him moved, but if I say it has to be done by, Monday and Hill Country Youth Ranch hasn't, accepted him, then I don't want him put in some place that nobody wants him at. I mean, I
Okay.
want him to go to the place that everybody wants him to go, whether that's one day from now or a week from now.
Okay.
I
And
don't, go ahead.
excuse me, sorry. And then, would you like the medication review to be done within a certain amount of time?
Yes, we'll say the medication review needs to be done within 21 days.
Okay.
Can I say something real quick?
Yes,
Typically,
ma'am.
oh, I'm sorry. Typically, after a hospitalization, they will have a pretty quick psychiatric appointment, usually within 2 weeks. I know when he was in the hospital here before, they would see them pretty quickly so that they can do things, like that.
Okay, so Ms. Martin, let me explain the medication review to you. That is something that's available under his Medicaid, and something that I can order from the bench as a judge. And so it's a slightly different process because I'll bring in a third party person from Medicaid to look at what he's had in the past, what he's on now, and make sure that it's an appropriate thing. This is not somebody that will examine Anthony. This is kind of a paper read, like an administrative review of what's going on at this point. So this is something that's available to us under Star Health, his Medicaid provider.
Thank you for explaining. Okay.
Okay. Again, thank you everybody for making yourselves available today on such short notice. I don't normally order emergency hearings on 1 day notice, but I did think it was important based upon some of the accusations and allegations in the motion that we get this thing heard quickly. So I hope everyone enjoys the rest of your evening, and I'm going to excuse you at this time.
Thank you, Judge. Thank you.
Thank
What's that?
I can't do September.
Why?
I have family that comes in around that time, and we do a lot of. We're never around the house at all with the kids because it's right at whenever they're at school, we're visiting, and when they're not at school, we're out in one of the lakes here in Kansas visiting, and that's just the month of September for our family. That's an every year occurrence.
This is in the District Court of Butler County, Kansas, case entitled State of Kansas versus Mark Anthony Carter. It's case number 2023 CR 194. Mark Carter appears on his own Zoom, apparently still representing himself pursuant to a previous announcement that he wanted to self-represent. Amber Norris appears for the state. This matter comes before the court at this time for evidentiary preliminary hearing. I trust the state's ready to proceed, Ms. Norris?
Yes, Your Honor.
All right. Mr. Carter, you're ready to proceed?
Yes, I do want to reserve all of my rights at this moment as well, and I do request that the court excuse the witnesses in this case to be only to only come into the call whenever they're being called to testify, and not to be able to hear the proceedings themselves.
All right. I understand, Mr. Carter. Ms. Norris, who will your first witness be?
Your Honor, I think I'll start with Kim Bishop.
All right. Mandy, if you could put all of the other witness participants in a waiting room until it's their time to testify.
Thank you.
And Your Honor, just I think kind of housekeeping matter. We do not yet have a signed waiver of counsel, which normally we get for purposes of providing discovery to those that decide to remain pro se.
Counsel, he waived orally on the record.
Okay.
Your record should be complete that he has waived the assistance of legal counsel, and he made it quite clear that he wanted to represent himself at a prior proceeding in this case. So,
And Your Honor, I do have notes to the effect that he did a waiver.
I've been muted for some reason. I can't hear anything anybody's saying.
but you may want to turn up your volume, Mr. Carter.
No, it's back on now. It came back on now. I haven't touched anything or anything.
Go ahead and complete your sentence.
I couldn't hear anything that y'all were discussing there.
All right.
It was my audio was muted towards me from your direction.
All right, Ms. Norris.
Your Honor, we have not provided discovery to the defendant. We were waiting on, well, we generally get a signed waiver. And I do know that he did say that he wanted to self-represent. So I just wanted to make it clear that we had not received a signed waiver, and that we also had not sent discovery. And I'm not quite sure how we're going to accomplish that with the defendant, but I just wanted the court to be aware of where we're at.
Very well. All right, Ms. Bishop, you'll need to join with both audio and video at this time.
Okay.
You can take your hand down. Okay. All right, Ms. Bishop, I'm going to administer an oath to you at this time. If you'd raise your right hand, please.
Okay.
You do solemnly swear that the testimony you're about to give in the matter now in hearing shall be the truth, the whole truth, and nothing but the truth. So help you God.
Yes, sir.
Ms. Norris, you may question the witness.
Thank you, Your Honor. Please state your name for the record.
Kimberly Lynn Bishop.
And Ms. Bishop, what is your, or I guess what was your employment status December 2021 to basically April of this year?
With Total Installation, co-owner.
Okay. And did you have something else to say?
We're split. With me and my husband are split. I'm 51%, he's 49%.
Okay.
So,
and where is your business located?
right now we're running it out of our house in Andover, Kansas.
Okay. And in December of 2021, did you have more than one property that the business basically operated out of?
We have our storing stuff, and we still are storing stuff at 13th and Andover Road, and also at our home, which is Kellogg at Andover Road approximately.
Okay. And those two locations that you just mentioned are within the city of Andover and within Butler County?
Yes.
Okay. And your co-owner, what is Total Installation?
We're a business that started in 1995, doing commercial interiors. Is a shortened sum it up. We did or do commercial flooring, commercial carpet cleaning, and a Division 10, which is like architectural accessories. And there's one more. Oh, office furniture installation, which is how we started it back in 95. So
Okay.
kind of those four areas.
All right. And are you familiar with Mark Carter?
Yes.
And the person that you identify and that you're familiar with as Mark Carter, do you see that person on the screen today?
Yes.
And can you explain the backgrounds, colors, that sort of thing, of Mr. Carter?
Can I describe
the background, what
relationship?
color of shirt he's wearing, that sort of thing?
Okay. His background is white wall, and he has a turquoise colored shirt on.
Okay. And does he have facial hair or no?
Yes.
Okay. And I would ask that the record reflect that the witnesses identified the defendant, Mark Carter.
The record so reflects.
And why are you familiar with the defendant?
He was an employee of ours.
From when to when?
He started officially, I think it was January of 2020 and through December, like November, December 2021.
And what was the reason he's no longer an employee?
There's a lot to it, but basically he ended up stealing a lot of our property that was product. He stole a bunch of our equipment and also a bunch of tools.
And did you report the theft to law enforcement?
Yes, he had asked to borrow our 20-foot box truck, probably late October, early November of 2021. And he did not return the box truck when we needed it, and he just abandoned it, and we had to go find it. And so we had damage to that also. And that was December 1st, I think, was when we recovered the box truck. And that we went to and we filed a police report probably the next day or the day after that, if I had to get all the information gathered, but I think it was the very next day.
Okay, so December of 2021, you made a theft report for the box truck and other items, or at that point, was it the truck or not?
We had the truck back, but we reported that he had taken it and not returned it. It would not return it. That was documented, but we had the truck when we filed the report. We just knew he had our equipment, and that was the main thing, was we wanted our equipment back. Oops.
And in December of 2021, you recall which item or which piece of equipment that was missing that you knew of specifically that you reported?
It was I think we made a list of the biggest 6 that we knew were gone, including gosh, I'm gonna have to see if I get these right.
And if your husband Tim is actually better suited for the equipment questions, yeah,
that's
you
probably
can certainly let me know that.
That's probably a good idea. Although I know it was a shot blasting machine that was, when we purchased it, was close to $60,000. It was another one we call it the National, is a floor scraping machine. It was our big equipment that we use for work. That's and any other questions, if I think of, I can answer. But yeah, Tim can go over the equipment probably better than, more knowledgeable about it than I am.
Okay. And so you make the report to law enforcement, and that's back in December of 2021. At that point, is there much else that happens for a while?
No, and I didn't know what to expect after we filed the police report. We were at the time still like neck deep in a lawsuit down in Oklahoma with a contractor that we had. It's been part of our lives since 2016 is when it was filed.
Objection.
What's the objection, Mr. Gordon?
Relevance.
Well, I'm wondering what the relevance is too, Ms. Norris. If we could just focus on the theft items involved in count 1.
Your Honor, I don't know, because she just started talking about it. So without, I guess, maybe letting her continue a little further, I really can't say.
Why don't you focus a question that she can answer? Restate a question, please.
Your Honor, I think my question was, if, you know, once they made the police report, if anything regarding same, if anything significant, if anything happened, for a while after that police report was made.
No, and we didn't hear from the police department or know what to do from that point on, or at that point.
Okay, but then, did you have contact with the police again at a later date regarding that initial police report?
I contacted them again when I saw a piece of our equipment that was going up for auction within a couple days.
And where did you see it, and how did you know that it was yours?
I had been periodically checking, like, to see if our stuff was up for sale somewhere, like Facebook Marketplace. I found the piece of equipment was on a site called Purple Wave, and I was just searching for the equipment by the name and for sale. And it was up for sale on Purple Wave under, I don't think Mark used his real name. I think he used a name of Matt Carter instead of Mark Carter, but the serial numbers matched, the picture matched, and I think his address was in the picture on Purple Wave even.
And what piece of equipment was that?
That was the shot blaster, the BP 15. That also has a Blast Pro 954 vacuum with it, a HEPA vacuum with it.
Okay, and did you know at that time, and when was this? What month, year was this that you found this?
It was 2022, and I want to say around probably October. It was the point that they were able to get a search warrant the first time. And I don't know if that was October, if it was early November.
Okay, so around late October, early November is when you see this on Purple Wave, and you know it's your piece of equipment based on the serial number.
Correct.
And were there pictures of the serial number?
Yes. Yes.
Okay. And at the time that the defendant was employed, or shortly after he was still employed with you, which you said was in November, December of 2021, so basically a year before this, did you know where he lived?
Yes.
And where is that?
He had lived at a house on Flynn Street, which is South Rock Road and Pawnee-ish. When he asked to borrow the box truck, he said he was moving to a place down south. And we didn't know, we thought he was moving to that location. We didn't know he was keeping both houses. But because of him clocking in, I knew he had taken stuff down to that south. He had clocked in to go down south, and there would have been no other reason for him to do that.
Okay, maybe let's back up. So we'll come back to that. You see the piece of equipment on Purple Wave, you match a serial number to the photographs that they've posted, and you contact law enforcement to tell them that you found this Blast Pro piece of equipment.
Yes.
Okay. Now, as we know, this is approximately 1 year after he no longer worked for your company, correct?
Correct.
Okay. And had you asked him to, or told him or allowed him to take any of this property, to take any of these pieces of equipment besides borrowing the box truck temporarily?
No.
And had you asked him to repair any of them or store any of them on behalf of your company?
No, not after that point of the truck, December 1st of 2021. No. And before that, he was not, no, repairing any of it. No. And not storing it either.
Okay. Now, you just mentioned clocking in and clocking out. I guess maybe explain to me what you mean by that, and does that have something to do with when he was still employed?
Yes, we used a service, and it was an app called Clock Shark, and we started using that in 2019. And it's just an app that employees can clock into a job when they get to the site, and they clock out when they leave. It keeps track of it. It does GPS while you're clocked in to that job.
Okay. So what significance does the clocking in, clocking out have to do with the property missing?
Because we live close to where we were storing it. Where we were storing it's a kind of a unique place. It's at 13th and Andover Road, but it's in between the building and 35, Interstate 35 that goes over it. So it's on the north side of that building, and it's fenced, and we kept it locked. But because it was outside and against the building, I went down there weekly and took pictures of everything there, just to I don't know, I just did it. And I did it in the warehouse too, when we were at the warehouse in Bel Air. And so I can compare the pictures that I took, but also he told, we had another employee at the time that he actually gave a piece of the equipment back to, and I don't know the date of that, but it was mid-November to late November. I didn't want to think that he took all of that equipment, but he took all that equipment because I've seen it up for sale online. And I know that one of the posts shows that it was posted January 1st of 2022 that he started trying to sell our equipment. I didn't catch it at that time because I wasn't familiar with all these online auctions that there are and places there are to sell equipment. But it was pretty clear when he wouldn't return the box truck. It was pretty clear that what was going on. I don't know how long he had been doing it. I know I suspect it was over several days. It wasn't a one-time thing because it was a lot of equipment.
Okay, so you take weekly pictures of this lot storage that's fenced, and how many people had access to that area?
Probably 3 or 4 people. Our lock had a combination on it. It wasn't a key lock. It was just a combo. And so there was a handful of people that probably had that combination.
Okay,
or
so
that
3 to
even knew that it was there, because you don't really see it from the street, and there's only one way to access it is from 13th Street. It's fenced. So he knows about it because he helped us deliver the product and stuff there to begin with, over like April, May, and June. of 2021 is when it was delivered there.
And when you say product, you mean the equipment and maybe other building materials?
We were evicted from our office in Bel Air that we had been at for 20 years. And that was part of my story of what led us to where we're at. We'd been in I think 12,000 square foot warehouse that we had pallet racked, 3 high, and we'd been there 20 years. And we had like 10 days to move out once we were evicted. And obviously it took us longer than that, but there was a shortage of storage trailers, which was our plan. We were going to get storage trailers and park them there. There was a shortage in Wichita. We could not get storage trailers. At the time, we were fighting the court case down in Oklahoma that took more of my time. And so I know Mark knew there was opportunity to do this.
And you were changing locations. You said April through June. Was that 2020 or 2021?
2021.
Okay. And did you end up having, after you found this piece of equipment, did you actually get that piece of equipment back? This blast?
No, we still not. We have not gotten any of our equipment back. Other than from this latest search warrant that was the second one.
Okay. Now, do you end up having contact with law enforcement a subsequent time after you report this Purple Wave Blast Pro piece of equipment? Then what happens?
They got a judge to sign off on the search warrant for the one house where the Blast Pro was in the picture at his house. They did a search warrant there, and I don't know anything other than them calling me and saying that he said he doesn't have the equipment anymore, that he sold it all because we owed him money. Because
and did you owe him money?
I do not believe I owed him money for what he said. He said that it was for storage, that we were supposed to be paying him for storage. That's what the agreement was, but I don't have an agreement. There was never a verbal agreement for him. We had just moved it all to storage at 13th and Andover Road. I've never received an invoice from him. I don't know a dollar amount that we supposedly owe him. And in the time that it was taken to the time we knew for sure that some equipment had been sold, he had told the police officer that he sold it all. And so I'm like, okay, what are we supposed to do now? Because nobody's doing anything, and he has stolen everything that we used to, try and create some revenue for our business. And I mean, he just took it all. And
the state's next question to the witness is what, Ms. North?
And so the next time you have contact with law enforcement, are they actually doing another search warrant?
No, well, no, a little more time went by and we still nothing. And I was trying to figure out how we could get a search warrant for his house down south. That's what the struggle was. Because he had everything covered up in tarps. He had a semi-trailer parked out front there. We couldn't get the search warrant. But then on Facebook Marketplace, I saw his wife had put my husband's motorcycle up for sale. And so I contacted the police department again saying, okay, he obviously still has a motorcycle because his wife's trying to sell it.
And what kind of motorcycle was it?
A Yamaha, like a dirt bike motorcycle.
Okay, and so you saw something on Facebook Marketplace, and you know what defendant's wife's name is?
Michaela, I think. I'm not positive what her name is, but I recognized the motorcycle. I was still doing periodic searches for our staff. Because
okay,
I mean,
so you didn't necessarily look up her specifically.
No.
You just saw there was a motorcycle and you looked at it knowing that you had a motorcycle missing.
Right.
Okay. And you know, what color is it? You know, what kind it is?
It was a dirt bike that, I don't know, it was kind of a little bit unique, and I had pictures of ours from it had been in the warehouse, and I knew what it looked like and I could compare it that way.
Okay.
And with it being his wife being the seller, and I knew what the VIN number was for it, and so it was pretty clear that it was our bike or my husband's
And
bike.
were you able to see the VIN in the photos on Facebook Marketplace, or was that
No.
something that they discovered later?
I don't know when they discovered it. I know I had it. I mean, I had given it to the police prior to.
Okay. That I guess my question wasn't clear. I want to know if you can see the VIN when you're looking at the pictures on Facebook Marketplace.
I don't think so. I don't think so.
You recognize it just because it's sort of unique and you've seen it before and it's your husband's, and so you call it into law enforcement.
Yes.
Okay. And then after that, do you end up needing to, then you end up getting the motorcycle identified, and is it your motorcycle?
So I had pictures of the motorcycle that I sent to the police department. And it took several times because I think the detective at the time was on leave. So it was several days. But then they were able to get another search warrant or do a search on that with the information that I'd given them about our stuff and the history of knowing that we were trying to get another search warrant, and what had happened throughout the year before.
But did you get the motorcycle back? I mean, was the motorcycle, did they recover it from someone?
Yes.
Okay. And so the motorcycle that you had seen on Facebook Marketplace was in fact your husband's motorcycle?
Yes.
A white and blue 2000 Yamaha 450 motorcycle?
Yeah, it was a 2003.
I'm sorry, if I didn't say 2003, that's what I meant.
Okay, I'm sorry. I heard just 2000. So,
and did you end up looking at more property besides the motorcycle thereafter that was yours?
Yes.
And was that in conjunction with law enforcement executing another search warrant?
I don't know what happened on their side. I just know we got a call to come and take a look because there was a lot more stuff that was there this time that wasn't there the last time they searched the house.
Okay, so where did you go to look at property with law enforcement?
To his house on Flynn, which is Rock and Pawnee.
Okay, so you go there and you look at property. Are you able to identify property as being yours? And if so, how did you go about doing that?
I brought my iPad with me and I had pictures of our property on there that we were able to try and identify. And I know looking through the pictures now, I know there's stuff that is still there at his house that is ours. Yeah, and I mean, there was stuff with our name on it, like Bishop. There is, I mean, you saw I assume everybody has seen the list of everything that was recovered.
That's no one except for probably me and law enforcement has seen the list. The court doesn't necessarily get like full police reports, but we're talking countless items.
It was a list of stuff. It wasn't our equipment though. But it was a lot of stuff, yes.
Like miscellaneous stuff like rolls of rubber adhesive, saw blade, sledgehammer.
He had some of our tile saws. There was a folding white table. There was a job box that we had, a gray job box, like a job site job box that was in his garage. Some tool, like tool boxes. There was a cooler that was an OtterBox cooler that we found. I mean, there was a lot there.
Okay, so miscellaneous tools and a lot of other things, but none of your really expensive, larger, big pieces of equipment.
Correct.
Okay, so like the Blast Pro machine that you still haven't found that was sold on Purple Wave, which I think the defendant's law enforcement that he did actually do that. I think that's what you said earlier, but about how much is that piece of equipment when it was new?
It's two pieces of equipment together, but they work with each other. And I want to say we paid around $60,000 for them in 2016.
Okay.
For a project, but it did not sell on Purple Wave. Purple Wave pulled it before the auction. But then by the time the search warrant was served to Mark in Wichita, he said he had sold it, and I was told that it was sold back to the company who sold it to us, Blast Pro. And we're like, okay. I think he said that he sold it for $22,000, and I still don't know how we're supposed to get that back or how that works. I know the police department contacted Blast Pro, and he would have to speak to what went on there, but we still don't have our equipment. But I know it did not go in the auction. It was pulled before the auction.
Okay. And but out of all the items that were that you did find, and then these other items that are still missing, about how much are these items, or were they worth at the time that they were taken?
I bet I can get to $500,000 worth of stuff easily. That's how much stuff he has taken.
Okay. And the stuff that was located, are the kind of miscellaneous tools and the cooler and all that kind of stuff. Do you recall about how much of that recovered property was? Was that over $10,000 worth of items?
That came up to about $30,000 worth of stuff.
Okay.
I don't mean to cut off here or anything, but do I get to question the witness here today at this time as well, Your Honor?
Not at this time, but eventually you will, Mr. Carter.
Okay.
You'll just wait your turn.
Okay. Sorry.
Any further questions for this witness?
No, not for me.
I was asking the prosecutor.
Oh, from the prosecutor. Okay.
And no, Your Honor, I don't think I do at this time. Thank you, Ms. Bishop.
Now, Mr. Carter, if you have questions for
don't go anywhere, Ms. Bishop.
Okay.
Stay with
remember,
us.
you ask the question, Mr. Carter, she provides an answer. Okay.
Okay. Sounds good. Thank you. Yes. Okay, Kim, let me ask you, you stated that you stated here today that you reported the box truck stolen on December 1st of 2021, or the box truck was returned December 1st of 2021, and then you reported it the next day or the day after that. Is that correct?
No, you're misunderstanding. We recovered the box truck on December 1st. That's when we were able to get it back. And it was that very next day, because it was like 2:00 in the morning, I want to say. And I think it was the next day is when we filed the report of the stolen equipment, not of the box truck, but that you had the box truck and would not return it. But then we recovered the box truck. There's damage to it. There was.
Okay, that's not my question. I mean, you answered my question, but that's all I needed.
Okay.
So you reported the equipment the next day after the box truck. So what day did you initially report the box truck stolen?
We never reported the box truck stolen. We reported that you had not returned it because we let you borrow it to move.
What day did
but
you
then
report?
You would not return it.
What day did you make that report for the box truck?
We did not make a report for the box truck. When we got the box truck back in our possession, that's when we filed the police report because you would not return the box truck. And we knew the equipment was gone at that point.
Okay, see, I'm trying to understand this here. So you reported the box truck as not being returned, but you didn't report the box truck at all.
That was part of our report. That was part of the actions that you had done up until that point in the last the 3 to 4 weeks prior to that, because you kept that, you borrowed it, but you didn't return it.
Okay. So let's say December 2nd, you reported the equipment gone. Is that what you're saying?
Yeah. Yes.
Okay.
That was when the police report was filed.
And what equipment was on that report?
The equipment of the shot blaster, the national carpet flooring scraper, all of the stuff that we had serial numbers for and we knew was gone.
Okay. Now, speaking of serial numbers, the serial number for the Blast Pro that was listed on the search warrant, was that accurate?
I did not see the search warrant.
With the one that you gave the police?
I didn't give them a search warrant.
You didn't buy it, so you gave the serial number that you gave them.
Was your question?
The serial number that you reported for the Blast Pro machine to the police, that was an accurate serial number for the machine that you reported stolen, correct?
I don't know what you're asking, since I have the documentation of what the serial numbers were for the equipment. I assume that they typed it in right, but I don't know I didn't see the search warrant.
Okay, I'll say that for a later time. Okay, now the weeks leading up before the December 1st or 2nd report, you stated that I had contacted another employee, or another employer had contacted me and received another piece of equipment from me that I was storing. Is that correct?
No, that's not correct. It was a piece of equipment that he went to go pick up at 13th Street and it wasn't there. He asked you if you had it and you had it, but there was no reason for you to have it. But he made a time and schedule to get it back from you at that point.
Do you recall if I was working at all at any time during that time frame that I was contacted by the other employee? Was I still an employee of Total at that time?
I think at the time we thought you were, but I didn't. You never like officially quit. It was just you stole all the equipment, and then it was obvious that what had happened.
Okay, so the weeks leading up before the December 2nd report and the return of the box truck, you said that I was in Clock Shark, correct?
You
For some
did
of the
clock
time,
in.
and I was, the GPS showed me down at the other place down south. Is that correct?
Yes.
Okay. Would it be fair to say that I was clocked in for what reason? What reason was I clocked in for?
I don't know why you're asking that. You were,
Why would I have
but
been clocked?
you did different jobs. You went to different places to do different jobs. You clocked into those jobs, you clocked out of those jobs.
Okay,
So
there's that I was an employee, correct?
Okay, wait, you two, you can't talk over one another.
Sorry.
We're trying to make an electronic recording of these proceedings, and there's no way this could be accurately transcribed if you're talking at the same time.
I'm sorry, Your Honor.
So, Ms. Bishop, let me instruct you to just narrowly answer the question that's being put to you. And Mr. Carter, allow her to finish answering the question before you start talking again, okay?
Sir. Yes, sir.
Ask your next question, Mr. Carter.
Yes. What reason was I clocked in to show my GPS location down at my south house?
there would have been no reason for that.
Okay. Were you aware of any conversations that I had with your husband about work or anything of that nature?
Not that you had around me that I would know. And I do want to add to the part on the GPS. I didn't check GPS on our employees every time I did payroll. I just would normally do the hours. I only checked the GPS because of the equipment missing. I was able to go back and see that he had clocked in and driven down south and was clocked in down there for several hours. That's not normally something I would check or should have to check.
Okay.
I don't know if that makes sense.
My next question is, did you ever tell detectives that I had stored anything for you or your husband?
No, I told.
Okay.
We were storing the product at 13th Street, Mark. We were never storing it at your house.
I'm just asking you. Simple question, simple answer.
No, the answer is no.
Thank you. So when did you report the dirt bike stolen? Was that reported on the December 2nd report in 2021?
The report was a list of product and equipment and tools. I still don't know to this day. I can only give what we know for sure is gone, not everything that I'm sure is gone.
Didn't you go out there every week and take pictures as you just testified to?
I did go out there and take pictures every week.
And compare?
Mark, I didn't compare them at the time. I can only do that now that I know everything that was gone.
Okay. So when did you report the dirt bike as being stolen?
It was part of the unknown of what was gone. We knew the dirt bike was gone. That was obvious. That was from the initial report. I don't have a copy of that. I don't know what all was on there. I know that for sure the equipment was on there because that was our main priority of getting it back. I don't know what all was on there from that.
What date did you notify law enforcement in Andover, Kansas that the dirt bike had been stolen and you see it online? When did you know the dirt bike was stolen? And when did you make the report for it being stolen?
December. We've only filed one police report of 2021.
So the December 2021 report should state in there the dirt bike, correct?
I don't know if it specifically says the dirt bike. I just know it was unknown what all was gone at that point when the police report was filed.
But you'd given them a list though at that time, right?
I I think it, I don't remember, and I don't have a copy of the police report. I don't know if it was a list that was made at the time that we were sitting at the police department, or if it was something that was sent later. I don't know.
Okay. Now, if I had stolen the equipment, supposedly as you claim, during the time frames just weeks before the December 2nd report, when I was borrowing the box truck to clock into work for no reason whatsoever to work, and the other employee asked me for the equipment back, if I had stolen it, why would I give that equipment back to the other employee, do you think?
I'm not sure what your
calls
question
for
is.
speculation.
Objection sustained. Next question, Mr. Carter.
Sorry about that. Well, when you came to my house to identify items that were supposedly stolen from you back in 2021, actually back in, what is it, April 5th of 2022 or 23, I'm talking about the search warrant where you came to my house on the 23rd of April of this year, April 5th. Did you come over, and what were you instructed to do by the law enforcement officers there on the scene that day?
To come and identify what property was ours. And I know pictures would help of what your garage looked like, of why they could not go in there and identify specific things, because there's just so much stuff.
Because it wasn't in the,
No.
there wasn't items specifically listed in the report that they were trying to identify, correct?
There had been several email exchanges of updating property and stuff that we were missing from that initial.
From then, from April 5th, from till now, or I'm talking about prior to that.
It was.
All I need to know is, what did the officers instruct you to do the day that you came to my house on April 5th of 2023? What were your instructions?
That they had recovered, they called and said they'd recovered the dirt bike, and that there was some other property that matched the pictures that I had given to them of our equipment and tools and stuff that was missing.
There was pictures of it?
There was.
Okay.
It wasn't like pictures. It was a piece of paper, like a 11 by 14 piece of a picture that had a bunch of pictures on them. It was like a screenshot from your computer of pictures from the warehouse of our property.
Okay. Now, while you were there, did you ever identify anything that wasn't yours that originally that you may have told Tim to have them listed either way because it needed to be put into evidence so somebody else could claim it? Did you ever make that statement that day?
I don't recall making that statement.
Okay.
No.
That's fair. Did you, when you were at the house that day, did you ever point out any item that you knew not to be your item prior to that day, but still claimed to be yours at that moment, just to take it?
No. In fact, we were very careful about that.
Did you have pictures of every item that you took that day, prior to that day that you took the items from my garage?
Yes.
Every single item?
I would think so. That was part of why I had the iPad and the pictures with us.
Okay. Back to whenever before the 3 weeks or so before the report was made originally in 2021, December of 2021, were you aware of where Tim was working at the time, what job he was at, and what project he was working on at that time frame? Do you know?
I think that he was between a couple of different jobs at the time.
Do you know of any other jobs where I would have been working at during that time frame, or projects I was working on for you?
I know you were helping Jimmy do the Millicare, the carpet cleaning side of it is what you were mainly doing. And I know you helped him some. I know you weren't available a lot when he did need you to help him there towards the end for sure.
Why wasn't I able to help him?
What?
Why wasn't I able to help him? Do you know?
It was probably you had other things going on that I don't know.
Like clocking in for reason? Is that what you're saying?
Did you say like clocking in for no reason?
Yes.
No, I didn't mean to say that. It was there was no reason for you to be clocked in at your house down south.
Okay.
You were helping Jimmy do the carpet cleaning side, and that you were scheduling your hours with him.
So do you not know of me helping Tim out in the basement in Valley Center doing grinding and polishing there?
I'm sure you probably did help him in Valley Center.
Okay, that's all I have for that. The day. So I know you've stated that you've only made the one report to detectives for all of the equipment and whatnot, and it was on or about December 2nd of 2021. And the serial numbers were all given to them at that time for all the equipment that you had listed, and all the photos were pretty much submitted at that time as well, correct?
There was that submitted at that time, and there was also stuff submitted between that and now. I mean, as we were able to gather the information and put it into a format, there were emails that were sent to them.
All right, let me ask you this, Kim, did you ever report to the federal government on a contract job, wages that you had paid me that were inaccurate in any way?
Mark, your time for McConnell Air Force Base was reported to the contractor. And if you've got a problem with that, like you threatened to file a labor department complaint, file the complaint with the labor department.
Get into a bickering match over some sort of wage claim.
I'm not trying to. I'm just straight asking a question. I'm just asking for a simple answer. It's very relevant, and I do have evidence to submit in support of this to show for character purposes, Your Honor.
Yeah, I'm not sure her character is legitimately at issue here. All right. Have you completed that line of questioning, Mr. Carter?
No, I'm just, it's got about 2 to 3 small parts, just simple answers, and that's all.
That has to do with your wages?
For what they were trying to claim, it's for a reason they're trying to claim as me stealing stuff from them. It's kind of their excuse as to saying why I stole something from them when I haven't stolen anything at all. That's why. They're trying to use another point of saying that I have a reason to go and steal. They owe me money is what it originally came down to at the beginning of her testimony. Then I owed her money, and that's why I stole something.
Because that's what you told the police officer.
I never told the police officer anything like that.
All right, perhaps we should move forward by Mr. Carter, you asking your next question.
Thank you.
Will determine whether I will allow.
Thank you. My question was, did you ever report wages to the federal government regarding the McConnell Air Force Base job for Davis-Bacon pay hours that you claim were paid to me by you and your company?
Those hours were reported weekly to the contractor in 2020 for that project.
Okay, why don't you stop there?
Okay.
Any further question along those lines, Mr. Carter?
Yes, it's to deal with the temporary agency that I was working for at the time. I was subcontracting through a
Okay,
temporary.
I'm not wanting to hear your side of it. What I'm here, do you have another question for her?
Yes. Yes.
Ask it.
Okay. While I was working before I became a total installation permanent employee, and I was working for the temp agency over on West Street, DES Solutions, did you report the same wages to DES Solutions as you did to the federal government for the contract paperwork on McConnell Air Force Base?
Yes, those hours were reported. And at the time that you were a subcontractor through a temporary agency is how it was reported.
Okay, that's all I need. Thank you. I have no more questions about that now, Your Honor. That'll be coming into play later. Thank you. I think there was one more. Hang on, let me read through my notes just briefly here, okay? And then I might have one question after this, and that's it. And if not, I'll be done. Okay, so the dirt bike. What you said you were looking through and you noticed the dirt bike. Where did you notice the dirt bike for sale at?
On Facebook Marketplace.
Okay, and can you describe the colors of the motorcycle?
Blue and white and yellow.
Yellow? Okay.
There was like a yellow part on the stickers or something. I compared it to a picture that I had from the warehouse, Mark.
I'm just asking simple questions, that's all. Simple answers. Did you ever report to the police that the box truck had been located after the report was made on December 2nd of 2021?
Objection, Your Honor, asked and answered several times.
Not this portion, no, not.
Objection sustained.
Okay, I'm done with this witness. We can go ahead and call the next one if you want, Your Honor.
Anything further for this witness at this time, Ms. Norris?
No, Your Honor, thank you.
Do you intend to present further evidence at the preliminary hearing, Ms. Norris?
Your Honor, briefly, I will ask that we call Tim Bishop.
Will he be your last witness?
I believe so, Your Honor.
Okay. So then I need to inquire, Mr. Carter, do you intend to present evidence at this preliminary hearing stage of the case?
Yes, I do, Your Honor.
All right, counsel, we're going to have to bifurcate this proceeding. We're already out of time. This was a single count property crime felony, and I set it for an hour. I have to move on to other matters, and it doesn't appear we're anywhere near a conclusion. So I'm going to have to go ahead and reschedule, but unless my assistant tells me otherwise, I can pick this up at 3:30 tomorrow.
Your Honor, I'm not sure I'm available, but could we bring in all the other witnesses so they can be, we could talk to them about their calendars as well?
Yes.
Thank you.
And Your Honor, at this time, I would like to go ahead and make the motion for the return of at the bare minimum my welder back, because they didn't have they have no serial number, they have no evidence of anything. It was not listed in the search warrant specifically, and it is not their equipment. I have photos. I've submitted documentation to the detectives that proves that I've had that thing for a long time. And I'm missing out on money right now because I can't weld.
Sorry.
And Your Honor, I think I'm available. I'm having a hard time getting into both my, I can see obviously my book calendar, but I'm having a hard time getting into my computerized calendar for whatever reason. But I do believe I am available in the afternoon of July 28th.
I was looking at late morning, 10:30 to noon.
Oh, I'm sorry. Yes, Your Honor, that should be fine.
All right, I will reschedule then the Mark Carter matter to resume the preliminary hearing, having completed one witness's testimony for 10:30 a.m. on Friday, July the 28th. That again will be by Zoom. We'll use the same Zoom numbers as we did today to reconvene the hearing. Again, that's Friday, July 28th at 10:30. Mr. Carter, did you file any type of written motion regarding the return of property?
No, I have not. I didn't know I needed to file it in writing, Your Honor.
Did
They won't
you
let me
hear-
electronically
Did you hear
file
his
it.
request, Ms. Norris? He's got apparently they confiscated a welder that he says isn't involved as stolen property or evidence in this case.
Yes, Your Honor. He actually has, he brought that up at the last setting, according to file notes. That was back June 5th. I don't have any information that, other than his request made on the record, that is his, and that it should be returned. It's in evidence with law enforcement, as far as I understand. And like I said, other than him, saying kind of the same thing, I don't have any information from law enforcement or any documentation that leads me to believe that it was wrongly taken as part of the search warrant. Sometimes things like that, could happen, but I don't have any information that is the case. And I do believe he's talked to Lieutenant Scheinert more than once. And I think he's probably been told that it's in evidence and it will stay there until, the case is complete without some other, orders from the court.
I'll take this under advisement. I may rule on it on July 28th, but frankly, there's no welder charged as stolen property in this case. And I would expect, Ms. Norris, that you'll check with the victims in this case to see if a welder was one of the items that they had that came up missing. And if the department doesn't have any reason to believe that this has been stolen either from these alleged victims or some other alleged victim, the property really ought to be returned to Mr. Carter.
Well, and Your Honor, I did not list every single piece of property that they found. Miscellaneous tools covers a lot of things, but if the court wants me to list every single item, this information will go from, 2 pages to probably like 3 or 4.
All we're discussing is the welder, and I don't see it listed as a specific item. It very well may be involved in this case. All I'm simply expressing is I would ask you to look into it, and if the welder is not needed as evidence in this case, it ought to be released.
And Your Honor, I like I said, I understand his position, but it's been my understanding after speaking with law enforcement, et cetera, that it was appropriately in their care and custody, but I will have further discussions with them and find out more information.
Thank you. I appreciate your efforts in that regard, and we'll address it again most likely on July the 28th.
That'd be my guess. Yes, Your Honor. July 28th, 10:30.
10:30 a.m. Again by Zoom.
And Your Honor, could I have all witnesses be ordered to return at that time for purposes of not reissuing subpoenas?
The court so orders, Ms. Norris. Everyone that's been subpoenaed to testify today is also subpoenaed and ordered by the court to be available by Zoom Friday, July 28th at 10:30 unless released. The Carter matter will currently be in recess. You may end this meeting for all at this time, Andy. This is in the District Court of Butler County, Kansas, case entitled State of Kansas versus Mark Anthony Carter. It's case number 2023 CR 194. Mr. Carter appears on the meeting, again, representing himself. Amber Norris appears for the state of Kansas. Numerous witnesses that apparently have been summoned by the state are also present on this meeting. This matter comes before the court at this time for continuation of the preliminary hearing that was initiated on July 5 of 2023. At that time, Kim Bishop completed her testimony, but due to time constraints, the prelim was bifurcated and continued for further hearing today at 10:30. I trust that the state's again ready to proceed, Ms. Norris.
Yes, Your Honor.
You may call your next witness.
State calls Lieutenant Michael Shiner.
Right. I think I'm going to go ahead and sequester the other witnesses. So if we could have the other witnesses besides Mr. Shiner placed in a waiting room until it's time for them to testify. All right, Mr. Shiner, if you do raise your right hand, I'll administer an oath. You do solemnly swear that the testimony you're about to give in the matter now on hearing shall be the truth, the whole truth, and nothing but the truth. So help you God.
Yes, Your Honor.
You may question the witness, Ms. Norris.
Thank you, Your Honor. Please state your name and occupation for the record.
Michael Shiner, and I'm a police officer with the Andover Police Department.
And how long have you been in law enforcement?
A little over 10 years.
And how long with Andover?
Same.
And how long on your current position?
About 2 years.
And are you familiar with defendant Mark Carter?
Yes.
And can you explain briefly why you're familiar with Mr. Carter? And do you see him on your screen today?
Yes, I worked a burglary / theft case involving Mr. Carter, and he is kind of an orange background, white walls, white male with a beard, short hair.
Okay, and that's the same Mark Carter that you have dealt with regarding this burglary theft case that you just referenced.
Yes.
Your Honor, would ask that the record reflect that the witness has identified the defendant, Mark Carter.
The record so reflects.
Thank you, Your Honor. This case started a while ago, is that correct?
Yes.
And just briefly, it started when, and then when did you really start making, I guess, good progress with the case?
It started, I think, in November of 2021. And first came in, I think, as an employee that stole a truck, a work truck. And then the victims in the case kind of lost contact with them for almost a year. I think they were going through a civil case is what they told me is why they weren't answering calls or anything. And then they noticed that some property that they had in a warehouse that was being stored somewhere had all gone missing. And they believe that Mark Carter was the person that took that stuff. And they found one of the items that went missing on Purple Wave being sold by Mark Carter.
Okay, and so is that, what did you do with that information?
I contacted an employee of Purple Wave and asked him about the item that was being sold and verified the serial numbers and verified that serial number did match the one that they were reporting stolen. And then you want me to keep going?
And what was that piece of equipment?
It was a Blast Pro large concrete piece of equipment.
And like Blast Pro shock blaster machine?
Yes.
And were you able to, so you talked to ProWave, were you able to recover that from them, or how did that end up playing out? And were you able to get any documentation? I mean, how did you know that it was Mr. Carter?
So there were photographs of the item. And you could see the house and the yard in the background of the photos of the item. And we drove by the house and verified that those pictures were taken in the driveway at that residence.
And what residence?
Mark Carter's residence.
Okay.
And then talking to the Purple Wave employee, he sent me like the contract for selling the piece of equipment, and it had Mark Carter's name on it. And I had a discussion with him. If I remember right, it was supposed to be sold that day or the day after, go to auction. And he told me that it wasn't actually going to auction because they felt like Mark Carter, or the person that was selling the piece of equipment, was shady. So they kind of canceled the entire transaction.
Okay, so it didn't actually get sold through Purple Wave, but you confirmed the so the contract, did it have phone number, address, name, those sorts of things where you could confirm that the Mark Carter that's in the paperwork is the same as the Mark Carter that you've identified here today?
Yes.
And did you talk to Mark Carter regarding said piece of equipment?
So the first thing we did was apply for a search warrant, believing that the item was still there because the pictures were taken fairly recently.
Still there where?
At Mark Carter's residence.
Okay, and is that on South Flynn?
Yes.
Okay.
So we applied for the search warrant and went to the house. I don't believe Mark Carter was home. And he had a Ring doorbell, and we rung the doorbell and talked to him through the ring. And he asked that we wait and not bust through his door or anything like that. So we did. We waited for him to come home for wherever he was at. And that's when I had a discussion with Mark Carter about the equipment.
Okay, and so did he tell you that he did have the equipment and that he did sell it?
Yes.
So you were not able to recover that Blast Pro piece of equipment on behalf of the victims?
No.
Okay. And he didn't sell it through Purple Wave. Where did he sell it, if you know?
He told me that he sold it directly back to the Blast Pro company in Oklahoma. And then I came back and called Blast Pro and verified that they did have that equipment. It was sold by Mark Carter to them. But they wouldn't give it back or anything, which is understandable because they spent a lot of money buying it from him.
Okay. And so the search warrant obviously did not yield that piece of equipment. Did you do any additional search warrants in this case?
Yes.
And when and where after this particular one?
So after that initial search warrant, I had a discussion with Mark. I don't know, is now a good time to go into that?
Well, when's the next time you do a search warrant?
It was on April 5th of 2022.
April 5th of 2022 or 2023?
2023.
Okay, because the one that you just talked about where you went to his house to look for that Blast Pro machine, when was that one?
That was December 8th of 2022.
Okay. Okay, so let's talk about why did you do another search warrant in April of 2023?
I was talking with Miss Bishop, and she stated that a dirt bike that was stolen during the same time that they believe Mark Carter had stolen came up for sale on Facebook. And it was being sold by his wife, Kayla Carter.
Okay, so she sees something on Facebook Marketplace and she identifies this motorcycle as being something else that is missing.
Yes.
And so what did you do with that information?
I contacted Kayla on Facebook, pretending to be someone else and set up kind of a transaction to go purchase the motorcycle. In the meantime, writing up a search warrant, a second search warrant. And when that got approved, we went over to the house and was able to recover the motorcycle.
Okay, so you basically set up a fake buy
Yes.
of the motorcycle, which were you able to confirm prior to the buy that it was in fact the victim's stolen motorcycle?
Yes.
And how were you able to confirm that?
There was a piece that was missing on it that the victim in the case had to weld to fix. And in the picture, it was clearly the piece that he was talking about was clearly on there. He was able to describe the colors and everything like that. And actually, when we got to the house, first thing we did was verify the serial number or the VIN number on the motorcycle, and it matched the VIN number that the victims gave to us.
Okay. So you said go to the house. Where are you going to do this motorcycle transaction?
On South Flynn.
Okay, so same address that you had been at before.
Correct.
And had something changed between the December 2022 search warrant and the April 2023 search warrant?
As in, I think the property was still missing. We still haven't recovered anything.
Right, but you had done a search warrant in December. I mean, obviously you were looking for the blast probe, but was there another property where that the defendant owned?
Yes.
Where, like this, say, like, had you run across this motorcycle in December of 2022 when you were at Mark Carter's?
It was not there.
Okay. And but like, so what had changed between December and April?
We knew about a property that Mr. Carter had in Sedgwick County, I think close to Iola somewhere. And we were never able to get a search warrant for there. There's just nothing that ever gave us enough probable cause to go over there and search that property. And from what the victims was telling me, he may have been evicted from that property. So he may have been moving stuff back to Flynn. And maybe that's why the motorcycle showed up.
And you said Iola, is it Viola or Iola?
Viola.
Viola. Okay. Viola in Sedgwick County. Okay. So see the motorcycle, go to basically confirm / make the buy. And then what did you do once you confirmed that the motorcycle was in fact a stolen one and at the residence on Flynn?
We seized the motorcycle and then executed the search warrant on the Flynn address for the rest of the property.
And what was the rest of the property?
The property that was taking out of the warehouse storage area that the victims had reported still missing.
And how did you word that?
It was the exact pieces of machinery that we knew about, and then we put their business was like concrete work, flooring work. So we worded as concrete tools and equipment or something similar.
Okay, because you're not necessarily, as a law enforcement officer, familiar with how you do floors and concrete necessarily work.
Correct. I had no idea what any of this equipment was.
Okay, or what kind of tools or anything like that.
Right.
Okay, so your search warrant was, I don't want to say completely vague, but maybe a little more vague when it came to the concrete tools and equipment.
I would agree with that.
Okay, so you executed that search warrant on the Flynn address?
Yes.
And I guess kind of just basically walk me through how you did that. Who was there and what was your process and procedure, if you could?
So the residence, I believe there's pictures of what it looked like. It was, I mean, it's pretty trashed, full of stuff. And again, I didn't really know exactly what I was looking for as far as concrete tools. So I had the victims meet me at the residence to help me look at stuff. And I also had the defendant's wife with me.
Okay, so the defendant wasn't present, but Kayla Carter was.
Correct.
Okay, so are we talking, you said it's kind of trashed. Are we talking like hoarders
Yes.
trashed or, okay,
to be-
and describe the property. I mean, you know, is it a house with a garage or outbuildings or just a yard full of stuff? Kind of explain, give the lay of the land for the court.
It's a house with a, I believe, 2-car garage.
Attached, unattached?
Attached.
Okay.
The garage was completely piled almost to the ceiling and all 4 walls of stuff. The inside of the residence, you can't even walk on the floors. There's so much stuff. The backyard, can't even see the ground. There was so much stuff on the ground. There's stuff everywhere.
Okay. Okay. So a lot of things to go through.
Correct.
All right. So you've got the defendant's wife, Kayla, and you've got Kim and Tim Bishop, the victims.
Yes.
Okay. Now, what's the process regarding the property? I mean, what are you doing and how are you validating and verifying these sorts of things?
So it was myself, Detective Snedeker, and Detective Sign were all present, and we were searching through the stuff with Kim and Tim kind of looking over my shoulder and Kayla on the other side looking over my shoulder, and they would identify something as theirs, and then I would tell them they had to prove it somehow. And first time I ever had a victim do this, but they had pictures of everything, their entire warehouse. So they were able to pull it up on the pictures, and still, if Kayla said that that's not theirs, that's Mark's or mine, there's a lot of things that Kim and Tim would say that was theirs. Kayla would say it wasn't, and I told them we couldn't take it.
Okay. And if Kim and Tim said it was theirs and they could confirm by photograph, and then was and Kayla said yes or no, if they could confirm by photograph, what did you do?
I seized the item.
Okay. And on most of the items that you seized, which I know you did like a whole separate report, I think, that lists out a bunch of the items that you took. Of those items, do you recall if any of the ones that you took that Kim and Tim showed either photographs or identifying marks, or, you know, could identify the property in some capacity? And then did you actually ask Kayla, you know, is that yours or Mark's? And if she responded no.
Yes.
Yes. I mean, any of the items that you took, had she responded, yes, those are ours, or were they all no's, they were not theirs?
There's a couple things, and that's the reason why I stored them in evidence, because she would say, yes, those are mine or Mark's. But then they would have a picture of it in their warehouse.
Okay. And were there some things though that she agreed, no, they absolutely weren't hers or Mark's?
Correct.
Okay. So a little bit of each, but she was with you the whole time during this process.
Yes.
Okay. Now, and if you just quickly want to list out the items that you found that you did recover as stolen, and this was based on Kim showing you pictures, and then also either Kim or Tim giving you physical marking descriptions, or how did this, I guess,
So,
you know, a little more detail about how you guys figured this out.
there were some items, like some of the hand tools. I asked Tim before we even looked at any of this stuff, how would I know that that's yours? And he told me, I can't remember the colors without looking at the report, but there'd be certain colors of paint on the tools. And sure enough, when we were going through, we'd find the hand tools and they would have the paint colors he described that were on them. There were also some items that had their company tag on them, Total Installations, and the tag was on there saying that it belonged to them, and had Tim's phone number, call this number if found. But like I said, most of the things we took had pictures. They had pictures of the items.
Okay, from their warehouse.
Yes.
Okay, and so, I guess, if you could go through the list. And just, name a few items and that's, that would probably be helpful for the court.
Okay, is it okay to read it from my narrative?
Sure. I don't expect you to remember all of
Okay.
these items, especially after, since April.
Okay. In the garage, there were 15 rolls of rubber adhesive for like flooring, a compressed gas tank.
Hey, Detective Shiner or Lieutenant Shiner, you might just hold off for a second. Judge, it looks like we just lost the defendant.
Okay.
We'll give him an opportunity to rejoin. Mr. Carter?
Yes, I can hear you now. I had technical difficulties. I was trying to object several times there, but my microphone on my laptop wasn't working, I guess, when it said it was. I do apologize.
Okay, it's working now.
Yes.
All right, we paused to let you rejoin. So now that you have, you may proceed further, Ms. Norris. We were talking about a list of items, 15 rolls of adhesive, and then a gas tank. And then I think that's when there was an interruption.
Yes, Ron, I think that's correct. So, Lieutenant Shiner, if you would like to continue through a little bit more of your list. I think it's maybe broken down in like to 3 different parts. So you don't need to probably read everything from all 3 lists, but give a good sampling for the court. If you
Okay.
would.
Purple air gun tank, red snap-on toolbox, a Lincoln electric welder, DeWalt hammer drill, some extension cords, car batteries, some red, green, blue plastic trays, a gray job box, some vinyl cutting machines, an appliance dolly, a blue sample locker. There was a white otter box, and then some industrial electric cords.
Okay, and so were these found all in the attached garage?
No, they were found, most of it was found in the garage, but there was like a wooden box trailer on the driveway that had some of the stuff in it, and then in the backyard.
Okay, and the total amount, in the approximate dollar amount recovered was what?
$14,110.
Okay. And all of that equipment that you have, all of that you listed, and then everything else, because you didn't list every single item just for sake of time. Where is all of that evidence at this point?
Everything except for the dirt bike is at the Andover Police Department.
Okay. And the dirt bike is where?
I gave that back to Tim because Mr. Carter and Kayla both told me that is his.
No. Objection.
To objection, Mr. Carter.
He's not, he can't speak for me because I never told him that. I wasn't even there. I was in jail.
All right. All right, so noted. Let's proceed further, Ms. Norris.
Yeah, the objection is overruled.
It is.
Lieutenant, sorry. Did you said that Kayla told you that the motorcycle and that Mr. Carter at some point in time both had told you that dirt bike did in fact belong to the Bishops? When was that, and how did that come about?
That was before Mr. Carter went to jail. And then when Kayla showed up, she told me the same thing.
And when he went to jail, when was that?
The same day as the search warrant, so April 5th. we had a conversation before he was taken to jail, before we even executed the search warrant. Because the dirt bike was in the driveway when we arrived.
Okay, and what specifically did he say regarding said dirt bike, the defendant?
Again, just like the first time we served the first search warrant, he told us that this is all civil, they owed him money. And then told us that we could take the dirt bike because it is his, but none of the other stuff on the search warrant was.
Okay. And did you have additional conversation with the defendant after you served this search warrant that we've been talking about and recovered all of this property? Did you have any additional conversation with the defendant?
After he got out of jail, yes.
And was it about the search warrant or specific pieces of property, or similar conversation to what you've already told us, which is he claims that it's civil and that's I think did you talk about them owing him money?
Yes, it was all of the above, everything you just stated.
Okay, so civil, and that they owed him money, and that
About the search warrant and specific pieces of property.
okay. So he doesn't actually deny that he had the property, or that a lot of the property that you recovered wasn't actually the bishops or the total installations.
Correct.
And I know that this has come up basically just not necessarily as part of the prelim per se, but as part of even scheduling, etc. The Lincoln welder that you mentioned, how is that identified as the bishops?
The bishops
Their
had
companies.
They had a photograph of it and the serial number for it. They provided when they listed out property that was stolen from them. And
Okay.
that's how they see it. Go ahead.
And you had referenced it as a piece of equipment more in the concrete tools category and equipment, not necessarily, you had not specifically listed it out
Correct.
as far as a search warrant.
Correct.
And all of these items that you recovered are all ones that the bishops did not give permission, or the company did not give permission to the defendant to take from their warehouse or storage areas.
That's correct.
Okay. And have you talked to Mr. Carter regarding any of this property since we filed this case?
Yes.
Has he been calling you, emailing you, and what about?
Both, and most of it's about the Lincoln welder. Mr. Carter says that was his welder and it was at the warehouse because he was using it to fix things when he was employed by them. And then he did provide a pawn slip from when he pawned the Lincoln welder. And I believe it was in September of 2022, maybe. So, and my only issue with that is that was after the theft was reported. He pawned the Lincoln welder and then went and picked it up.
Okay. Because the original theft report was November, December of 2021, right?
Yes.
Okay. All right. And so you requested charges on the defendant. What were the charges and based on what?
They were for theft, and it was based on the fact that they reported this property stolen, and Mr. Carter admitted that he did take at least some of the property and then was selling it through Purple Wave, or at least attempting through Purple Wave and on Facebook.
And he claimed that they owed him money, but did you talk to the bishops about that or their company representatives?
I did, and they said that they did not owe him any money. And with my conversations with Mr. Carter, I told him that even if this was kind of a civil deal, he's required to go through civil court before he can just start selling people's property.
Okay. Lieutenant, I don't think I have any further questions. But Mr. Carter may have some follow-up for you, okay?
Okay.
Carter, questions for this witness?
Yes, sir. May I proceed?
You may.
All right. All right, Detective. You said that the Lincoln welder, they had the serial number to it. On which document do you refer to that has anything where they have a serial number written down for that Lincoln welder?
So I asked them to provide me with a serial number after we took it, and they were able to provide me a serial number that matches the Lincoln welder.
Well, yeah, they had photos of it after that, right?
No,
From our garage?
no,
Kim wasn't taking photographs in the garage with her iPad?
not specific items, no.
Okay, well, I do have video evidence of her actually doing that. Do you know that my Ring camera was working the entire time that y'all were there that day?
That's fine. She wasn't doing that.
Okay. Let me ask you this. When you first showed up, what happened and what did I say to you exactly?
Again, you told me that it was a civil deal and asked why I was there and doing all of this.
And why would I say it was a civil deal?
Because I believe that you believe that they owe you money.
No, that was not it at all. That was because I was storing the items for them and they never
Objection,
paid.
Your Honor. It's not his turn to testify. Is there a question in here somewhere?
The objection is sustained. Formulate your
Sorry.
next question
Sorry.
to this witness, Mr. Carter.
Sorry. Do you not remember any conversations about them owing me rent for storing the items?
I do remember you telling me that.
Did Kim ever tell you that I was storing items for you?
No.
Your Honor, at this time, I would like to submit some evidence, some video evidence of this witness actually stating the opposite of what he's saying right now on the Ring camera of accounts that had happened that day. But I'll let him go further. I got a few more questions before I do submit that, I guess, just to go ahead and nail this down. I do apologize. Okay. And you also said that I told you that the dirt bike belonged to Tim?
Yes.
You said I said that? And when did I
Yes.
say that to you?
You said that when we showed up with the second search warrant before you were taken to the Butler County Jail.
And you also stated that when you came to the house the first time on the first search warrant that the motorcycle wasn't there?
Correct.
And on that list of stuff that you took, you said that you were the one searching through everything and Tim and Kim were kind of in the background looking over your shoulder. Is that correct?
Yes.
Okay. And they didn't search through anything themselves by hand, right?
They looked through some stuff, yes, after I looked through it, when they were verifying what was theirs. For example, like I'd pick up a container and it'd have stuff in it, I'd look through it. And then either most of it was Tim, he'd look through it, finding what was his.
Okay. If I was storing the stuff for them and had their permission to take the stuff to begin with, would that make this case criminal?
Yes.
It still would? How would that be?
After you started selling their property?
If So can you state that statute of abandoned property for me? Do you know what that statute is?
I know what the theft statute is.
And what's the abandoned property statute?
I don't know what you're talking about. That's not a criminal statute that I know of.
Mr. Carter, I'm not going to get into an argument between you and this officer regarding.
I'm not arguing. I'm just asking him if he knows what the statute is. That's all.
I think he's answered the question. Let's move on.
Okay, then he was still talking. I didn't interrupt him.
Let's move on, Mr. Carter.
Okay. So whenever you showed up and arrested me right away, did you ever read me my Miranda rights?
No,
Ever? The entire time I was arrested?
no, and I didn't question you either.
Okay. Did upon my request, was I taken straight before a magistrate that day?
I have no idea.
I wasn't. I was taken straight to the jail. But either way, do you know what the procedures are for whenever you arrest a person out of your county's jurisdiction for a crime that may have been committed in your county? Do you know the procedures for that to arrest someone, what you're supposed to do or whatnot? Whenever you arrest someone in another county from your jurisdiction without a warrant?
Yes,
And what would that be?
if I have probable cause to arrest you, for a crime that you committed in my jurisdiction, I can arrest you. And
I understand
typically
that.
we call the jurisdiction in which you're in to come assist us, which we did in this case as well.
Okay, what else?
That's it.
And what about if the defendant is request that time to be taken in front of a magistrate closer?
Mr. Carter, that issue is not before the court. This is a preliminary hearing to determine if there's probable cause that a felony crime has been committed and that you committed it. We need to limit the scope of the testimony to those issues. That's what's currently before the court, and this current line of questioning, it does not go to the issue of probable cause. So you'll need, if you have further questions that are relevant, you can ask those now.
Okay. So can I ask him, Your Honor, about his knowledge of the statutes of the Kansas law?
No.
I can't?
No. It's
Okay.
not, his knowledge of the law is not relevant to the issue as to whether the state is showing probable cause.
Okay. All right, I got you. So can I submit evidence? Well, the state has submitted evidence to me that that they're using against me. And one of those things are included are Tim and Kim's initial report of this theft, quote unquote. And do you, Amber, do you have that video available to play by chance?
Mr. Carter, I'm not sure what you're referring to.
The video from the detective or the officer that took their initial on 12/7 of 21 when they came in person to the lobby and made their report. There's 2 body cam footages of
Mr.
video.
Carter, I'm not going to require the state's attorney to submit evidence that she doesn't request to submit.
I'm asking, okay, because I'm not on my laptop now, Your Honor. All of my stuff is on my laptop. I'm on my phone now because my microphone wasn't working on my laptop. So I'm gonna try to pull it up on my phone. I don't know if I'm gonna lose you. Can y'all still hear me?
All right, this isn't time for presentation of your evidence.
I'm not, it's testimony from Tim for him to cooperate with what he's saying that never mind, just do whatever, it's okay. Let me ask him a few more questions and I'll be done with him.
All right.
Are you still there?
Yes.
Okay, I'm trying to find my Zoom call here again. Here we go. Okay. So you're also stating that There was stuff in the driveway in a box trailer, is that correct?
Yes.
Okay. When you, just to clarify though, whenever you came and arrested me right away, the first thing I said to you was that was Tim's motorcycle, correct?
I'm not saying that's the first thing you said to me.
Okay. But it was around that time though, right?
It was during that conversation.
Okay, before I was taken out to the car?
Yes.
Okay, just, that's well enough for me. All right, that's all I need. Thank you.
No more questions then, Mr. Carter?
Nope.
All right, Ms. Norris, anything further for Mr. Shiner?
Not at this time, Your Honor. I don't know that I would necessarily need to recall Lieutenant Shiner, but I would ask that he stay with the meeting.
All right, very well. If you go ahead and mute yourself at this time, Mr. Shiner.
Yes, sir.
Thank you.
And Your Honor, one more brief witness, Tim Bishop. I believe he's in the waiting room. I think he was the iPhone, but I'm not absolutely positive.
Mandy, can you bring Tim Bishop into the meeting, please?
And I asked that the witness that just got off the stand go back into the waiting room.
Request denied. He's completed his testimony before the court today, so he's allowed to stay.
Okay, well, the last hearing, I wasn't adequately, I didn't have all the evidence that the state had against me in front of me because they never provided it to me until like the 12th of this month. Tim and Kim are witnesses together in the same household. She was able to give her testimony with the other witness there, and now he's going to give his testimony with her there. And I still had questions for Kim as well that I wasn't able to ask last time because I didn't have the evidence that I have in front of me now. So it wasn't a very adequate cross-examination, Your Honor.
Well, Mr. Carter, I'm not aware that there is a preliminary hearing right to discovery. So I don't think that that's really objectionable. Furthermore, I'm inclined under the circumstances to allow Mr. Carter's testimony, even though he may have listened in on his wife's testimony. The purpose of this line of questioning, Ms. Norris, would be what?
Your Honor, just to talk specifically about the tools and that kind of to confirm what Detective Scheinert had just been referencing and his ability to identify that sort of thing. I don't have a lot of questions for Mr. Bishop.
For that purpose, the court will allow his testimony. So, iPhone, if you can join with video and audio, please. Mr. Carter, your video went away.
Oh,
Okay,
sorry.
you're back.
Sorry, I'm trying to pull up evidence. Sorry.
Okay. Again, iPhone participant, if you could go ahead and join us with both video and audio.
Am I on?
You
are on.
Audio. Let me figure out my video. There we go.
Okay. And this is Tim Bishop that you're calling as a witness. Is that correct, Ms. Norris?
Yes, Your Honor.
All right. Mr. Bishop, if you'd raise your right hand, I will administer an oath to you at this time. You do solemnly swear that the testimony you're about to give in the matter now in hearing shall be the truth, the whole truth, and nothing but the truth. So help you God.
I do.
You may question the witness, Ms. Norris.
Thank you, Your Honor. Please state your name and occupation for the record.
Timothy Bishop, owner of Total Installation, partial owner.
Okay. And what type of things does your business Total Installation do?
We do commercial interiors for the most part, which would include almost anything on the commercial interior side of flooring, furnishings, that type of finish. Division 9, Division 10.
Okay. And at one time, did the defendant Mark Carter work for you?
Yes.
Okay. And in what capacity?
As a installer.
Okay. And when he was employed with you or thereafter, had you allowed him to take items from your warehouse?
When he had asked, I had allowed him.
Okay. And what, just give me an example of something that he would have asked to borrow from your business.
Our carpet stretchers, our tile equipment, that type thing.
Okay. And if he had asked to borrow it, you would generally say yes when he was employed with you?
Yes.
And as long as he would return it?
Well, absolutely.
Okay. And at some point, Mr. Carter stops working for you. Do you recall about when that was?
I believe that was mid-November or around there
Of
2021.
Okay. And after he stopped working for you, did you notice some items that had gone missing?
Yes.
And did you notice items that had gone missing over a period of time, or did you notice them all in like right after he stopped working for you?
That's hard to quantify. We had just moved product to a storage area from our warehouse. And so in organizing and moving that stuff around, I can't give an exact answer as to when I noticed it mostly was when my equipment disappeared, which was all at one time, basically.
Okay. And so you notice that you've got equipment that has disappeared. You make a police report.
Yes.
And did after it disappeared, did you end up adding additional equipment to it as you were you noticing other things missing, or did you really notice like one giant thing and then that's it?
Well, as I said, we moved out of 12,000 square foot warehouse. I didn't say that, but we did. It was racked to 3 levels high. So currently
a lot
on
of stuff.
site, yeah, a lot of stuff. On site over at my storage area, we currently still have 3 semi trailers full of product. I've got a storage unit full of product, and I had product sitting outside. Also, when we moved out, that we couldn't come up with trailers for storage for that product. So it was set outside in the storage area, and then we were asked to move it around to accommodate the owner of the property.
Okay. So at any time after November of 2021, had you had any items that you were willingly storing, that you had asked the defendant to store on behalf of you or your company basically as a business agreement?
No.
Okay. And had you given the defendant permission to take any of well, let's see, your Yamaha motorcycle,
No.
your Blast Pro shock blaster machine?
No, absolutely not.
A variety of miscellaneous tools, hand tools, welder, those.
No.
Do you allow him to take any of those items after he was no longer employed with you?
No.
Okay. And were you present when Lieutenant Scheinert and the Andover Police Department served a search warrant at the defendant's house?
I was not there when they served it. No, we arrived after they had served the warrant, I believe.
Okay. So were you there and to help go through and find and maybe figure out if some of the property at that residence on Flint was in fact yours or your business's?
Yes.
Okay. And how did you go about identifying property as being yours and belonging to you or your company?
We had pictures from our warehouse and from our storage area of the products and items that we had taken. And so that's the items that we were looking for. I realize now there was more items in there that we didn't identify as ours, it should have been, but anyways, that's how we identified. We had our list, but we also had pictures of the products and equipment and things that were in our possession in our warehouse and at our storage. That I mean, I've been doing this for almost 30 years, and I've accumulated a lot of stuff, things that I know are mine. I mean, things that I can identify readily without having a tag on or whatever. It's I know the dings and the nuances of the tools.
Okay.
So
Give me some examples. Give me some examples of dings and nuances of the tools that would help you that helped you identify items that you were locating that day.
Such as my tiles cutter. It had some of the pieces were loose that wouldn't be normally, and we've used some aftermarket parts to put it back together. Those are on it. I mean, there was simply a cash box in there that had our tag still on it. My carpet stretchers, they were, I believe, they still had a tag or two inside the poles on those. But as you use things, you become familiar with them. So that plus the pictures identifying specific things. I mean, there was a toolbox that I thought was mine that we pulled out, but then ended up not being mine. And so we put it back. Just that type of stuff. I'm sorry, I don't have any specifics of a particular.
Well, no, that's what you said makes sense. You mentioned tags on items. Tags is in like what kind of a tag?
There would be little metal stickers that we would use for our equipment for a job site. So we'd take them out and we would know what was ours to bring back.
And so what would it say on the tag?
It said total installation on the tag with our address and phone number.
Okay. And did you have specific marks or paint or anything on your tools?
Some of that was we had hired a new guy and we were trying to 5S our warehouse, and so we had red paint on a lot of tools, but we hadn't made it through all of the readjustment of that to mark and identify all the tools with red paint, but some of them or a lot of them had red paint.
Okay. And that was a way you used to identify or to mark them for your knowledge as your company.
Yes.
Okay. And when the defendant left your employment in November of 2021, was it under good terms or no?
No.
Okay. Your Honor, I don't think I have any further questions. Thank you, Mr. Bishop. Stay where you are. I'm sure Mr. Carter's going to have some follow-up for you, okay?
Okay, thank you.
Mr. Carter, do you have any questions for Mr. Bishop? You ask the question, he provides the answer.
I do, Your Honor.
All right, you may proceed.
Okay, Tim, did your wife, Kim had testified the last time that we were in court that y'all were evicted out of your warehouse. Is that correct?
Yes.
Can you kind of give a little bit of a rundown and circumstance around that whole deal?
Objection, Your Honor, outside the scope of direct and not relevant to this particular hearing.
And how is
Yeah.
that relevant to probable cause, Mr. Carter?
Because it leads to the backstory of why I was storing the items for him in the beginning.
I'll give him some latitude here. Objection overruled at this juncture.
Thank you, Your Honor.
Could you repeat the question, please?
Yes, sorry. Can you kind of give a little bit of a background on why you were evicted from the warehouse in Bel Air in the first place?
It had to do with a larger story of an incident or a lawsuit from back in 2016 or 15 that was still currently going on at that time. We had been paying attorneys and had basically came to a point where we needed to downsize. We had made an agreement with our landlord about what our rent should be and things, but his kids took over and didn't necessarily abide by the agreement. But so we were evicted. I didn't want to take that to court, and because I really respected the landlord that I had for 20 years. So we moved out.
Okay, Mr. Carter, if you can now focus on whatever storage issue you were wanting to address.
Yes, and how long, just abruptly, how much do you think you owed to the landlord at the time of eviction?
Objection, Your Honor, not relevant to probable cause.
Okay, Tim, did you make any insurance claims on any of the stuff that you reported stolen?
No.
At any time?
No.
To this day, you haven't made any?
No. I had no insurance at the time.
Okay. Did we have an agreement for me to store any of your items at all?
No.
Not at all. We never had a conversation about it?
No.
Okay, that's good to know. Your Honor, if I'm trying to pull up the video of his interview that totally impeaches this witness right now against what he's saying. How do I do that on this app on my phone? I have the video on my phone, but I don't know how to pull it up to submit it into evidence.
You're asking me how to present your evidence?
No, how to do it on the app. I could do it if I was in a court, in a real court in person with a video, I'd have it there, but I don't have that option because we're on this Zoom call stuff.
Okay, and the relevance of his prior interview?
It contradicts everything he's stating right now, Your Honor. 100% contradicts everything he's saying right now. About not having a conversation about, he admitted all of that on the 7th of December in 2021 to the officer that took his initial report from him and his wife. I just watched the video this morning.
All right, well, you can ask him about any inconsistencies about any prior statement that he's made.
Okay. So Tim, whenever you made your initial report on December 7th, 2021 to the officer at the Andover Police Department in the lobby, do you recall what you told her that day?
No, I don't.
You don't at all?
Nope.
You just have no memory of even meeting her?
No, I met her.
Well, can you kind of give a rundown of a conversation that you had, if you had one?
I just said I don't recall what the conversation was. If I could see my video of it, I would clarify anything that's in there.
But so you can't recall anything you said to her whatsoever that the whole day?
That you had stolen property from us? Yeah.
And that's all you said?
I'm sure that's not all I said.
Okay. Do you recall any text messages that me and you had during that time frame as well?
I don't. My phone has been, I've been through 2 phones since then. Those conversations are gone from mine.
Okay, I still have them, thank God.
Okay.
Well, I do
If those
have
are
the
submitted as
evidence of
evidence,
the conversation, and I was gonna ask you, do you recall ever asking me why I was clocked in at an odd time that you didn't think I should have been clocked into the ClockShot app?
I don't recall that, no.
You don't? Okay. Do you recall paying me fuel for the box truck to haul the tools from the location at 13th to my house?
No, I paid you for fuel to take the products from the trailer that was at Larry's trailer to 13th Street in Andover, where our storage was, that I discovered that whole trailer's load of products gone too.
Okay, you mentioned Larry's trailer. Why was your Larry's trailer? Why did I have to go get this stuff from Larry's trailer?
Because it was on the trailer there.
And why was it at Larry's though? Why wasn't it out there at the 13th place where it had been?
Because they took the trailer to his place.
Because you didn't pay him rent?
We paid him rent. We obviously got the product.
So you were up to date current with him on the rent on that trailer
Yes.
that he repossessed? Okay.
He didn't repossess. I never owned it.
Oh, you were renting it, correct?
We ended up renting it, yes.
Okay.
Having
Do you
some real
still have any
difficulty
trailers for him?
with the
Do you still
relevance
have
of
any-
all of this questioning, Mr. Carter. I don't see how it's
The relevance, Your Honor, is he's renting trailers from a place where they came and repossessed. I was working out there at the time. They came and repossessed the trailer from him because they couldn't pay the rent for the storage trailer. So they came and took it with all of his stuff in it still. I had to go unload that stuff. He had nowhere to put it. He asked me to put it at my new place that I got. So I did. I felt obligated to help them out because they were going through a lot of stuff at that time.
All right, then stop there. All right, Mr. Bishop, based on what he just said, is that correct? What he just related?
Well, I'm sorry, which part?
Okay, fair
There
enough.
was no
fair enough. The
repossession
part
there.
where supposedly you wanted him to store some stuff for you because you didn't have another place for it.
No, he was supposed to be taking it to 13th Street.
All right.
To our storage area.
Okay, so at the 13th Street storage area, were you getting in trouble for all the stuff that was outside?
No.
Your Honor, he
I still
just
have storage
testified
there.
to it earlier that he did, just a few minutes ago. You had to move it
That
around.
had nothing to
correct?
do with what was there. It was where it was at there.
Okay. So you weren't getting in trouble for the stuff that was stored out there at 13th Street?
My product is still there, part of it. I mean, the part
That's
that
not my
you haven't
question.
taken.
I'm asking you, you just stated earlier, you were getting in trouble for the stuff that was up there being stored. Is that correct or not?
No, my product is still there. It was the owner asked me to move it from where it was, which we had done.
I'm not following. Can you repeat that again? Explain that a little better.
It's a large lot. He asked me to
Okay.
move it away from the building, which we
Okay.
did,
And where did you move it to?
away from the building.
And what exactly did you move?
Objection, Your
Whatever
Honor,
was-
relevance.
Objection sustained. Mr. Carter, I again, you may see that there's some sort of relevance to this line of questioning, but the court doesn't. When it
Okay,
comes to
well, Your
narrow
Honor,
issues which are currently before the court.
he just testified just a few minutes ago that he was getting in trouble by the owner lot up there, that he had to move the stuff from the location.
All right, he's given his explanation, Mr. Carter, so.
Okay, but then
Where are we
he
going
goes
with it?
against that. He went right against saying that, so. Okay, relevance, I guess not, right? But anyway, so the welder did you ever have any text messages with me about the welder, me coming up and welding anything on the trailer that broke during the time that we were loading everything out of the warehouse when you were evicted?
Mark, I don't have those text messages. I don't remember.
But do you remember that time frame, right?
Do I remember that time frame?
How did you
Yeah.
obtain the welder from me in the first place that you claim is yours?
I didn't obtain it, Mark. You brought it. You traded it to me when you took the carpet out of the warehouse and the bedroom suit that we traded.
Well, I traded you the welder for that.
Along with a torch, oxygen, and acetylene setup. And you were supposed to give me 2 toolboxes, of which you give me 1.
And I was supposed to give you a welder too. Is that what you're saying?
Yes.
Okay. Well, I have messages for that as well. Now, let me ask you, did you, hold on, let me backtrack a little bit. When you found the box truck, where was it located?
In front of your
Whenever you
house
came
on
to-
Flynn.
Whenever you came to get it for the last time from me, where was it located?
I found it on Flynn. You didn't tell me where it was.
Okay. You found it on Flynn. It was on Flynn's. Was it in front of my house or down the road from my house or where?
Got pictures of the area, but it was right by your house.
Okay. And it wasn't a few streets over or anything like that?
Objection,
No.
Your Honor. Again, relevance to probable cause for this charge has nothing to do with the box truck.
The objection is sustained.
Well, it has to do with the credibility of the witnesses, Your Honor, because they are obviously can't keep their story straight. His wife just testified the last time.
Objection, Your Honor, he is
The box truck was found a few streets over.
testifying.
Mr. Carter, I've made my ruling. The objection is sustained. If you have other questions for Mr. Bishop.
Yes, I do.
Okay.
So did you have the serial numbers to the Lincoln welder prior to the search warrant being conducted that day?
I believe so, yeah.
You believe so? How would you have gotten that?
It was in my warehouse. There's pictures of it, Mark.
Okay. When you left the warehouse, did you leave anything in the warehouse or was it completely empty whenever you were evicted?
There was still product in the warehouse.
How much product was in the warehouse do you estimate?
Mark, that's a hard estimate to throw. I've got pictures. We've been there since. We've been,
okay.
I get along with the landlord fine, Mark. We've been back over there and picked up product. I've taken pictures and videos while I was in there.
Would you recognize this letter right here from your landlord? Hang on. Can you see that?
It's very, very small. I mean, what's the point?
Can you read that though?
No, I can't.
You say you're on very good terms with the landlord. That's Buck Alley right there wrote that letter.
Okay, how is his relationship with his landlord relevant to the issue of probable cause here?
Because I'm breaking his character witness down, Your Honor, because he's lying again. And I just spoke with Mr. Buck Alley just 2 days ago, and I've got the letter from the guy. He signed this. He typed it up himself. This guy's he's like 90.
Objection, Your Honor. Mr. Alley is not present, and I still don't see the relevance.
Okay.
So hearsay and relevance.
Carter, I also sustain that objection by the state's attorney. Again, focusing on the elements of the crime in this case.
Okay.
Mr. Carter.
Tim, how come you didn't report your dirt bike supposedly stolen back whenever you made the initial report for the truck in 2021? When did you report the dirt bike stolen?
I don't recall which I mean, when we made the initial report, I was expecting detectives to contact us and follow it up. So there was a few initial things, obviously large stuff, such as my shot blaster and my large grinder, which both of those I use to make a living at, Mark. That were missing. So those were part of the initial statement, but they're, I believe, part of my initial statement probably would have said a bunch of other stuff. So a bunch of other stuff is, I mean, I still don't have a complete, I mean, there's still things coming up missing. So
are you implying that I took those as well?
I'm not implying anything, Mark.
Okay, I'm just asking. Okay. Now, the tools that were there at the 13th storage, were they stored inside or outside, Tim?
Outside.
And are these electric tools? Do they run off of power? They got electric motors?
Some.
Most of them? The big
Some.
machines like you're talking about, like the shot blaster?
Yes. Yes.
Okay.
That's why we had them
weather
tarped.
good? Are they weatherproof?
No, that's why we had them tarped. That's why I paid you to tarp them.
And did the tarp stay on them all the time?
They did after I reattached them.
After you reattached them? Okay. Nothing got ever wet out there ever?
They could have.
Okay. So how much, and as expensive as those machines were, you didn't have anywhere to store them inside, correct?
At the time, no.
Okay. And at the time, correct? So there was never a time where you were having me bring the tools out from my place where I was storing them to bring them to you or to Jimmy, our other employee there. Was there ever any of that kind of a back and forth at all?
From what I recall, you had taken something to fix it, and we had asked for you to bring it back, which you did not until after we had needed it, and that was done.
To fix what?
I believe that was a one of the scrubbers, or not a scrubber, but a buffing machine or something like that. And I think you had some of my grinding bits for the grinder, which I'm not sure why you had, but I asked for those back, which you never responded, never brought back.
I never responded back to you
on those. No.
Okay.
Not that I remember. I mean, like I said, you have the text, obviously.
Yes. So, but we did have back and forth conversation about tools that I'd had during this time frame of November, mid-November, correct?
Some small pieces. Yeah.
Bits and small pieces, nothing big.
Mark, you've got the texts.
Okay, I'm
put them in front of me. We'll talk about
asking you to recall from your memory, Tim, because you have a memory, correct?
I sure do.
Okay, well, that's why I'm asking. So
how much did you ask me? Or never mind.
The box truck, you stated that there was something wrong with it whenever you picked it up.
Your Honor,
Of
relevance,
box
again.
questions here, Mr. Carter. I agree, Ms. Norris.
Okay, sorry.
I don't think the box truck is an issue here.
Well, it was reported stolen, and they claim that I stole it, and I never stole anything from them.
Okay. Doesn't appear to be part of the charges in this case. So.
And speaking of the charges, what are my charges, Your Honor? Because they charged me with theft, and then I got another charge that nobody ever even told me about a few weeks ago. I've seen it online. I never even was served any papers about that.
Your Honor, might we finish with testimony before we get into amended informations? It is not a felony charge, so it's not.
I agree.
Part of this preliminary hearing.
All right,
I
fair
agree.
enough, Ms. Norris. Anything else for this witness, Mr. Carter?
Hold on, let me read through my notes real fast, sir. Hold on, let's see. When you were at my house doing the search warrant, were you the one conducting the search there that day, or was the detectives doing all the work and you were just kind of looking around over their shoulders, not going through stuff?
The detectives were pulling and recording the product.
Okay. Do you know were you aware that I had a Ring camera up that day recording as well?
No.
Okay. Do you recall taking anything out there that didn't ever belong to you prior to your abandonment of the property whenever you didn't pay for the storage cleaning?
What was the question?
I said, did you take anything from the garage that day or my house during that search warrant conducting that had never belonged to you or that wasn't a part of the abandoned property that you didn't ever pay storage on?
There was no abandoned property.
There was none? You didn't abandon the property to me whenever you didn't pay
No.
me for the storage?
Is there anything? Did you have anything saying that you charged me storage for something?
We had a verbal agreement.
Oh, we did? I don't recall that at all.
And we do have back and forth conversations over text messages that.
Of an amount or what? What's?
Not necessarily an amount, but the fact that I was on the clock working during the times that I moved it.
Objection, Your Honor. If Mr. Carter wants to testify, this is certainly not the time for it.
I understand.
Court agrees. Any other questions that Mr. Bishop can answer?
Yes. I'm almost done, Your Honor. Did you ever tell the detectives that I was storing any items for you at all during any conversations or reporting?
I don't recall, Mark.
Do you recall?
I sure as heck didn't tell you to sell anything. If you were storing anything, I don't recall that. I don't recall having a conversation with you about storing anything.
Okay. Do you recall if Kim ever told the detectives that I was storing any items for you or Kim?
Objection,
That would be
Your Honor.
hearsay.
That's a whole other witness who has already testified.
Sorry.
All right. Next question, Mr. Carter.
Yes. Was I a good employee, Tim?
Most of the time.
Most of the time. Did you ever have any trust issues with me? As far as like taking stuff that didn't belong to me and whatnot?
Not until the end.
Okay. But for the most part, I was a very loyal employee to you and through all the thick and thin that your company and your wife and your family had gone through at that time, correct?
I don't know.
Objection, Your Honor. Relevance.
Objection sustained. Carter, let's stay on task.
All right. Okay, I guess that's all for now, Your Honor.
Any follow-up from Mr. Bishop?
I don't believe so, Your Honor. Thank you.
All right. Bishop, you can go ahead and stay with the meeting if you like, if someone asks you to mute yourself at this time, or you can leave it at your choice. Okay?
Okay, thank you.
And Your Honor, I have no further witnesses at this time. I'd ask that all the witnesses be brought in so they can all be allowed to leave at this point,
Andy, go ahead.
if they so choose. And Your Honor, I would make an amendment on the record to add basically an alternative of possession of stolen property for, and I would specifically add the Lincoln welder, and I will amongst the miscellaneous tools. And I think that's it for my on the record amendment.
Would it be level 9 non-person felony theft charged in the alternative?
Correct, Your Honor.
All right, and I trust you'll be following this up with a written amended information?
Yes, Your Honor. Thank you.
Mr. Carter, anything you want to say about that?
Oh, yes, Your Honor. I believe I've already provided text message or email proof that before 2021 that the welder was mined in pawn shop, and had because I'd weld with it, and then I'd pawn it when I needed the money, and then I'd get it out. Okay.
That goes to the defense of the charge against you rather than the state's ability to charge it.
Okay,
it's going to allow the amendment, and I'll direct the prosecutor's office to follow up with an amended information in writing filed with the clerk's office as soon as possible. Anything else, Ms. Norris?
Not from the state at this time, Your Honor, other than if the witness would like to be released.
Oh, indeed. Mr. Snedeker, and then I think there's a Mr. York and Mr. Sine, is that correct? All right, all of you apparently, and Kim Bishop, apparently all of you may have been asked to be present to testify today. The state's concluded their presentation of evidence at the preliminary hearing. I can release all of you from the meeting at this time if you so desire.
Thank you.
Thank you. Thank you for your patience this morning. All right, Mr. Carter, do you intend to present evidence at this hearing?
I do, but like I said, my laptop is the only way I could do that. If I presented the evidence, I'd have to get on and log back onto my computer through the Zoom, but I would not be able to communicate via voice through the laptop. Is there a way that any of your staff know that I could keep like a phone call going where audio through my cell phone on a phone call or something, while I can do the Zoom video and evidence presenting on the Zoom through my laptop?
All right. First of all, Mr. Carter, it's really unusual. In fact, I'd even use the term highly unusual for the defendants to even present evidence at a preliminary hearing. And there's one fundamental reason for that. And that is that when there's a conflict of evidence, this court at preliminary hearing stage must resolve those doubts in favor of the state's position. In other words, looking at the evidence in the light most favorable to the prosecution. So if you're challenging the state's evidence or credibility of a witness, the state is still entitled to a favorable determination from this court at this juncture regarding any disputed issue. So what is it that you were wanting to play? And what is its purpose?
Its purpose is to impeach every witness that the state has had on the stand at this moment. Every witness that they've called has contradicted what has on my records and through the court records that was given to me through the discovery is a straight 100% contradiction to the testimony that was given today and prior by all witnesses. And I was going to ask you if I would be able to present that today. If I know that I have technical difficulties, and it would be easier for me to explain it, or can we call for a special hearing that could get me another laptop and download everything on it, and maybe in another week have a special counsel hearing to present my evidence for this? That would, because it's very straightforward, and it's audio and video recording mostly of contradicting testimony that was just given to what they've stated that they did not say, including the detective.
And Your Honor, I have no idea what this evidence is. I have not received anything from Mr. Carter.
Your evidence that you gave to me through the discovery was one of the videos that was Tim and Kim Bishop giving their interview on the 7th of 2021 in December. It has Tim Bishop clearly stating that we were having back and forth. I was having tools and he was getting tools from me. And even the detective the lady taking the interview stated, so he was storing stuff for you. And
Your Honor, I would object to him testifying about a video that he did not create, or that he is not present for, or that he has no, records custodian, etc., to present.
you presented it to me through the evidence. It's in the discovery.
I'd still make the same objection, Your Honor.
Which the court will sustain. Mr. Carter, do you intend to present any witness testimony at this hearing?
I didn't know I was allowed to, Your Honor. I thought it was the state's burden to prove they had.
It is.
Okay, and let me ask you this, Your Honor. Am I presumed innocent by the court at all times until proven guilty?
Yes.
And you're the one that upholds that, correct?
I do my best to do so, Mr. Carter.
Okay. And I expect that from the court here. As far as the evidence that would be more in light favor of the prosecution at this stage, isn't this the only time I can present my evidence and arguments before a plea? Before I waive any rights to any such arguments? I'm not asking for advice, I'm just asking a direct question of the court.
You're entitled to a trial on the merits. I presume you know that.
Yes.
That is not what today's hearing is. Your guilt or innocence will not be determined today, Mr. Carter, but rather.
Oh, I understand that.
At a
But
trial.
if I can show now, before even a trial has to come, the evidence that contradicts testimony from all the witnesses that the state has brought forward in their offense and against me is saying that I've committed a felony crime here. To the contrary, I have enough to hold all of them in contempt for you to be able to do that, because it does. I know that I don't have the money to pay for the testimony to be recorded back through verbatim or through however the recorders do that. Transcribe. Yes. I don't have the money to pay for all of that. I don't, but I would like for a copy of all the witnesses' testimony in verbatim and to be transcribed, to go back over with the video to show the court exactly what I'm getting, my point of view here and my arguments. That's the only way to do that. But I'm at a part where I don't have the money to afford to have that transcribed on any of it, but I need it.
All right, have you filed a written motion with the court for that recording or that witness testimony?
No, I did. I was directed that you would have to, that's why I emailed, and I do apologize for that.
We're not going to deal with resolving motions by email, Mr. Carter.
Okay, I understand that.
Okay.
But I was just directed that I had to contact your office through that if I was to obtain that without a court order. So if I have to file a motion, I will. Can I get the ability to be able to file motions electronically so I don't have to drive all the way out there to El Dorado?
I don't think that the Kansas Supreme Court has authorized pro se individuals to electronically file.
Okay, I was able to do that in a pro se case against an employer of mine in federal court. I was able to electronically file.
This isn't federal court.
I understand that. I just didn't know if it kind of correlated into the same system or not.
No.
Okay. There's no way to get special authority to do that.
Not that I'm aware of.
Okay.
And Your Honor, are we complete with prelim?
We're getting there, Ms. Norris. We're trying to get to that. I'm just as interested in that question being resolved as you are. Mr. Carter, so where are we here?
I would like to present my evidence in the contrary to that, but I would like to set up a hearing for this so I can have my electronics working where I can be able to upload it through, because we're limited on the Zoom here. It's not in person. I could have it in person. If we had a hearing in person, it would be a lot easier to present it because I'd have it all with me. But on this, there's technical difficulties, and that shouldn't hinder my ability to defend myself here. You understand?
Okay, well, Mr. Carter, I'm just trying to let you know, I realize you're not a trained lawyer, even though this court has admonished you in the past that you would benefit greatly from having an attorney represent your interest. You've insisted on representing yourself, and you do have a legal right to do that. But I also need to inform you that prior to the trial, the court is not going to, except for certain limited circumstances, I'm not going to get into credibility issues regarding the witnesses. Again, the state's entitled at this juncture that if there's conflicting evidence, even if you present something to the contrary, I have to resolve those doubts and consider the evidence in the light most favorable to the prosecution at this stage. Now, that doesn't hold true at time of trial, but it does at this stage. So if you're going to present a video, which I'm not even sure you've laid a proper foundation for, or even have the ability to present, purely for the purpose of impugning various witnesses' testimony, it's probably a futile act on your point, because this court must construe the evidence in the state's favor if it conflicts.
If it conflicts
with anything you've got to present.
I mean, either way, I still would like for the court to allow me to present that and take that matter up before trial. Just to, if we can avoid trial, I would rather avoid trial. I don't want to have to, and if I have to obtain a lawyer, I don't want to have to pay for a lawyer for trial if I don't have to. That's why I want to present. If there's a conflict, from what I understand, if there is a conflict in the evidence or testimony, and there's evidence to provide to the court that would totally be exacerbating to that, like it totally and I have to file a motion for the prosecution as well. That I'm busy writing right now on my motions actually to file to the court before I do any pleading or any of that. I want to get it at this stage here while I still have my rights and they're not waived in any way. And I want to reserve all of my rights here moving forward as well throughout this entire proceeding without prejudice, because I'm being accused of a felony wrongfully by bad actors here. Even now,
now you're making argument here.
I'm pleading to you that I need to submit evidence to the contrary. Even if you can't weigh it in my favor, that's fine. I want to get it on the record, and I'm just not allowed to do that like I thought I was earlier, because my microphone is not working on my computer, and I don't want that to be.
Your request to continue this hearing is denied, Mr. Carter.
Okay.
I mean, this is the second hearing, not the first, and you were quite aware that we were going to be continuing the hearing by Zoom, and I would have expected you to make any technological arrangements necessary to present any evidence that you intended to present, including laying a proper foundation before any videos or audio recordings are played. So,
and what would be the proper foundation to lay?
I'm not going to give you legal advice.
Well, I'm asking you. That would be that would impeach everybody that was on the stand, Your Honor, that I have direct evidence to put in front of your face to let you judge for yourself, that says this guy said something that was not true. 100%. He lied directly to my face. He said the opposite of what he said on the video at my house on the Ring camera.
Your Honor, I object to him testifying and or, dragging people's, testimony through proverbial mud at this point without.
Your objection has merit. Ms. Norris, and the court will sustain it. Really, we're just getting down to a fundamental question. Are you going to call any witnesses today, Mr. Carter?
I'm not gonna call any witnesses today besides myself.
Besides yourself?
Yeah,
Okay.
can I testify myself?
So if you're going to consider testifying, the court's going to admonish you at this point. You understand that anything you say in this hearing can be used against you in any further proceedings, including your trial on the merits. You understand that? Your jury trial or a trial to the court or whatever the case ends up being. Anything you say today, if you say anything incriminating, can be used against you. Do you understand that?
Let me see.
Also, I need to tell you that you've proceeded on your own. I must caution you about trying to proceed with your own testimony without an attorney's advice or assistance.
Okay. I will hold off on testifying today then, and if I could, what is our next stage after this, Your Honor?
Well, I have to make a ruling on probable cause first.
Okay.
Which, since both sides have rested, I can now do. The court does find that the court finds probable cause from the evidence presented that the defendant, Mark Anthony Carter, has committed the crime of theft, a level 9 non-person felony. That felony crime has been committed, and that the evidence does indicate that Mark Anthony Carter committed it. So he is bound over for trial on the felony charge of the information, noting that it is now a charge in the alternative. We're going to proceed to formal arraignment at this time. Except, well, perhaps I'll have to continue that because I don't have the current charging document before me. Were you asking for a reading of the information, Mr. Carter?
Yes, I would also, I'm going to file a motion for,
Okay.
I'll just do it in
My
writing.
question
I'll do it
was,
all in
do
writing.
you want the information read to you?
Yeah, no, I don't, not at this time.
All right.
I know, I would like it to
So,
be filed. Get it
all
that
right.
way.
Very well. And then what plea is being entered, Mr. Carter?
I'm not gonna plea at this moment because I want to present my evidence
All right.
before I plead.
That's fine. And then the court will enter a plea of not guilty on behalf of the defendant. And we'll
How do
start
you
with-
move how are you moving the court without my consent? on that?
Because you declined to enter a plea, the court will enter a plea of not guilty. I'm sure
I
you
didn't
wouldn't want me to
decline.
enter
I
a plea
just
of
didn't at
guilty.
this moment. I didn't say I wouldn't.
Well, but this is arraignment and it's time for you to enter your plea. So I'm going to enter a plea of not guilty. Set this matter for both pretrial conference and jury trial settings.
Well, I don't want to waive any rights to my defense either, or my arguments at this
I
time.
don't think anything is implicit here that you've waived anything, Mr. Carter, except maybe your right to have the information read to you. All right. I'm going to set pretrial conference the week before the jury trial, which I'm going to put on the docket, Ms. Norris, of Tuesday, October 3rd. Tuesday, October 3 is day one, 9:00 a.m., unless otherwise announced later. October 3, 9:00 for jury trial.
Your Honor, I'm not going to be available on the 3rd or 4th.
Is that because of a conflict on trial?
No,
Okay,
personal.
fine.
Does the court have a September date?
I do. I'm looking
I
now.
can't
to
do
see what's
September,
there.
Your Honor.
What's that?
I can't do September.
Why?
I have family that comes in around that time, and we do a lot of, we're never around the house at all with the kids because it's right at whenever they're at school, we're visiting. And when they're not at school, we're out and at one of the lakes here in Kansas visiting. And that's just the month of September for our family. That's an every year occurrence.
Ms. Norris, if you would take a look at your calendar for Tuesday, October 31.
I'm sure that'll be fine, Your Honor.
Very well. We'll set day one of the jury trial, 9:00 a.m. Tuesday, October the 31st. We'll set a pretrial conference the week before. I'll have to set that early in the week. $11:00 a.m. on Tuesday, October 24th.
October the 31st.
No. The pretrial conference, which is a mandatory hearing that we conduct prior to the trial,
Okay.
is
And that's
Tuesday,
on November-
October 24 at 11:00 a.m.
That's fine by the state, Your Honor.
All right, I'll set pretrial conference there. That is a mandatory appearance by Zoom for you, Mr. Carter. October 24th, 11:00 a.m. Obviously, all stages of the jury trial, if it goes on the October 31st, will be in person. So pretrial conference, 11:00 Tuesday, October the 24th.
Is that where the jury, my peers, correct?
No. Pretrial conference is the week before. It's a hearing we do by Zoom, essentially to talk about the trial, for lack of a better way to explain it. And to see if the case is resolved by then, which seems like it's not much of a chance here, but court remains optimistic. So let me repeat one more time, Mr. Carter. Your pretrial conference by Zoom, mandatory appearance by you, is Tuesday, October 24th, 11:00 a.m. Your jury trial is set to begin October 31, 1 week later at 9:00 a.m. You must be present for all stages of that jury trial if it goes. I again highly advise you to consider the retention of counsel to represent you, Mr. Carter. And if you can't afford one, you have a right to apply for court-appointed counsel. All
And
right,
Your Honor,
date set. Anything else, Ms. Norris?
Your Honor, before we go off the record, I just would ask that if Mr. Carter does have any video or text messages that are his, that he should talk to law enforcement about those as far as evidence. If he wishes for the law enforcement to view them or for the state to see them for purposes of the case, he would need to contact law enforcement for anything that he has himself. As opposed to myself or the court.
Why wouldn't I submit it to you, the prosecutor and the court at the same time?
You submit evidence through law enforcement, then they can look into it and forward it to my office. You submit nothing directly to the court until trial.
So I can't, even motions?
Well,
No, you can
motions,
file your
yes.
motions with the clerk.
But the evidence to go along with those motions, I can't present to the court?
Only during a scheduled hearing, Mr. Carter.
Okay, I wasn't aware of that.
According to the rules of evidence.
Okay. All right, I'll have to go back and look over that as well.
But I'll just note that the prosecutor's request is that if you're going to submit or you intend to submit anything as evidence that essentially she hasn't provided you, it needs to go through the Andover Police Department. Is that the proper agency?
I'm sorry.
Yes, Your Honor.
She's requesting that you submit it to them with an explanation that you intend to present it as evidence in your case. And I'm
Okay,
sure
and that's anything that I have of myself and not the evidence that she has given me in the discovery, is that correct?
Correct.
Okay, so anything that is in the discovery, I can use to file with the motion, correct?
Well, I'm not
Within the
gonna,
rules of evidence.
yes,
Yeah.
I'm not going to rule in advance on foundation or any other issues that might exist in your presentation of evidence. And again, Mr. Carter, an attorney's assistance would be very valuable regarding the
Okay, and I do have one question. I do remember at the beginning of the hearing, I heard the word burglary tossed around with theft. Is that a charge that I have currently?
Ms. Norris,
Not in the information as filed, Your Honor.
or in the amended information?
No, Your Honor, there's never
right.
been a charge of burglary filed.
Question's
Okay.
been answered then, Mr. Carter.
Thank you. Thank you.
Anything further, Ms. Norris?
No, Your Honor, thank you.
Mr. Carter?
No, thank you.
Very well. There's nothing further. The Carter matter will currently be in recess. And Mandy, you may end the meeting.
Hey everyone. I have got an update to Mr. Carter. He was a handful the first time we saw him, and he went pro se to defend himself against his former employers who he reportedly stole like all of their business equipment. I tried to condense the case down, and I'm not even sure how to do it. So, and if you want to watch the whole thing, I'll put a link in the description. It is 2.5 hours long. I highly recommend watching it on like 1.5 speed because there is so much dead space, and this lady just talks and talks and talks in circles and can't answer a question concisely at all. But let's get to the update hearing, which I've only watched a little bit of, but so far is way crazier than the first one.
This is in the District Court of Butler County, Kansas, case entitled State of Kansas versus Mark A. Carter. It's case number 2023 CR 194. Mr. Carter appears still representing himself in the case. Amber Norris appears on behalf of the state of Kansas. This matter last came before the court on August the 22nd. At that time, the court established pretrial conference and jury trial dates, with the pretrial conference obviously for today. Jury trial was set to begin October 3rd at 9 o'clock. At that time, Mr. Carter argued an oral motion to dismiss based on insufficiency of evidence. Court denied that motion. Court also denied a request for return of a toolbox and welder. Ms. Norris had asserted to the court that this was being held as evidence in the case or on good faith suspicion of theft. The court ordered the county attorney's office to provide an affidavit supporting the search warrant from April the 5th of 23 by email within 7 days. The defendant was again informed by the court of his need for retained or appointed counsel rather than representing himself. The court noting that he was still desiring to proceed pro se. Ms. Norris was to draft a continuance order. Since then, there's been 2 motions filed, which we'll address today. One is entitled Defendant's Motion to have Assistant County Amber R. Norris held in criminal contempt.
Did he seriously just say criminal charges against the prosecutor?
And affidavit. The other, motion for transcript of court proceedings held on Zoom. Are you still wanting to pursue a contempt citation here, Mr. Carter?
Your Honor, she was not complying with your order. That was my only way to bring it to the court's attention that I know of. So she has complied with the order since, but it was way late, and she did not email it when she did comply on the lateness of the original uploading of the document to the DocuShare website. And it only after the motion I filed was the email sent to me.
All right, Ms. Norris, do you want to address that?
Sure, Your Honor. The court had ordered that we comply within 7 days. When I returned to my office and I went through our file, we actually did not, we had the search warrant, but we did not have the affidavit and application. So we had to request that from law enforcement. They did not. We requested it several times over the course of the 7 days, and we did not receive it until I believe the 13th. And that's the day that we sent it through DocuShare, and the defendant opened it, downloaded it. And because we could see when he looks at anything and when he downloads things from that program. And I think since it took longer, obviously, because we had to wait for law enforcement to provide it to us. And then the motion was filed after he had already had, after it had already been uploaded to DocuShare, after he had already had access to it, and after he had already repeatedly emailed me regarding same, then he filed the motion for contempt. So he actually had it, but we, I think in our office, there was a little bit of confusion. We normally send discovery through DocuShare. And so when we got the affidavit and application, it was sent the normal way we do discovery, instead of specifically by email. And then once I realized that it hadn't officially been sent by email, but that he had already had access to it, I did go ahead and send it by email to be in compliance with the court's order. But I think that was just really an oversight. But the reason that it was longer than 7 days is because I could not produce what I did not have.
All right. The court is prepared to rule on the contempt motion that was filed by Mr. Carter. First of all, it would not appear to the court, at least from the content of the file before me, that Ms. Norris was ever properly served by the sheriff with the contempt citation as Kansas law requires.
It's a good thing it's Judge Ricky hearing this case, and he has that stoic, straight business appearance, because I think most other judges would have laughed and had a hard time covering it up. But he didn't even bother to serve her. Come on. I thought you were an expert pro se.
Further, the motion in this case is not really one based in criminal contempt, but rather civil contempt. And because it's meant to try to compel compliance with a court order, the remedy that the court would be seeking would be to try to compel compliance and try to take steps to compel compliance. The county attorney's office is already compliant. Furthermore, the 7-day order was more directory in nature than mandatory. It presupposed that the county attorney's office was in possession of the affidavit. They apparently weren't. It does appear that the county attorney's office took reasonable steps to comply with the court's order anyway. And even on its merits, the motion fails. So at this time, the court will deny the motion to hold Amber Norris in criminal contempt for the reasons stated. And we'll move on to the next motion, which is before the court, a motion for transcripts of court proceedings held on Zoom. Mr. Carter, I note this wasn't even filed until September the 14th. You're requesting transcripts of a preliminary hearing, which took place in July. Further, your motion for transcripts, I think for the first time, is making the allegation that you are indigent. You've never submitted a financial affidavit which sets forth your financial assets to let this court make a determination whether you're indigent or not. But even presupposing that you are, this is a very belated request. We are set for trial next week. And you didn't file a motion for these transcripts, which you claim are critical to your defense, until September the 14th. Which I find curious, to say the least. Furthermore, without having made a prior finding of indigency and without a financial affidavit, I'm in no position to be able to determine that you can't afford them. I mean, when these hearings were over, you could have made a request to court administration for a transcript of this, received an estimate of cost. Did you do that?
Yes, sir, Your Honor, I did.
All right. What was the estimate of cost?
Several $100 per hearing. Several $100 per hearing.
Several hundred dollars. Okay. Obviously, unless you are found indigent by the court, you have to pay for that yourself. Furthermore, I'm not currently aware, nor am I aware exactly what your theory of defense is. That will obviously come out at trial, I think, but I don't know that they're necessarily critical to your defense. Further, you made a request for a hearing that wasn't even evidentiary, saying that you think that that was critical to your defense. It's difficult for this court to understand how a non-evidentiary hearing and the transcript of that would somehow be critical to a trial defense. And you fill the gap on that one, Mr. Carter?
Yes, sir, Your Honor. It was statements made by the defense. I mean, not by the defense, but by the prosecuting attorney, Ms. Norris, as to hold her to what was actually said in court on the ruling and your ruling as well for the return of my items of my welder and my toolbox?
So just to explain that one real quick, he stole everything from his former employers, saying that they asked him to store the items for them and then never picked them up, and then they owed him money and then all these different things, and then he didn't do it. He has 20 different defenses, but in return, he's saying that they have a welder that belongs to him in a toolbox and he wants those back. And he is very adamant that he wants those back. And that is what he's referring to as the things that he wants back, you know, regardless of what he actually took of theirs.
Where I feel like it is I don't feel like you've remained impartial with this with that section of this case, Your Honor. Respectfully here, I feel like you're biased in a way because I know that you worked with Ms. Norris, and as you even stated so in your finding of that ruling, that you've never known her to lie or whatnot. I can't remember exactly how you worded it, but it was along those lines. And you said on that alone that you're gonna let her hold the items from me and continue, even though I have evidence that she has the evidence that clearly shows by the photos that those toolboxes and the welder has never been their items to begin with, and they never owned them. They weren't in any possession of them at any time. The Snap-on toolbox, he's never even had it at his shop to even consider it be his.
All right. Identity of the ownership of those items. Can you mute yourself again for a minute, Mr. Carter? All right. The ownership of those items may indeed be an issue for trial. However, Ms. Norris will not be a witness. Her statements are not going to be held as evidence in court. So anything she said during the motions hearing isn't really going to be relevant for purposes of the trial. Determination of that ownership issue has to be based on evidence that's presented there. And I can assure you that Ms. Norris will not be a witness. So again, it wouldn't appear that there is a legitimate issue stemming from that motions hearing where there's even a colorable claim that you're entitled to a transcript. Further, the court, even if you're determined to be indigent, which this court has not made such a finding, Mr. Carter, because you've never submitted a financial affidavit, and I kind of getting the impression that you don't want to.
Your Honor, may I say something here? I was going off of what you had, and that's why I've inquired so much about whoever filled out the paperwork or had it applied for me to have the attorney at trial. And
the court made that determination on its own.
I understand that. And that's why I come to find that out. And that's what I was wondering is how they became, how it was found that, because it stated that I was found to be indigent for that process to happen. That's what I was going off of, Your Honor.
All right, if you'll mute yourself again. Okay. That determination was not based on indigency at all, Mr. Carter. That was made based on this court's determination that you may indeed need access to legal counsel. We're going to go over that a little bit more here in a bit, Mr. Carter. But again, that was not based on an indigency finding. It was based on this court's determination there was a need, independent of indigency.
I was just going off of what it said in the order, Your Honor. It just had that stated on the order, that's all.
Well, yeah, that's a boilerplate order that BIDS uses. Sometimes there aren't enough boxes on there to check. But I do wish to clarify that point. It was certainly not based on any determination regarding your financial condition, Mr. Carter.
And that's where I was just confused on how the court was even able to find that out and make that determination, because that's all I could read on there was that box was checked. That's where I got that basis from. I'm not saying that I've filled any affidavit out for that. I'm not claiming any of that. I'm just going off of what I read that the court had found in my ruling or on the ruling for me to have the attorney present at trial. That's all, Your Honor. That's
all right. And that's fair enough, Mr. Carter. Again, it was on a BIDS form. Generally, these appointments are based on indigency, but in your unique case, it was not. But that form is what's required by BIDS. So that's what it was submitted on. Further, Mr. Carter, I think this is the proper time to address certain matters. From the very inception of this case, Mr. Carter, you've insisted on representing yourself. There's a number of advisories I'm going to go ahead and give you at this time. I have advised you all along that you could change your mind and either retain counsel, or if determined to be indigent, you can have counsel appointed to represent you, and you can petition the court for appointment of counsel to assist with your defense. And I do want to make sure that you're aware, even though this court has appointed standby counsel, that once the trial starts, that no postponement of that trial will be permitted for a more active role by an attorney, including your court-appointed attorney who's operating on standby. That at some point during the trial, the court does have the discretion to terminate self-representation if you, the defendant, deliberately engages in serious or obstructionist misconduct before the court in that trial or any proceeding in this court. That the court, once again, I'll inform you, Mr. Carter, that I consider it detrimental for you, the defendant, not to accept or employ counsel to represent you. Even when you were asked for a delay of this morning's hearing so that Chris Pate, your standby counsel, could attend, you rejected that notion. And I understand that you wish to represent yourself and that you have a right to do so. But I think Mr. Pate did want to be part of this, just to know what was going on with the case, since he's being asked to stand by next week. But nevertheless, you wanted to go forward with this hearing at 9 o'clock, and we have done so. Again, I think self-representation is not in your best interest. That if you are allowed to represent yourself, which at this point you are, you must follow all legal rules applicable to the trial of a criminal action. That there's a number of dangers and disadvantages to self-representation, including the following things. That the law provides for numerous pretrial motions available to you, which are of a technical nature, the advantage of which you would lose if allowed to represent yourself. For example, you filed a criminal contempt motion, you didn't know how to serve it, and you didn't even couch it in proper contempt terms because you sought a criminal contempt, and clearly what the remedy you were seeking had nothing to do with criminal contempt. That's just one example that counsel can help you with when it comes to these legal issues. I'll point out to you that your vocabulary and lack of legal training may impede clear communication with the court and opposing counsel. I'll inform you, Mr. Carter, the judges will not act on behalf of a defendant in asserting objections or making appropriate motions, where ordinarily it is the duty of counsel to call such matters to the court's attention. The county attorney, Ms. Norris, will not assist in the defense of your case. I'll point out to you that the rules of law are highly technical and will not be set aside in view of your status. And that you, as a defendant in a criminal case, may waive constitutional, statutory, or common law rights unknowingly. I need to point out to you, if this hasn't been pointed out to you clearly before, that the maximum sentence for this offense is 17 months in prison. The sentencing range under the guidelines for a level 9 felony with which you are charged is 5 to 17 months based on criminal history, and that you also face up to a $100,000 fine for this offense. So I wanted to make sure that you realize the possible penalties that can be imposed if you go ahead, represent yourself, and are convicted. Further, the court did appoint standby counsel, a very experienced and very good trial attorney, Christopher Pate. His role is limited. Since you've asserted a right to self-representation, Mr. Carter, he is only there for the purpose of giving advice to you if you expressly request it. He will sit near you during the trial, but he will not participate without the express request of you or perhaps as directed by the court. But I would have to first then determine, before I get involved in that, that you are not competent or qualified to continue with your own defense. Do you have any questions about what we've gone over here, Mr. Carter? Did you understand clearly all of the points that the court has made?
Your Honor, I do and I don't. I have concerns. I have many concerns here. First of all, the attorney that you have appointed for standby, we have been communicating, and in our communications, it is my understanding that that I understand that he is there for limited capacity, and he's there for just the legal procedure advice, which I've asked him for, which then he gives opinions, and then he repeats what he's supposed to be there for. I've only gotten opinions from him and not so much as procedural advice or help with the procedural stuff that I've asked him so far. I don't feel like he's there for I don't feel like he's there for me to help me in any way other than he said that I have to prove my innocence, basically. That's exactly what he said in his email. He said, I have to prove to the jury that I didn't do that and that the bishops are lying. And then he states right after that, he said, well, actually it's the court's or the prosecuting job to to prove that you're guilty beyond a reasonable doubt. So he's more of an opinionated person to me than he is helping with the procedural. He's weighing in on facts or disputes in the case of evidence or whatnot. And I'm not asking him about that. I'm asking him procedural and legal advice for how to proceed or how to file something. And I'm not getting the response back that I need or even anything remotely close to that, Your Honor. I don't know if there's any other standby counsel. I understand, but it's limited to the capacity where it's not opinionated though, right? I don't need he's not there to give opinions and legal opinions. That's not what I'm asking him for.
Okay. If you mute yourself for a moment. All right, Mr. Carter, his role is quite limited. You're representing yourself in the case. His duty is really at trial. It is at the trial proceeding that I want him available as someone who can be accessed by you to provide advice either on procedure or maybe even substance during the course of the trial. As far as being a pretrial resource for legal information or advice, that wasn't his role. I'm glad you two could communicate. That certainly doesn't bother me that you've communicated. But again, you have asserted self-representation. And if you don't wish to rely on anything he said, so be it. You can consider it, reject it. He does not have a role in actively representing you or advising you until time of trial. And I just hope you understand that. He's really only there to be trial standby counsel at this point.
Okay, Your Honor. Well, that's not what he was. He portrayed to me that at that point that he was appointed and by you or the court, that his role was from that point on to assist with me with procedural if needed. He said, I understand that you represent yourself, but I'm here as legal advice or procedural advice on how to proceed all the way from then till through trial and sentencing is what he said. That's what he told me.
All right. So I'm not sure what your ultimate point is here. Please clarify.
Okay, you just stated that he wasn't here for that until trial, but I'm just saying that's why I was asking him what I was asking him, because he made it seem as if he was in that capacity at that moment, not just at trial, is what he portrayed to me. So I'm under the belief, I'm being told one thing, you're telling me something else. He's telling me one thing and he's not giving me the procedural advice or how to proceed or how to file. I'm asking for motional support to file, and you're saying that he's not even supposed to be doing that right now. I understand that, but I'm just expecting. Okay, well, I'm just saying that's what he said that he was there for that as of then. I asked him, I didn't get the response back. I got nothing but mainly his perspective on things and what he weighed in on legal stuff. And I'm not asking him to do that. I was just seeing if he was trying to help me or not on procedural wise. That's all. And I don't feel like he's there for that. I feel like it'll be the same way through trial with him for some reason.
Court's not inclined to change its previous order regarding Chris Pate's role as standby counsel.
And Your Honor, just so the court is aware, once we got the appointment, we did forward discovery, and any further discovery that has come in, and also generally Mr. Carter emails quite frequently. And when I reply, if I do reply, Mr. Pate has been on the emails so that at least he's aware of what's going on. To what benefit that is to anyone.
All right, Ms. Norris, let me ask you, has there been any attempt for you to communicate with Mr. Carter to try to resolve this case in any way? It's a question I generally ask counsel at times.
Your Honor, no, there has not, but Mr. Carter has not really put himself in a position, or his emails, etc., do not lead me to believe that he has any interest whatsoever in taking care of this case in any other fashion than to go to trial. I don't. That's just the impression I get from the emails and the and obviously the motions that he's filed. And there is a motion in limine that I filed yesterday, Judge. It did get filed with just where I emailed a copy to the defendant, and then I emailed a copy to you and your AA this morning on the off chance that you had just not seen it in the Justware queue.
Maybe
anyway,
will produce that for me here momentarily.
And so, Your Honor, if you wanted to ask Mr. Carter about the possibility of resolving the case, I just have never gotten the impression that he's even remotely interested. So I would say that discussion has never occurred.
All right. I'm going to take a 5-minute recess at this time. We're going to put you two in a breakout session. And I want you two to at least discuss the possibility of it.
Yes, Your Honor.
We'll come back on in 5 minutes. If you need more time, perhaps the court will extend the conference time. But I want you two to at least have had the opportunity to talk, as is traditional, as part of this pretrial conference docket. So I'm going to go ahead and stop recording and broadcasting at this. Following a recess to allow a conversation between Mark Carter representing himself and prosecuting attorney Amber Norris, the court resumes proceedings in case number 2023 CR 194. I'll also note that Chris Pate, who's the standby counsel for trial purposes only that the court appointed, has now joined the meeting. Ms. Norris, following this opportunity to discuss possible case resolution with Mr. Carter, what would you announce at this point?
Your Honor, that there is, and probably won't ever be, a chance, really, I don't think, for this case to be resolved outside of a trial situation. We had some discussions and we had a hard time staying on topic. But yeah, I don't think that there's any way that there will be any kind of a plea in this matter to the point where the defendant is, talking about civil action after this case.
All right. There are a couple of motions still before the court at this pretrial conference that the court needs to address. Mr. Carter, your motion for transcript of court proceedings held on Zoom. Number one, as the court referred to earlier, there's never been a finding of indigency. So as far as your claim that you can't afford the transcripts, the court doesn't have any information before it to verify that.
Can I say something, Your Honor?
Go ahead.
Okay, I'm going to say that I already had the paperwork filled out to file. I just can't drive over there. It's a lot of gas from Viola area to El Dorado, of course. That's a pretty good long distance away from me to drive over there to file paperwork and then leave and come straight back. I did not file since the order was for Chris to be my attorney because of, like I explained earlier, the indigent thing was attached to the order that you made, and where it was, the box was checked off for that, and I assumed that that was the way it was going to go for, and that I could be found for that to get the transcripts at this point. And it was a mere obvious misunderstanding of what the judge, of what you had ordered, and the box is checked and whatnot, finding the indigent, but it's actually not found indigent. I can attest to you here today, any financial statements that you would require for me to fill out on form, I could, under oath, whatever you need me to do. But I can attest to that I am an indigent defendant at this point, that I cannot afford the amounts or anything close to that for the transcripts, but I desperately do need these transcripts for trial due to the fact that they do have the testimony of the 3 witnesses that the state has brought forth to get this action and keep it going to trial. And in those testimony, the officer Shiner has perjured himself several times on several notes, clearly on from things that Ms. Norris has asked him and things that I have asked him. His responses, and I've clarified it with him 2 to 3 times during that testimony of his answer, and my ring video clearly are in total 100% contradiction to what he has stated on, as far as letting the Tim and Kim Bishop search through my stuff or assist in the search. He's testified that they were not there to, they didn't assist in anything. They didn't search through anything. He testified that he was there and searching, and that they were looking over his shoulder. Now, the ring video that I've submitted to Ms. Norris, she's got it. It does show that the Tim Bishop, Kim Bishop searching through my stuff without the police even in the presence of them, like there. You can just hear them in the background to the side. They're not searching through anything, but Tim and Kim are. And if anything, it shows that the police are looking over Tim and Kim's shoulder as they're searching. That's just one thing. There's obviously Kim has taken videos and taken pictures on her iPad. He testified, Shiner testified that she did not take any photos there. She wasn't allowed to have an iPad or anything, only to show him pictures. Tim has testified that she didn't take pictures, and Kim testified she didn't take pictures. Now we have the email chain.
Okay, so not only is he a wackadoo, but he's got a bad memory, because she specifically said she took pictures and compared them later. I remember that from months ago when I watched it, and I could rewatch it and clip that if, he needed me to.
Where Shiner is getting and requested the photos that she took, and we're waiting on those photos now. He's admitted to it, and so is Kim.
Mr. Carter, these witnesses would have to testify all over again at the trial. If you have some sort of evidence to challenge the credibility of their statements, you can present that at trial, can't you?
Yes, Your Honor, I can, if they state the same thing they testified to in the first one. But if they change their testimony at the trial to exactly what the video shows, that doesn't show my perjury, which I have it on. If we have the transcripts, it will clearly show contradictory 1,000% to everything that actually happened. They didn't know I had ring video, obviously. It has ring, and it has audio and video, and it rolls 2-minute clips at a time. Every time there was a motion, and it pretty much, it doesn't skip a beat through any of it for the good portion that anybody's up there close to the camera. I have every bit of it, like the entire day, that whole afternoon, all the way up till almost midnight, to where they're there going through the stuff, and it goes against everything that he claimed and they claimed in testimony before you in the court. Under oath, Your Honor. It's clear as day.
I'm not aware of any authority that absolutely requires a preliminary hearing transcript to be prepared. Court can consider alternatives to preparation of transcripts. I can set up giving you access to the Zoom record on Monday afternoon if you so desire.
Oh, that would be great.
You'd have to come to the Butler County Judicial Center here in El Dorado.
Oh, and Judge, I wasn't aware that you actually still had those.
Excuse me?
I wasn't aware that you were actually keeping the video.
Yes. Well, yes, we are. It should be available.
That'd be more than I could ever ask for, Your Honor.
All right, what time would I tell them that you're going to be here? I think that's probably a couple of hours, 2 or 3 hours worth of testimony total. Can you be here at 1 o'clock?
I could be there in that morning,
All right. What time in the morning?
10 o'clock.
All right. We'll have somebody contact you by email if that won't work. You'll have to go to the place in the judicial center that's designated for you. Obviously, I'll expect you to take care of any equipment that the court is using to display the Zoom recording. So I'm not going to allow any substitute video be introduced at the trial. So just in case you're thinking about recording what's on screen, you could do so, I suppose, for your own purposes, but it's not going to be admissible at trial. The only recording that would be admissible would be the Zoom recording itself. And then even then, you'd have to meet certain requirements as to whether that's even proper or not under the circumstances of the case. I'll reserve ruling on that. But I'll try to see if we can get set up at 10 o'clock on Monday to have you get access to the preliminary hearing record. All right. With that dealt with. If you mute yourself,
I just have a few questions, Your Honor, about the evidence in the trial on introduction of it. And I understand proper procedure and everything. I don't understand why it wouldn't be allowed for me to introduce during questioning of a witness of the state, should I say, at this point, a witness of the state, of their actual being recorded on my Ring camera and things they're saying, and it shows their picture of them, and have them testify as to that video being accurate description and representation of them in that day and what they're saying. Is are you saying there's no way I can actually have that brought into evidence?
I didn't say that at all. I was talking about the Zoom recording video. That's what I was saying.
I understand. Okay.
Not some independent video that might be determined relevant. No, I haven't ruled on that.
Okay, that's all. Thank you.
All right. The motion in limine filed by the state still needs to be addressed. What they're attempting to limit is that apparently defendant filed a PFS, a protection from stalking action, against the bishops, who are, I think, the alleged victims and will be witnesses at the trial. Apparently, they haven't even gone to final hearing yet. State's position is any information regarding these PFS cases would not be relevant and would not be material to any issue in the trial. And they're objecting to any reference to the existence of a PFS case. And apparently that's a Sedgwick County case.
Your Honor, they keep coming out here to my residence all hours of the day and night, making noise and ruckus, harassing me and my family. And I filed a PFA.
What does that have?
We had the hearing. Well, the thing of it is a character flaw, because their characters at question when they're on the stand, Your Honor. When they're giving testimony, their characters at 100% question. This is a part of that file of their character. Their character is they're coming from Andover, Butler County, a separate county from here, all the way to the far extreme southwest corner of Sedgwick County, just to drive around my place and harass me and my family at all hours of the night and day. Tim even admitted it to the judge, and the judge in that court actually found it enough to keep that order to remain in effect for them not to come out here and harass me anymore, Your Honor. It is an order, and the judge only continued it till after the trial of this matter here is taken care of. And he didn't know the exact date, and he didn't know how long, he knows, I guess he had experience with Butler County's trial dockets taken and sometimes extending out longer than they had been because of the COVID-19 issues going on. And he wasn't aware of anything changing since then and how it was going right now, to the effect that he didn't know exactly when the trial would actually commence and be finished. And so he gave it a little bit of a leeway with the November date of the hearing actually being held, but he did take into account the evidence that I submitted and showed him Tim admitted that it was him on the video, of all the videos I showed him, and the judge made his ruling.
The problem is the ultimate issue for the jury to decide is your guilt or innocence regarding felony theft. Their behavior toward you subsequent to the filing of these charges, I don't see the relevance at all. Carter,
They're
all
victims.
you do is get distracted on side issues that have nothing to do with the issues that are really there for trial.
Your Honor,
nothing you've said has convinced the court that the motion in limine should not be granted. I don't want to
Your Honor,
protection orders.
Your Honor, may I say something else here?
You may.
The reason it should not be excluded from this due to the fact that that is a character issue. If they're alleged victims in a case that is proceeding before the jury right then, the jury has the right to know the character and the actions of those people that are portraying to be a victim in a case that is trying to get me put in jail or fined and all this other stuff, found me guilty of a felony. So their characters at play here. They're out here harassing me. It has been found and extended to go into and remains in effect. It says it right here on the order. Remains in effect, Your Honor. Both of them, both cases. Kim and Tim separately filed. I filed separate ones because of their harassment to me. Now, it should be allowed that their character come up in court. And it is my right to bring their character up against any witness the state
Wait a
brings forth.
minute. If you're going to say it's your right, what is the authority behind that statement?
My constitutional right to have to question witnesses before me and their character, Your Honor.
Character evidence in Kansas is limited by statute to only certain instances the character can be brought up. We don't try cases based on the character.
I'm not asking you to. But the victim's character in the case where they're claiming to be victims in a matter before the court, claiming that I have stolen something from them, whenever there's evidence that shows that I have not, and their character where they have actually perjured themselves, which I will be able to prove, their character will all be at the show of the court and to the jury. If they've perjured themselves, and I can prove it in the court by the testimony that they've given already and what they say in court that day. It just depends on what they say that day but it'll be perjury either way because of the records that the officer's got in his notes with my ring videos that I can introduce. If it's there, Your Honor, the case will not proceed. The victims, the alleged victims in this case are lying. I do have the evidence of that. They have came out here, harassed me and my family at all hours of the day and night. That should be allowed in this case, especially make the determination at that time is what all I'm asking you, Your Honor. After, I won't even introduce it until after I've shown the perjury and laid my foundation for my case. I'll introduce it at the right time after that, and you can make that determination then. Can I ask you to do that, Your Honor?
I don't want any references made to this during jury questioning, during opening statement, or any other part.
The end of the video got cut off a little bit, but there was nothing else said that was super important other than you're going to trial. I'm not granting your motions. And he tried to get him to stop. So this was a couple days ago. It was just right at the end of last week, and it gets even better. He filed a motion yesterday. Trial's supposed to start today. Trial's supposed to start on the 3rd. He filed the motion on the 2nd. The motion to dismiss, motion to suppress evidence, motion to return seized property, which is his welder, motion to request a change of judge, statement of facts, and affidavit of memorandum. Like, what on earth, dude? There's just so much that I'm not even going to go through this whole thing. It's laughable, and I'm sure they'll have a hearing on it, and we'll cover it there. If you want to look it up, you can look it up on the Kansas court records and just search for Mark Carter and refine it by Judge Ricke's name, Ricke. Yeah. To be continued.
Detective, if you raise your right hand, you swear affirm testimony you're about to give is the truth, whole truth, nothing but the truth?
Yes, ma'am.
All right, state your name, spell it for the court reporter.
Yes, ma'am. Name is Detective Mustafa, ma'am. Last name is spells us Mary, Uncle Sam, Tom, Adam, Paul, Henry, Adam.
All right, stand by to get out here. All right, we got position 523 CP 218067, Andrew Lovett, 91 days without indictment, got aggravated assault, cruelty to children in the third, received possession, transport, or firearm by a convicted felon, first offender, and theft by receiving stolen property. Go ahead.
Yes, can you tell us where you work?
I work with City of Atlanta, assigned to major crimes, aggravated assault unit.
What's your position there?
I'm a detective, ma'am.
How long have you been employed with the city of Atlanta?
It's going to 15 years, ma'am.
And what about in law enforcement? How many years do you have?
Law enforcement, 15 years, but as a detective, ma'am, is going to 3 to 4 years.
Okay, are you post certified?
Yes, ma'am.
Are you familiar with the case that brings you in today?
Yes, ma'am.
You took out 4 warrants against Mr. Lovett. We're going to start with the aggravated assault. Can you explain why did you take out the warrant for aggravated assault against Mr. Lovett?
Reason why, and I took out charges against Mr. Lovett for the charge of aggravated assault. I received the case. It was an aggravated assault incident. I reviewed the case and I made contact with the victim / reporting party, Mrs. Brianna. And she told me at the time that they were outside this complex. They were outside. They went over there so our sister can get a sister or one of family member can get a hair braided. And while they were standing outside the location, an unknown dog, a stray dog that was out there, started to approach him in an aggressive manner. I said at some point in the time, the dog approached her brother, who's going to be the victim, Mr. Jaden, and the dog jumped on the brother and was almost about to bite him. At some point, she retrieved a weapon and shot the dog. And she said after they did shot the dog, somebody must have went and notified the owner of the dog, who's the accused, and the accused came by, pulled out a firearm and pointed at them. And that's when later on she said, when the accused knew the police were coming, he left the location. And that's when she called us and notified that she wanted to file a police report.
Okay. Who is the second victim?
The second victim, that's her brother. That's Miss Brianna's brother.
How old is he?
I think if I know juvenile, he's about 14 to 15 years of age.
Okay. Okay, you took out a warrant, I'm sorry, for cruelty to children in third degree. What was the probable cause for that warrant?
The probable cause, that's for the pulling out a firearm and pointing it in front of a minor. And a statement was also provided by the juvenile, the victim, when they came to do a full lineup. We also obtained a statement from him.
Okay, to clarify, who is the minor that's listed in the warrant? What is his name?
The minor name would be the brother of Mrs. Brianna, Miss Brianna Middlebrooks.
Right. Did you say that he was under the age of 18?
Yes, ma'am.
You also took out a warrant for possession of a firearm by a convicted felon or felony first offender, why did you take out that warrant?
The warrant was taken out also, ma'am, the accused, Mr. Lovett is a convicted felon, ma'am.
Okay. Did you, how do you know he's convicted felon?
For me to verify that, man, I have to pull out his criminal history. Then on there, you can tell if he's a convicted felon, ma'am.
Did you verify that he was a convicted felon?
Yes, ma'am. You have to look at his criminal history and verify that. Even before the judge sign it, you have to verify that.
Yes, okay. And what evidence do you have to I guess justify that he was in possession of a firearm?
Just for the fact that he had a firearm in his hand and victims they claim. Then also, if I'm not mistaken, man, when he was detained, when he was finally arrested by fugitive, I believe a firearm was found in his possession also.
Okay. And you also took out a warrant for death by receiving stolen property?
Now, that charges, I didn't take those out. I think the fugitive unit took that when he was arrested.
Okay, I'm sorry. What can you tell us about from your investigation about the death by receiving stolen property?
On that one, ma'am, I believe that the fugitive unit, the detective that actually make the arrest on him the time when he was arrested, they had to verify that. If I'm not mistaken, from the body cam or from their notes, I think the gun was stolen. It was a stolen recovered handgun that was found in his possession.
Okay.
Yes, ma'am.
What all evidence did you have a body cam on when you interviewed the victims?
Yes, ma'am. When they came up, actually, they were interviewed at headquarters. So that's how they were on the body cam for both victims, both Ms. Brianna and Mr. Hines.
Have all the evidence you have been stored into evidence?
Based on the evidence that was recovered from fugitive, I believe they stored those items in evidence.
Okay. Is there any additional information you would like the court to know regarding these 4 charges?
Other than the 2 charges, I believe the other 2 charges were added by fugitive unit, ma'am.
Mm-hmm.
But that was, as a matter of fact, I reviewed that on the body cam. That's how I came to realize of those additional 2 charges that was placed on Mr. Lovett.
Mm-hmm. Are you able to identify Mr. Lovett?
Yes, ma'am.
You can stand up if you like.
Yes, ma'am.
Can you tell us where he's sitting in relation to you and describe his physical and facial features?
Yes, ma'am. Mr. Lovett is sitting in front of me to the left of his counsel. Mr. Lovett does have on an orange jumpsuit and a white V-neck underneath. He's bald head, man, brown skin.
I'm sorry, you can sit down.
Yeah.
Your Honor, I'd like the record to reflect the identity has been established.
Okay, so noted.
In which city did this incident take place in?
It happened inside the city of Atlanta, ma'am.
Which county is that?
That would be Fulton County.
Your Honor, I also like the record to reflect the venue has been established.
Noted.
Court's indulgence, please.
Mm-hmm.
Nothing further from the state, Judge.
All right, go ahead, Cross.
Were you the officer who responded to the scene about a dog, correct?
No, I wasn't the officer, sir.
No, it was not you. Which officer was it?
That will be Officer Winder. Officer Winder was the primary officer. They did this, responded to the scene and did this police report.
Okay. So which scene did you respond to?
I'm the detective, sir. I reviewed the case.
You reviewed the case?
Yes, sir.
Were there any injuries to the children?
Not that was mentioned of, sir. The officer did took body cam pictures of the victim.
Okay. Who gave the 911 call?
At this top of my head, I cannot recall, but I'm assuming the Mrs. Brianna, if I'm not mistaken, made that call.
How long before the police arrived?
I am not certain, so I'm not sure about how long it took before they arrived.
Ms. Middlebrooks had a gun, correct?
Yes, sir.
And then Mr. Lovett arrived on the scene after the dog shot? Or, I'm sorry. Did Ms. Middlebrooks have a gun when a person came up and pointed a gun at her?
I am not sure if the gun was still in her position, but I'm sure after she shot the dog, a short while later, that's when Mr. Lovett arrives.
Okay. When did you receive the case?
Normally we received it when the incident, I believe the incident happened on the 6th of July, July. I probably received the case maybe about 6 days later on, because I reviewed the case on the, I believe it was a case on the, sometime in, I believe in a week from then.
All right. And there's body cam footage for the initial police response?
Yes, sir.
Okay. And Mr. Lovett was not there, right? Correct?
No, sir, he was not on the scene.
Okay. Was there any other gun at the scene other than Ms. Middlebrooks?
No other gun was on scene at that time.
Nothing further, Your Honor.
Anything else from the state?
Just 2 questions.
Okay.
Did you learn it from your investigation? Did you learn at any point if Ms. Middlebrooks was the first aggressor against Mr. Mosley?
Not that I'm aware of, ma'am. No, ma'am.
Did you from your investigation, did you feel that warrants needed to be taken out against Mr. Miss Middlebrooks for anything in crime?
No, ma'am.
Nothing further, Your Honor.
All right, any follow-up? All right, thank you, Detective.
Thank
Stay
you,
safe.
Thank you, George. Thank you.
All right, go ahead with the argument.
Your Honor, the state has provided testimony from Detective Mufasa. And from his testimony, the state feels that there is enough probable cause to for the aggravated assault or cruelty to children third degree, receipt, possession of a firearm by a convicted felon, and theft by receiving stolen property. As far as the aggravated assault, we learned from the detective that there were 2 victims involved and that the defendant Mosley approached the victims with a firearm and pointed it at them for what I believe had happened. Something had happened to his dog. And so he was angry, and there can be inferred that he was angry and wanted to confront Miss Middlebrooks and her brother about what happened to his dog. We learned from the detective's testimony that the juvenile involved was under the age of 18, which is enough probable cause to substantiate the cruelty to children, being that a gun was pointed at this juvenile and Mr. Mosley was the person who pointed the gun at him. We also learned from the officer, the detective, just based off his investigation, that he later found out that the defendant is a convicted felon. And also from his investigation, he learned that the particular gun that was in his possession had been reported as stolen. So just based off the detective's testimony, we believe that the state has made its burden for probable cause for all 4 charges.
All right, go ahead, Mr. Walter.
Your Honor, we don't have evidence of Mr. Lovett pointing a gun at anybody. We have he was not at the scene. There was no police testimony regarding seeing it. There's no video footage. There's no shell casings of this happening. And it sounds highly unlikely. The only gun was with Miss Middlebrooks, and if 2 people are pointing guns at each other, one might go off. It doesn't sound like a realistic charge. We also don't have any injuries reported to the children either, and so more the narrative is that for whatever reason the dog got shot. Mr. Lovett shows up. He's angry about because it's his dog, and then he goes off and leaves. There's nothing to show anything further than that, other than some words. Nothing further, Your Honor.
All right, I'll find probable cause on all 4 counts. We'll go ahead and address bond. Wow.
Love it. 6 prior arrests, took a first offenders on probation, 7/8/20, aggravated assault with deadly weapon, 4 counts, firearm during 4 counts, 20 SC 175-107, 6 months confinement, 4 years, 6 months probation, nothing further.
All right, go ahead.
Your Honor, currently Mr. Love is on a no bond status and, excuse me. We would like to offer him bond to give him a chance at life and to bring more evidence to better fight the case for himself, but also just to be back with friends and family on the outside. He has a criminal record, but he's not one of those types that's in and out of jail every week. And so we're asking for one of his last arrests was a couple years ago, and he has a 5-year-old son. He was trying to save up for a GED, and he was working as well, making himself productive in society, working different jobs. So we're asking for a reasonable bond, something a bit lower, Your Honor.
All right. What says the state?
Your Honor, the state is going to ask for a high bond if the court is inclined to set a bond today. The defendant did, just based off the testimony that we heard today, aim a firearm at a child. Aside from that, the defendant was in possession of a firearm, and he's a convicted felon. We feel that he is a danger to the community. This incident did take place outside in front of several people. Your Honor, also he was on probation when this incident took place. So we feel that he's likely to reoffend. And so for those reasons, we're going to ask for a high bond. If the court is inclined to set a bond, we ask for a bond no less than $70,000 on all the charges.
All right. No drugs unless prescribed, no alcohol, no weapons. Stay away from 532 Cleveland Avenue Southwest. No further contact with and Brianna Middlebrooks, Breunna Middlebrooks, Middlebrooks. You have income monitored paid for by the county with that 24-hour curfew, court, lawyer, medical, employment, as long as you supply the name of your employer, proof of employment schedule, exact location you'll be working. Got 10,000, 5,000, 5,000, and 3,000. 10, 5, 5, and 3. Best of luck to you, sir.
Clear now.
Hello. What's going on today? What can I do for you?
Well, obviously, I swung too wide on the roundabout. Hit a recycling.
Okay, you guys are coming through the roundabout?
Yeah.
I was going this way, he was coming this way, and he was in my lane coming straight towards
I
me.
went around it.
I went to slow down and it just...
All right, so
you.
Search.
I'm Tom Henry.
Yes, sir.
Pleasure.
Gotcha. I just drew the...
Okay, that's good enough.
I don't do that for the COVID.
I understand.
So you guys must want to stand over here closer to the car so we don't get hit. So which...
It was me.
So you're just coming out of the roundabout and you were on Old Mill?
I went around too
Yeah, I
wide.
was going this way.
Okay.
I thought I made the curve and I didn't.
Okay.
That was my fault.
All right. All right. The officer en route's going to need driver's license and insurance card.
Sure. Absolutely.
How many people in your car?
Just my wife and the niece. Business card.
Nope.
Well, that's good.
Driver's license.
My driver's license.
Oh.
And
Insurance card, auto insurance. Not the health
I thought
insurance.
that was which one? Well, I know which one it is. Take that one.
That's the auto. That's
Yeah,
your
right.
health insurance.
Hell, I don't know which one it is. Damn cards here. Thank you.
You're welcome.
Damn cards. Here we are.
That's your health insurance card. That's the
Well,
one
which
you
one-
just tried to
which
give
one-
me.
I'm sure by the city. Jesus Christ. That's my wife's. I'm insured by the city.
Sweet.
I'm not there. For God's sake, I'm insured by the fucking city.
You're insured by the city of Fort Wayne?
Do you think?
I don't know. I don't know how that runs. I understand. But
I'm insured by the city.
okay.
Take it
That's
for
a
that.
city car?
Yes.
Okay. Okay. Alright. So, alright. That's your health insurance card. I don't need that.
That's yours. Is that mine or yours?
That's
Okay, I'm
yours.
sorry. That's why I don't go.
Alright, stay here. This officer's going to take over the investigation here. They want supervisor down here. I don't know however you want to do this, but he was driving and he came out of the roundabout. The woman was going southbound. He came out of the roundabout too wide and hit her mirror.
Right on. So does that mean are we going to need a supervisor to do that?
I'd probably have
You got 21 traffic. 541 knowledge.
Clear mileage 541.
Is Troy sergeant tonight?
Whoa, careful.
No, it's fine. My wife needs a ride home right now. She's very ill. She has cancer and she's very, very sick. She needs a ride home right now.
She needs a what?
A ride home.
A ride home?
Oh, yes.
Okay, I'll get a unit out here to take her home.
I'm the mayor. God damn it. Take her home right now. Steve, I don't care who you call. You take my wife home.
You want me to take her home?
Yes, right now, and with lights and siren.
Where's home at? What's the address?
Out in the northwest part of town, off of Harris Road.
Off Harris Road?
Take her right now. God damn it, if I don't, I'll be on Steve back.
Okay.
Right now. Take her home.
I hear you, Mayor. Let me get your address. You want me to take her license irons?
I don't. Yes, please. She's very, very ill. I took her home for the first time
Right,
tonight.
stand over here. There's a car coming. Stand over here. Just
thank you. Right now.
What's the ad?
Take her right now.
Okay.
I'll give a shit what it takes. That's an
Okay.
order.
It's an order. All right.
Yes, sir.
Which one's your wife? In the front passenger? King 356. I'm being ordered by the mayor to take his wife home. Lights and sirens.
King 356, I'm clear. Ordered by the mayor. Take his wife home, lights and siren. King 356, I'll be not here shortly. I'll relieve you.
Nope, that's orders for me, he said.
I'm Cindy.
Cindy, I'm Julie.
This is Marty.
Marty, nice to meet you. My car's all the way back here, so I'm gonna have you guys step back here with me, okay?
Thank you. I've got soup with me. Thank you so much.
You're welcome, ma'am. No problem.
Thank you so much.
No problem.
Your mother?
No,
Cindy's,
Right.
okay.
She's too old to be my mother.
Oh. I'm gonna have you step back here with these officers. We're gonna go all the way back here, that way we don't fall and other cars.
People. 270. Did that officer that chimed up a minute ago, or are they going to
I'm getting hit, that's all.
transport?
Right.
We understand, but we care about you too, though.
Who's giving the wife a ride home? Julie, are you giving both of them a ride? Or if not, as I say, one of us can.
That's your wife and who else?
My wife.
Yeah, who else?
My wife is the one who's.
Right, there's two over there. Who else is over
One's
there?
my wife and one's my mother-in-law.
Gotcha, okay.
Tell me, pick one. Which one's what?
No, I just didn't, you kept saying your wife, I didn't know who the other one was.
No, my wife.
Gotcha.
She's the one who's hurting.
She's the one who's what? I'm sorry?
She's the one who has cancer.
I gotcha.
And we took her out for the first time tonight. Obviously, we were at a fundraiser, and I probably went over the line. It's me.
I gotcha.
I'll take whatever going on. Whether it wasn't just a pass around or whatever, I'll take it.
I gotcha. Where'd you guys, you said it was a fundraiser?
Oh yeah, it's a big theater.
Pacific Theater?
Yeah, and I took our mother-in-law home, and we were coming back, and I probably went around the damn traffic circle too wide and hit somebody's side view mirror.
I gotcha. You were driving then?
Yeah, I was driving. It is what it is.
I gotcha.
Damn traffic circles, I love them, but I hate them.
Yeah, they're not much fun.
No, they're not. Especially when you go too wide and somebody comes in too thin and you knock off their rear mirror. Of course, my wife went nuts on me.
About wiped out on that one.
She said, "You've been drinking too much." And I said, "Oh, for God's sake." We were there for 5 hours. Listen to him laughing at me. See, they're laughing at me. No way. I'll take whatever hit I need to. It's her I'm worrying about most. It's unfortunate. Who's stealing my car? Who's stealing my car? Is it my car? Okay, it's your car. I was going to say, who's stealing my car? Can I check on my wife, see how she's doing?
Nope, she's just about to leave. We have an officer that's taking her home. Yeah.
She's got to get her instantly.
Okay, yep. They're getting ready to leave right now. She's just getting the car all cleared out for them.
Good, thank you.
So she'll get her home safe and sound and get your mother-in-law home too.
Good. Yeah. Obviously, I'll take responsibility. I swung too wide, and I swung too wide. I think she was going straight, and I was going. I think that's what happened. Either I was going straight, and she was going around, or I was going around, she was going straight. I can't quite remember those two, but whatever it was, I hit her in the side view mirror.
I gotcha.
Ah, God dang it! There she is, right there, my wife. You see a ditty?
She's a pretty lady.
She is. I'm gonna go say hi.
You know, stay over here for me. Just hang out here.
There's a safer for you to stay right here, stay still in one spot.
All right. We have quite a few accidents on roundabouts.
Not down here.
Not usually.
With Marty Bender, I asked him from time to time. You know, we're building all these roundabouts. You know, how many of them are really effective? Do we still have a number of accidents?
I just know this one. We don't have that many down here on this one at all.
Yeah.
I've been to like one, maybe.
Oh, really?
So yeah, I mean.
And that's it?
Yeah.
Semi sometimes comes down here and tries to go.
Well, my
straight
wife was telling me that, you know, she goes in these roundabouts like at Goshen and Sherman and so on. And these people just fly by, and they don't understand. You yield to your left.
Right.
And they just fly by. And she said several times I've had to slam on my brakes. I wonder how many. I was going to talk to Marty. I wonder how many accidents we've really had at roundabouts. Because people just don't understand. You yield to your left.
Right.
I don't know the answer to that.
I wouldn't know either.
Is this your regular shift?
Yep. So, what was the fundraiser for?
Civic Theater. Normally that would have been fine, but I took my mother-in-law home. You're coming back. Yeah, I'm not down the south part of town very often.
You what?
I'm not down the south part of town very often.
Gotcha.
This is not my area. So when around about, obviously I swing too wide.
I think she's just getting them situated. They're in the car already.
Yes, she has a real medical problem.
Okay.
That's why I was going to have her over here. She shouldn't have gone tonight, but she did to support the Civic Theater. She shouldn't have gone.
I gotcha.
I was willing not to. That's why it's one of the reasons we left. Let's get this thing going. Let's see.
We're just waiting for my sergeant to get down here.
I understand. Let's get the sergeant moving. I'm serious.
He's on his way.
I don't give a shit what it is. Let's get going. I got a wife who's in serious medical problems. I can't screw around with this.
What's the problem?
Who's the quadrant leader for this area?
Quadrant leader?
Tonight it's Sergeant Wilkins.
Hafner, you mean the deputy chief?
Hafner.
Hafner?
Steve.
Yeah. He's the deputy chief for the quadrant.
Is he on duty?
No.
You're doing what you need to do. I understand. But obviously, when you get a family involved,
I gotcha.
Oh, she yelled at me because I was hurrying to get her home. It's time for an insulin shot.
I gotcha.
Who's that?
That's our sergeant. He's just turning around.
All right. Let's get him out of here. Do whatever you need to do. Actually, I'm more afraid of my wife.
Aren't we all? Aren't we all more afraid
I was
of
trying to get her
wives?
home in time for her shot. Oh God, I'm getting. Oh shit. Hi, honey. Right behind you. Who is? Honey, that's okay. We have a police car taking us. What?
Weiss.
I pulled up on it. I'm out of the shift.
Weiss is. Yep.
Okay. All right. All right. Thank you. She said my car is not. City car is not drivable.
Your car's not?
That's what she says.
Okay.
Let's go over and take a look.
Nope, hang out here for me.
Where is it?
Hey, sir.
It's up here?
Nope, I just need you to hang out here for me. There we go. Just hang out right here. I don't want you getting hit by a car.
I understand.
So if you just hang out here, he's getting caught up on what's going on, and
I have 379 King 385 to signal 43 937.
Crash. He's
385. Signal
I'll stay
43
on
at Matt
the
Anthony.
street. He's all over the
2 Broadway.
losing his balance.
2002 Broadway. Sheriff, his male Hispanic, wearing a white hat, blue jacket. Trying to start a signal
Our supervisor should probably be on the scene before anything like that goes on. He's stuck in on breath mints one after another. He asked for his license. He gave me his business card. I said, "That's your business card," and he gave me his. So well, you can keep that. And kept asking for his auto insurance. He kept looking for it. Then you realize that he's driving a city car. It's a city insurance.
Okay.
And I said, I didn't know it's got a personal plate on it, so I didn't know it was a city car.
Any breath stuff?
Just breath mints, so I can smell them one after another.
The steady unsteadiness on his feet.
Yes.
Okay.
Yeah. And
Okay.
slurs,
What I'm gonna have you do is
slurs,
I'm gonna have you stick around. I just want you to hang back.
That's fine.
I want you to
do whatever you want me to do.
We'll need a report tonight. Your overtime's approved. Everybody else and me, we're going to take care of this. Okay. So I'm gonna have one of them give him the PPD. Whoever can operate one of those things. How you doing, sir?
Well, obviously not too good.
Okay. So, you know, my officers, we got called in for a crash. Okay.
Go do what you gotta do.
I appreciate that, and we just have to walk through this.
No, I understand.
We have to walk through this.
No, I
and
understand.
just,
I was taking my wife home. We were at the Civic Theater tonight for a fundraiser.
Okay.
Somebody's wife couldn't take her home.
Okay.
So I took her home.
Okay.
Coming back, either I had obviously too much to drink or coming around that roundabout, which I'm not familiar with. I went over the line, I hit somebody's side view mirror.
Okay.
It is what it is. I understand that.
I really appreciate that, and I'm telling you right now, the way you're walking through this,
I know it.
it sucks.
I
But
know,
you know,
it sucks.
but the thing is, if we don't follow the steps, if we don't do this thing the right way, it's going to come back.
Oh no,
it always comes back.
Well,
so what we're going to do?
The mayor had a DUI or whatever you want to call it.
So what we're going to do is we're going to give you a PVD, breath, if you don't mind. We're going to give you a public breath test to see where you're at. There's one in the car over there. Okay. So we're just going to give you that.
My wife, I was hurrying home.
And she got home, right? We got her home.
No, they're in my hope so.
Okay.
Yeah, she's got. I don't know if you know that she's got cancer.
Okay, I didn't know that.
She's in severe pain.
Okay.
That's why I was hurrying home.
Okay, we'll get her home.
No, don't worry about that. That's not nothing to do with this. I was just in a hurry.
Officer, I suppose we're going to give you a...
Let's
do our thing.
Just big deep breath and blow.
Probably 4.0. No.
You'd be dead if it was 4.0.
I know it.
Sir, I do appreciate your cooperation.
No,
okay.
We have to do it.
Okay.
What is it?
You're over the legal limit.
That's about twice.
About twice.
Are we done with
Oh,
the
shit.
second floor?
Yeah.
We can get them out of here.
Yep. Let's go ahead and...
Please.
Who's B90, anybody?
Please.
Do what you have to do.
Okay, I got to take this. Sarges.
Go, turn around for me. Please. Put your hands behind your back.
Hands behind your back for just a minute here.
Yep. Behind your back. There we go.
No, you're just being detained right now for suspicion of drunk driving, sir.
Let go of your hands. Whose car is this?
Mine.
Hop in.
Let's wait and see.
He said go. Yeah, he already said yes for doing this.
You're going to take me in?
Well.
Can you have a seat for me? Have a seat for me?
You're gonna actually take me in?
We're working through it.
We're waiting to see.
Right now, you're just being detained. Can you please have a seat? Need help in, or are you good?
No, I'm looking at your name.
It's Asplund. It'll be on all the paperwork.
I'm sorry?
Asplund?
Aspen? Oh, I understand what you're doing. I just want to know.
I'll go with you. I'm not taking this. I said, I'll go with you and help. I'm not taking this.
Oh, I don't want you to take
This
it.
is a joint partnership.
This is me getting fired is what it is.
Yep, I'm right there with you. He's asked my name like 3 times.
Technically, I'm pretty sure you're supposed to get a supervisor with B90, but apparently that's not gonna.
Please get a supervisor with B90. I'm going to get fired. And so are all of you. So it's been nice working with you. It's been a good 3 years.
I might as well start looking for other departments now.
We'll go back to school.
Do we have a sergeant that's B90?
I am not.
I'm asking if we have a sergeant that's B90, because don't we need a sergeant that's B90 for this? I was under the impression we were, but I could be all wrong.
I'm going to walk through this with you.
Okay. Obviously, we're all in the same boat here.
Yes. We just need a report from you. We're going to get the wife, see if she could drive. If she
Okay.
can drive, who's working the
He
crash?
was saying she had some kind of medical condition. So
Where's she
I don't
at?
know. He's in this car.
Do we handcuff him?
Yes.
Do we handcuff him behind him?
Yes.
He told them to do it.
Okay. If he's good, that's good. Okay. I just
he's not good.
He's not good with it. He doesn't want to be handcuffed. He doesn't want to be in the car. So
And he's already threatening us.
yeah.
leave it the way it is now.
Okay.
I was going to do it a little bit differently, but we're good. We're fine.
I thought you said just go for it and then you left, so I didn't.
No. Listen, I was just going to handcuff him in the front and put his coat over in the front. But we're there, so it doesn't matter. Let me find out from Chief is talking to Coleman.
Cool.
I'm going to talk to Coleman in just a second. See how either I'm going to walk through this with you, and it's going to be my name on everything, with you running everything. If you're good with that,
I'll do whatever you need me to.
I want to walk through this thing.
At the end of the day, I got to do my job regardless of who it is.
We are, yes, that's, so you do your report the way you saw it. You did a perfect job. You know, like I told you, we don't do this the right way. Someone's going to find out. And it's going to come back to bite you one way or another. So this way you can go face it and walk through it. Say I made mistakes and people can forgive.
He's not been read anything.
Okay.
Do we want to read him?
Yes, go ahead and start reading him.
Gotcha.
Whoever's working the garage, you need to get working on that. If you got a lobster,
I can do whatever you need, Luis.
who wants to do the B90?
Nobody.
As of right now.
Nobody.
I can run it.
You can run B90?
Yeah.
B90 sometime? Okay, good.
Yeah.
I want to stick with you in there.
Okay.
If you can work the trash right now.
Yep.
And just document what he says.
I got you.
If apply consent, just start walking through this thing. If for some reason this thing starts, we can move things to the front and wrap it over. Get that concrete down so there. We can make it so that we can get through the front and we can wrap it. Get coat over the handcuff. That's it. So I'm going to let you do that. In fact, I'll go with you. All right. Is he in mine?
Yep.
This one?
Yep.
So, I'm going to do this. Come on, sir.
Put me in the handcuffs. Put the mayor in the back seat of the handcuffs. I won't forget this.
Yes, sir.
Believe me.
I just want you to know that you are recording everything.
That's fine. I just cannot believe that it put me in the handcuffs in the mayor of the city. It's one thing, to talk to me about, God damn it, these handcuffs are breaking me. wrist.
What we're gonna do, you have to go with handcuffs, okay? What we're gonna do is we're gonna move the handcuffs to the front, but we're gonna have you sit back in the car. Okay, we're gonna take your coat.
Where's the chief?
I just spoke to the chief. Okay? The chief said, I gotta do my job. And we already spoke about this. Okay? What we're gonna do is we're gonna take the handcuffs, we're gonna put them on the front, but we need your cooperation. Sir, just remember, we are recording. We are recording everything.
I understand what you're saying.
Okay?
I need a side view mirror and this.
We are, sir, we are in the middle of something that we don't want to be in.
I understand.
What I'm allowed to do is take the coat off. If you're going to take the coat off.
Sorry, Luis. My
take
bad.
the handcuff off first.
Yeah, it's fine. Give me some more to do.
What we're going to do is we're going to wrap you. We're going to take your coat. We'll take that off. Okay. We're going to take your coat. We're going to put the handcuffs back on. Go ahead, put them back. And then we'll wrap your coat over the top. I'm telling you this, please. We'll make sure the double lock so you're not
Where's my
locked up.
wife?
We're going to get her home.
She's still with me.
Is she? She's still home.
Yeah, she's still with me.
Get her home.
Go get her home, sir.
She has cancer treatment. God damn it, get her home.
Sir, we'll wrap these over the top, but you'll have to sit in the back of his car.
Where is she now?
She's in her car.
Get her home.
We will. We'll get her home.
I don't.
Sir, I'm not actually stepping on.
You all work for me,
Sir,
right?
please.
I'm serious.
Sir.
I don't care about me.
Sir.
Get my wife
We
home
will get your wife home. Listen.
right now.
Sir.
She is short of treatment. Get her home.
Sir, I'm going to ask you to step into the car. Okay? We will take care of
I will
everything.
take her home.
Sir.
Not until I make sure my wife is on the
Sir,
way home.
it's not your choice.
No,
anymore.
I will take her home.
I do.
Just have to sit back in the car for me, okay, please? You okay? Thank you, sir.
Thank you.
Did you get his wallet and ID? Because you need that for the machine.
His ID.
Good with me reading?
Just go.
Okay. All right, sir. I'm just going to read a couple things to you, okay? The first is implied consent warning,
Yeah. No, I understand.
and it just says, I have probable cause to believe that you've operated a vehicle while intoxicated.
Yes.
I must now offer you the opportunity to submit to a chemical test
Yes.
and inform you that your refusal to submit to a chemical test will result in the suspension of your driving privileges for 1 year.
Yes.
If you have at least one previous conviction for operating while intoxicated, your refusal to submit to a chemical test
Yes.
will result in the suspension of your driving privileges for 2
Yes.
years. Will you take the chemical test?
Yes.
Okay. So the second thing I'm going to read, I'm sure you already know it, but it's just a warning of your constitutional rights, okay? First, you have the right to remain silent. Anything you say can and will be used against you in court. You
Yes.
have the right to talk to a lawyer for advice before we ask you any questions,
Yes.
and to have him with you during questioning.
Yes.
If you can't afford a lawyer, one will be appointed for you for questioning if you wish.
Yes.
If you decide to answer questions without a lawyer present, you'll still have the right to stop answering at any time.
Yes.
You also have the right to stop answering at any time until you talk to a lawyer.
Yes, ma'am.
You understand each of these as I've read them to you? Okay.
All right. Let's get this done.
We have this. We're getting this car out of here. You get mom home. Make sure she gets in, or wife. Make sure she gets inside and tucked away very, very well. Ask her if she needs anything. Needs to call anybody.
They're friends of the family.
Okay. Okay. So you and I are going to follow. I'm following you. We're going to B90.
Is there a certain way we're going to take him in or anything? Do we want to have lockup staff come out and walk us back a certain
No,
way?
let's just go in the way we're going.
Okay.
Because this is the problem we have. If we don't follow protocol,
Yeah.
I don't mind doing it, but they're gonna have to check him. Have we checked him?
You didn't pat him down, did you?
Briefly.
He's got, what, like his own... Okay.
It is what it is.
All right, sir.
Okay.
You don't help out for a minute?
All right. I got DJ on the phone. Okay. Anyway, DJ, that's where we are. All right, buddy.
Yes, he's on his phone. Go ahead and get the phone off.
All right, sir.
Thank you.
Here, we got to take this, sir.
Well, that's okay. I just talked to PJ.
Okay.
You know,
We're gonna have to take everything out of your pockets.
All right, we gotta check your pockets, sir. We gotta follow protocol on everything here, okay?
I'll put them in a bag to keep them all together.
And then there's,
Are we going down to the county jail?
I believe so.
I don't think that's going to happen.
Can you turn around for a second here, sir?
Somebody said they talked to the chief already.
Yes, sir. All right, sir. Can you have a seat?
You good with me?
Mm-hmm.
That's fine. We'll go protocol.
You know how it is, sir. That's how we gotta do it.
All right, you gotta do what you gotta do.
Alrighty.
You're good. Just
Yeah, you're good. Just go ahead and have a seat there.
What do you want?
Just have a seat there, sir.
I'm sitting here.
Yeah, just put your feet in.
Can you go ahead and put your feet in? We'll get going.
Yeah.
Yes, sir.
Yep.
Who talked to the chief?
I did, sir.
I need to know who.
This Wilkins.
Officer who?
Sergeant Wilkins.
And
we're doing everything the correct way.
Steve, okay.
We're doing everything.
That's fine.
We're walking through this. We got to walk through this, sir. Okay, we're walking
Where's
through it.
my wife?
We have her, sir. We were about to
Is
take
she
her.
on her way home? God goddamn sake!
We were going to get home. She's on her way home. We had to get your car out of here first before we get her
I
home.
don't give a shit about me. I don't care about her.
Sir, just watch yourself coming in. We're shutting the door.
All right, we're good.
Is somebody coming to pick this car?
Yeah.
We're going.
You were saying I should go with me because nobody else wants to go behind me. There's a drum out, so it's good to have two.
Yeah. Alrighty. The quicker we get done, the quicker we'll get you out of here.
Thank you. Thank you. Yeah, do what you got to do.
Just like 5 minutes, maybe.
This is not exactly the way I wanted to
Make sure you don't have anything in your pockets and that's just there.
There's nothing there.
Okay, but they have to just make sure real quick.
Don't take my beautiful grandchildren from my phone.
Nah, nothing like that. I can get it when we're done. Or I can get it now.
Hey, you guys ready?
Don't take my money. Actually, my wife doesn't have any money. She spent it all at the auction.
Say, sir, if you're a married man, you don't have any to begin with.
Oh, man, we spent a ton of money tonight at the auction. But that's all right. Don't take my Sears card home. Never mind. Go ahead and take that.
Please.
Yeah, if you want to.
All right, sir. I know we read this in the car.
Oh yeah.
I'm just gonna read it to you again, okay? So it's on this camera.
Oh,
Yep.
yes.
Yep.
Put my camera up here.
There's one there and there's one there. And there's here and there and there.
I understand.
So this is just Indiana implied consent warning. So I have probable cause to believe that you've operated a vehicle while intoxicated. I must now offer you the opportunity to submit to a chemical test
Yes.
and inform you that your refusal to submit to a chemical test will result in the suspension of your driving privileges for 1 year.
Yes.
If you have at least one previous conviction for operating while intoxicated, your refusal to submit to a chemical test will result in the suspension of your driving privileges for 2 years. Having read that, will you take the chemical test? Okay, thank you.
Never had one in my life. This is going to be a new experience.
We will walk you right through it, sir.
I know you won't.
It's not too big of a thing.
Can I get my picture taken?
Maybe.
Maybe, I don't know.
I don't know.
So I'm also going to read you your constitutional rights again while we're waiting for this.
Can I read it to you?
Yeah, if you want to.
I still have. No, I'm sorry.
All right. So you have the right to remain silent. Anything you say can and will be used against you in court. You have the right to talk to a lawyer for advice before we ask you any questions and to have him with you during questioning. If you cannot afford a lawyer, one will be appointed for you before any questioning if you wish. If you decide to answer questions without a lawyer present, you'll still have the right to stop answering at any time. You also have the right to stop answering at any time until you talk to a lawyer. You understand each of these rights as I've read them to you? Okay. With these rights in mind, do you wish to talk to me? Okay.
I talk to my wife instead of you. She'd be worse than you.
You don't want to talk to her right now?
Oh, no. And I spent a couple nights. Oh, I'm a dead man walking.
Did you have the OL, his license?
Yep, right here.
Mind if I grab that for a second? Thank you.
So basically, this is going to be similar to what we did down there. Where's the mouthpiece we'll put in here, and we'll just have you blow into it like blowing up a balloon. Until we tell you to stop the machine.
Yeah. Oh, Lordy Moses. I kind of wish we hadn't just left the event. That would have been better. But those new licenses are great, aren't they? You get your face all movie style.
Yeah.
I think mine looks better in black and white.
Oh.
All right, sir.
All right.
You blow into this like you're blowing up a balloon until it stops, okay?
You ready?
Yes, sir. Whenever you are. Oh, you gotta stop. Yeah, just more of a long, continuous breath, not so much in the front end there, sir.
You told me to blow up a balloon.
Yeah, well, blow up a balloon better than I do then.
I'm okay, yeah.
They're kind of.
I've never done this before. This is cool.
They're kind of finicky sometimes.
That's all key. That's all right.
You gotta have like a nice long even breath.
Breath.
I thought you wanted me to.
No, not a.
I didn't know, man. I didn't know.
You probably got better lungs than me, sir.
I don't know about that. I'm an old man.
And it's gonna make you do it one more time, generally, isn't that right?
I don't know.
It'll print the result.
It won't tell us until the end.
Yeah.
But so you'll
provide
do
2 samples.
It's 0.07.
No, it doesn't. Is that what you're saying?
It'll provide 2 samples.
It might be.
And the lowest of the 2 samples is the official.
That's fair.
So it makes us wait 2 minutes and then we'll do it over.
No, that's fine.
And then we'll be done.
All right. Oh, what a pain in the ass. Are you recording this?
Yes.
Oh, okay, good. Oh, what a pain in the rear. You can delete it.
I think that they've heard asked before on the
You think so? I'll be from one of the 3 of you.
I would say that's counted on the small of the below spectrum of bad words. So we're
No, that's all right.
That's the worst thing about it. Cam Pierce tonight has tried the best night it's ever had.
I've heard that just talking to 2 people on the phones.
When do you get home to my wife?
And we did make sure she got home. So.
Thank you very much. And she's got some.
Well, our prayers will be with her.
Thank you. Are you, are we still on record?
Yes, sir.
I'm gonna ask you about the new jail situation. Turn those.
Well, that's the problem, sir. We can't.
We can't.
That's the policy we have.
Yeah, okay.
Yeah, we get in trouble if we turn them off.
Yeah, I know. Understand. Colin, Timberstons are in the Hillwood line, aren't they?
Yeah, they 8 of the places are denied or something like that, or.
Well, I know where they want to go, and all of us know where they probably want to go. That's where the shirt's.
Might be different than where they will go, though.
Yeah. Although they keep turning down these 6 or 7 places, they can at least come back and say, "Hey, we've done our research, we've done all this, and there's no other place." But they aren't there yet.
One more breath for you.
We're gonna do this.
Three of
one
us,
more
I don't
time.
know if they have. Anyway, okay.
Steady.
Just like before.
Yep, same as last time. Keep going, a little stronger. Keep going, keep going, keep going, keep going, keep going, keep going, keep going. There you are, sir.
Okay.
All right,
Okay.
we are all done.
All right. What are we looking at?
We'll get it for now.
Don't say higher than it was before.
It takes a minute. It'll read everything and
It'll start
print it out for us.
All right. What's that?
Doing that.
Yeah, it's running through its cycle.
Okay, when I start doing Phil's Bragg's done.
Give you the English one.
How good are you with these?
I can do it if you want.
Okay, yeah, if you want to.
If you want to document, I will do.
Blank check. What's that mean?
That's how
It's running through its systematic checks and balances to make sure it's properly calibrated, sir.
So while that's running through that,
Oh, for God's sake, what call me sir? That was my dad.
while we're waiting for the results,
I served in the military.
I know, as did I, so I totally understand.
I'm gonna do a couple more tests, okay?
Sure.
You mind coming back and standing against this line for me?
God, yes.
All right. I'm just gonna check your eyes first. You wear glasses or anything?
No.
Anything wrong with your eyes? No? Okay. You see the tip of my pen right here?
Yeah.
Okay. I want you to watch the tip of my pen with your eyes and your eyes only. Don't move your head, okay?
Okay.
All right.
Pretty good with that.
All right. Now we're gonna go up and down. Same thing.
Okay.
Don't move your head. Just
Okay.
follow it with your eyes, okay? Yep. Watch that tip of my pen.
Mm-hmm. I like your chest. I see those.
All right.
All righty.
So if you just want to hang out there 1 second.
I see those.
Your tattoo?
Ah, I found it.
Yeah.
Okay. What is it? I need to walk.
We're gonna do a couple more. If you just want to come. Yep.
Oh, I'm sorry.
You're good. No, just stand. Come off the wall a little bit. Oh, careful! Don't fall over.
No, I just want to make sure I'm on the line.
Yep, you're good. Just take a step forward for me. This isn't part of the test. Just come step forward so
Okay.
you're not against the wall. That's perfect. Yep. Right
Okay.
there. Right there's good. Just stay there.
I didn't know
All
if
right.
I was supposed to do something.
No, you're good. All right. So this is called the one leg stand. Can you take your hands out of your pockets for me? Thank you. So all I want you to do, you're good.
Which hand?
Both hands out of your pockets. Just put them down at your side.
Okay.
Perfect. I want you to stand with your feet together. Perfect. Just like that. All right. So please stand with your feet together and your arms down at the sides. Just like that. And let me read the instructions. Don't start until I tell you to, okay? All right. When I tell you to start, I want you to raise either leg with your foot approximately 6 inches off the ground, keeping your foot parallel to the ground. So it's going to look like this.
This. Yeah.
Oh, don't start yet.
Oh, okay.
Yep. So
I
stand.
thought you didn't want me to
You're
go.
good. Nope. Stand just like this.
Okay.
Perfect. So while holding that position, after you start, count out loud 1001, 1002, 1003 until I tell you to stop, okay?
Slow guy.
All right, so keep your arms down at your sides at all times. We don't start yet.
Okay. Okay.
So keep your arms down at your sides at all times, okay? Do you understand all those instructions? All right. Go ahead and start.
1002, 1003. How many?
Yep, just keep counting until I tell you to stop.
Sorry.
You're okay.
1001, 1002,
Arms down.
1003. Oh, I'm sorry.
You're good.
1004, 1005, 1006, 1007.
You're good. Just keep going.
I can't do that till even when I was totally so.
All right.
8, 9.
You're good. You're good.
Jesus, Mary.
Do we have the walk and turn or no? Yeah, perfect. All right, we're just going to do one more, okay? So you can go back to your place at the start of the wall. Perfect. Yep, right there. Just take one step off the wall. Perfect. All right. So this is called the walk and turn test. So I want you to take your left foot and put it on the line. Yep. And then you're going to place your right foot in front of your left foot. So it's going to look like this. One in front of the other, heel to toe. Yep. So hang on, don't start yet.
Oh, I'm sorry.
No, you're okay. So both arms down at your sides, feet on the line, left foot in front of left foot, right foot, and just stand like that, okay, until I tell you to start.
Okay.
Yep, just come off the wall.
Left first?
Don't start yet.
Okay.
So I just need you to stand like that until I read all the instructions, okay?
Okay.
Come off the wall for me. Yep, take a step off the wall. There we go. All right, so when I tell you to start, you're gonna take 9 heel to toe steps down this line. All right, and it's gonna look like this.
Yeah.
1, 2, 3, and so on until you reach 9. Don't start yet.
Oh, I'm sorry.
Yep, so
I was fired up.
that's okay. When you reach 9, you're gonna take a series of small steps like this and turn around on the line. And then you're going to take 9 heel to toe steps back.
How am I supposed to remember all of that?
I'll walk you through it if you need. So it's just 9 heel to toe steps down, and then you're going to turn around slowly and 9 heel to toe steps back. All right? And I need you to just count out loud while you do it. Do you understand all that? Okay. Okay, you can begin.
1, 2, 3.
Yep, watch your feet.
4, 5, 6, 7, 8, 9. Answer the phone. 10. 1, 2.
Yep, heel to toe steps.
Oh, I'm sorry.
You're good.
5, 6, 7. Well, I guess I was one short.
That's okay. We are all done with those, all right?
All right. Can I spend the night here? My wife.
I don't think you want to do that, sir.
And she will kill me. You sorry?
That's free.
No, I'm not.
We're good on the first one. That's all we need.
Yeah.
Oh, no. Sergeant, it's not. Because I spend the night in Hamilton, Michigan City. How we doing?
All right.
How they do?
We are all done, sir. Your official score was .152.
Yeah, that's
Just under twice the legal.
Did you sign them all?
Yeah.
And give me a minute when you're done.
Sometimes you just don't know how much you drink sometimes.
No, you know, that's a lie. Yeah,
It's not good. Your wife's home and stuff like that, so
no, I understand.
you're like, you know,
So I'm spending the night here.
you're not going to price it.
I appreciate that.
It's an OR charge, sir.
I'm sorry.
I'll be here for a little bit. Sorry.
Not right.
I just want to make sure my wife.
It's 2 in the drawer, right?
Make sure she needed everything, got her home, make sure that if she needed anybody that we would contact them and stuff like that.
Don't let me pinch your fingers. I'm going to open this drawer.
I'm fine. Yeah, but that's not okay. I'm
It's 2 in the drawer, right?
47 years of married.
I think.
And
Or is it 1 in the drawer?
Of those, I think it's just one.
Okay, then you get 2.
Yeah.
I never remember.
no pictures, I hope.
You look very photogenic in your suit.
I don't have my suit. You guys took it.
He's got your jacket.
No, I don't want it. No.
You don't want it.
We don't get any pictures taken.
You still look photogenic in your shirt.
Why we don't get pictures taken?
I don't even know.
Do that. Let's not do that.
Yeah, this is the county's deal now, sir.
No, well, I'll take care of the comments. No pictures taken tonight.
Well,
We
that's
don't
not, that's not up to us, sir.
I'm sorry.
That's not up to us.
Yes, it is.
No,
Well,
sir.
it will be. Not up to you, but up to me.
Sir, I'm sorry.
No, I'm sorry, but this is a situation like
The thing is we have to follow.
I can't have my wife embarrassed like
Look, sir,
We have to follow the protocol.
I know you do. I know.
We have to follow the
I
things.
know. Where are we going next? I know.
We're just waiting here for just a second. Are we ready?
Yeah, we're ready.
Okay, let's go.
Where are we going next?
So we're gonna follow. You're gonna follow this.
We're gonna go back out. Yeah, this is the county show now, sir.
Well, that's not this. So that's not that commits. Yeah, it is. But
Are we? Yeah, let me go. I'll give him a heads up. I'll come back. I'll come back. How do you guys want to do this?
is he staying?
Well, probably not staying, but he's over, so he's
Let's see.
152.
When do you guys arrest him?
Like 20 minutes, half an hour ago.
So he's got
He was 152 just now.
6 hours.
Okay, I don't.
You ready?
Here's the jacket, Mike. What I'm gonna have to do when we get over here to the scanner, I need you, you know,
Mobile.
I need you to take off the shoes, so I can scan you, promote me.
You'll take off your shoes and you'll hold them and they'll scan you and then you can put them back on.
Yep. Mr. Healy, look straight ahead, please, sir.
Look straight
ahead. Ahead, the red target.
Got it?
Yep.
Or not.
You have a middle initial, sir? Sir? A middle initial?
C.
It's an A. It's Thomas with an A. Donnie. It doesn't like you.
Okay, look at that red target right there. All right, you just take your shoes off.
I don't know what your protocols are for this. How the sheriff wants to handle this, because it's out of our hands. So I know that he's 1-5. Therefore, he's supposed to stay here for 6 hours and 40 minutes.
Correct. Gonna house him alone or get in contact with
Okay, so that's set.
supervisors and
That's set in stone. The 6 hour and 40 minutes.
that's legally we have to.
Okay, that's all I needed to hear. Can he have his coat or not?
Yeah, he can have his coat, we just gotta run it through the camera.
And then we have to also take his belt off. You're making this more difficult.
Not trying to, man, not trying to.
Yeah. Okay, so what we're gonna have to do
State law requires you to be here for 6 hours and 40 minutes. State law. No way around it. You're the level that you are. They have a cell to yourself, away from everybody else, and we've been very specific to just get you in here as easily. Huh? I cannot talk to Steve. This is state law. This is the county state law. This is state law.
State law or county law?
This is state law that you have to be here for 6 hours and 40 minutes. I just talked to their command, and you have to be here for that long.
Who in your command?
I don't know. I don't know who it was, but it's their jailer. They know their job. I can give you your coat back so you can stay a little bit warmer. We are going to have to remove your belt at some point here when they get done with that person out here. We're getting them out of the way. We're going to have to remove your belt. I can give your coat back though.
You're obviously taking all this.
Yes, sir. So we're going to remove your belt, but I can give your coat back, they said. We will put you in a cell by yourself.
What time is it?
It is,
You took my watch.
it's right after midnight, sir.
I'm sorry?
It's after midnight, 2 after midnight. These are the things we have to walk through.
I understand.
And understand. No, sir. No, sir.
I can't talk to the chief.
No, sir.
I can't talk to the sheriff.
No, sir. Not unless they are going to allow you to do it. You can speak to their lockup. Their lockup staff. They've already talked to their command already.
And the sheriff and the chief both said I cannot talk to them.
Yes, sir. We were just walking through it. If the sheriff or the chief wants to talk to you, they will have to contact you
And
themselves.
neither one of them have said no.
I have not asked if they can contact you or not, but we do not walk through this. He told me to follow protocols.
Oh, no, I understand what your
We're
job
following
is.
protocols.
I understand what your job is.
I
would like to talk to either the chief.
I will, this is what I will
Or the
do.
sheriff.
I will talk to my command and let them know what we have. It will be up to them if they probably are going to I would say wall this off because they don't want to look like they have a hand in it, because if they have a hand in it, guess what? You get bad perception, right? It's the way it is.
Tell me about it.
But listen, the thing is this, I'm not telling you how.
Sergeant, I understand.
I'm not trying to tell you how this.
I just want to make sure that the sheriff
I will
and
make
the
sure.
chief
I will make sure.
both know that
You're here. You're here.
Yeah.
I will. I will make.
Obviously, I admit that.
Sir.
Thinking too much.
Sorry. Listen, I will make sure. I will call the chief.
Let's do it. Do what you have to do.
I want to make sure there's nobody out here in the hall. We are good to go. Let's go here, sir. Hold on.
I need to grab my data. I'm sorry.
We covered the window, sir. But we were going to have to ask you to sit.
sorry?
We're going to have to ask you to sit in here until they release you, okay? Like according to state law, what we're required to do, you have to sit a minimum of what your BAC comes back to, okay?
Which is how much?
It's 1.5. It's 6 hours and 40 minutes. And there's nothing we can do about that.
Starting since when?
You blew. Since you blew.
Since when? What time?
11:47.
11:47.
I gotta be here till 6 o'clock in the morning.
A little bit less than that, sir. Somewhere there.
Does my wife know?
Your wife knows you came with us, yes.
Does she know how much time I gotta be here?
I will get.
I mean, goddamn, she's got medical problems. You know that.
I will. When I get her phone number, I will call her and let her know how long you're going to be here.
Who's a quadrant leader in this area?
I'm the quadrant sergeant.
Is it PJ or?
No, it's Hafner. Steve Hafner.
Get hold of Steve. Have to get hold of me.
Okay. What, do you want me?
Have Steve get hold of me now.
Sir, do you want me to?
That's an order.
Do you want me to call your wife and let her know how long you're going to be?
Call Steve and have him get here now. That's an order.
I will, this is what I'm going to do.
That's an order.
I'm going to call the
You
chief.
understand what I'm saying?
I will call the chief of police. I know what the disposition is right now. I will let him know.
Either Steve gets here or Steve gets here.
Okay.
Now.
Sir, you're going to have to
I don't
step
care what time it is.
Sir, you're going to have to step aside.
I will.
Thank you very much.
I'm
I'm sorry for these circumstances that we had to meet.
Here now.
Yes, sir. I will let the chief know.
Thank you.
Thank you. Yes, sir. Can you hear me? Sir. Thank you guys for all your help. That was phenomenal. I mean, seriously. I mean, y'all made that smooth. As smooth as it can be, so. I got a call. I got a phone call, so I got to get out of here. Can I use your phone? Yo, do I have to dial 9 to get out? Are these recorded?
They are.
Okay. I just can't get out of here.
Your statewide news network covers Fort Wayne, where Mayor Tom Henry was arrested for drunk driving. According to his office, Henry was involved in a car crash. When police got to the scene, officers found that he was impaired. Well, he was then booked in the Allen County Jail and later released. Fort Wayne police did not provide any additional details about the arrest.
I made the decision to get behind the wheel of a car after drinking at a local function. And I accept responsibility for those actions.
Good evening, I'm Drew Fry. Thank you for joining us. You just heard from Fort Wayne Mayor Tom Henry hours after he was released from the Allen County Jail this morning. Henry is charged with operating while intoxicated. Here's what we know right now. Fort Wayne police arrested Henry just after 11:45 last night after he crashed his car. He was booked into the Allen County Jail and released this morning. The four-term mayor called a press conference this afternoon where he read a brief statement in which he apologized to his family, his staff, and the citizens of Fort Wayne.
I knew better. I knew better than to be in a position where there was going to be impaired driving. So today I'm again here to apologize for my actions.
Henry left the room without answering questions from reporters about his political future. Both city police and the administration have declined to release any details about the crash, including where and when it happened, citing the active investigation. Fort Wayne Mayor Tom Henry sentenced this afternoon for OWI 4 days earlier than initially scheduled. A city representative confirmed that Henry's counsel and the court system agreed to move the hearing to today. Henry will pay more than $3,000 in restitution and roughly $800 more in fines and court costs. His plea agreement is also part of the sentencing, which includes the suspending a year-long jail sentence.
The city of Fort Wayne refusing to release police video from Mayor Tom Henry's OWI arrest. New tonight, a media law attorney tells us he's not sure the city has the standing to withhold the video, and Indiana's public access counselor says his office is investigating after receiving a number of complaints. Fox 55's Brianna Bias is live in studio to tell us more about the city's reasons for denying our request. Brianna.
Yeah, Kelsey, the city of Fort Wayne says they don't have to release the dashboard and body cam video because they consider it an investigatory record. But I spoke to attorney Steve Key today, and he says since Mayor Henry pleaded guilty, that's the end of the investigation. So he can't think of a reason for them to not release it.
A major development in our efforts to obtain the body camera and dash cam video of Mayor Tom Henry's drunk driving arrest. Good evening, I'm Kelsey Mannix. Thank you for joining us tonight. First reported by Fox 55 this afternoon, Indiana's public access counselor says the city of Fort Wayne violated the Access to Public Records Act by not releasing it. We, along with other local news outlets, have been working to get the video since Henry's arrest in October. And City Council President Jason Arp has also been vocal about the frustrations with this issue. Fox 55's Brianna Bias spoke to him tonight. She's live now at the Allen County Courthouse with that response and more details about what that public access counselor said. Brianna.
Good evening. Kelsey, yes, Mayor Henry first pleaded guilty to drunk driving back on October 10th, and Fox 55 requested the body camera footage from his arrest the very next day. But the city attorney told us we couldn't have it because it was investigatory record. But in the public access counselor's opinion that was published today, Lucas Britt says Henry pleaded guilty, so that means the footage is no longer investigatory record. So they're violating public access laws by not releasing it. Fox 55 sent in a second request for the footage on November 4th after Henry's sentencing. They told us they received the request, but we have not heard anything from the city attorney since. And we are not the only ones who are asking for the video to be released. City Councilman Jason Arp is also trying to get it released and says this recommendation from Britt could help.
There's been questions about some of the circumstances that happened on the scene that we have no clarity as to whether or not those allegations are true or not. This will give us the opportunity to take a look to see if they were or not.
Fort Wayne City Council members responded tonight to seeing the police video to Mayor Tom Henry's arrest.
Put the mayor in the back seat of the handcuff.
Sir, I'm gonna have you step out.
Councilman Russ Yale was the first to bring it up, saying he was disappointed by the mayor's behavior toward the officers. It's been a good 3 years.
I might as well start looking for other departments now.
I support an independent council to review the footage and make a nonpartisan recommendation whether council should formally admonish the mayor.
Council President Jason Arp did not comment on the footage during tonight's meeting, but he did send Fox 55 a statement condemning the mayor's behavior as inappropriate. His main concern, the threats Henry made toward the officers. He says, quote, intimidation of city employees is something that we must take seriously, especially those who are tasked with enforcing the laws. Arp has not yet seen the entirety of the footage, but when he does, he says council will be able to determine how direct the threats really were.
Police just released body cam video of the mayor's arrest back in October for drunk driving.
Police say this video shows the mayor with slurred speech and unable to show officers his ID when they ask for it, and him ordering officers to take his wife and his mother-in-law home with lights and sirens. At one point, even threatening to get the police chief involved.
This release came 10 days after the state found the city violated Indiana law by refusing to disclose the video to the public.